Court officer. Court officer. Court officer. Court officer.
Sir, ಹೇಳ್ರಿ.
Madam, audio video ಎರಡು correct ಐತಲ್ರಿ? ನಾನು
sir.
ಒಬ್ಬನೇ ಲಾಗಿನ್ ತೋರ್ಸಾಕತ್ತೈತಿ.
Clear ಇದೆ sir.
Okay, madam. Thanks.
Big memos, my lords. Fresh. On 23rd, my lords, MFA. 23rd. 23rd, huh?
One matter of consideration of interim prayer this week, not any date. Good day. One matter for a family court, my lord. I'm seeking for a nullity of marriage, my lord. Still 2019, my lord, the matter will not listed before you.
Contempt, my lord. Contempt, my lord. Good day. Find up.
Page by adjournment. Page number 6, serial number 18 to 21. Page number 7, serial number 22 to 24. Page number
Serial number 24, my lord. Only may I have short adjournment, my lord. Senior has some personal inconvenience, my lord.
Compassionate appointment.
Right.
Nade.
Like 4 to 5 days, my lord. He's out of station. His mother-in-law is expired, man. Next week, any day.
Monday.
Grateful.
You list on Monday. Now you just look into that point. One, suppose there is no scheme at all as on the date of death. If there is no scheme for compassionate appointment, then suppose subsequently if the rule comes, you may not be in a position to take benefit of it because there was no scheme at all. One. And two, if the boy was 14 years, then the delay more than 20 years, that also will go against you. Those 2 points you examine.
And we have filed the application as per the prescribed.
No doubt. But under the rule, if it says within 1 year you must attain majority,
Correct.
then there'll be an issue because he was 14 years.
Correct.
Isn't it?
Yes, ma'am. 14 years.
So that one, that judgment of the Supreme Court appears to indicate not after 20 years and all, it will become difficult. So if you say 87, more than 20 years, isn't it? That one point. Second, if there's no scheme as on that date, then there is an issue. You'll have to overcome that point.
As the judgment, my lord, Lakshmi, I'll demonstrate in the next
Yes,
occasion.
yes.
page number 8, serial number 25 to 29.
Serial number 28, my lords.
Ah,
Kindly 2 days accommodation, lords.
but request relist. But they didn't enhancement.
The file itself is misplaced, my lords. For that, I'm seeking only 2 days adjournment.
How much?
2 days, my lords.
Put it immediate short. If
Okay.
possibility of settlement, it can go to Lok Adalat. You
Yes.
decide because you have to say. Examine it. Yes.
Page number 9, serial number 30 to 33. Page number 10, serial number 34.
Court video is muted. Sorry.
We can hear you.
Page number 10, serial number 34. Page number 11, serial number 35 to 37. Page number 12, serial number 38 to 42. Page number 13, 43 to 45.
Yes.
Non-compliance of office objection. Number 1, RS Kadaganchi.
Lords, may I submit with the due permission? Lords, this is a matter wherein tomorrow the no confidence motion is being scheduled. Against the notice, I filed a writ petition on the ground that previously before this, there was a meeting, notice was issued, which was being stayed by Honorable Single Judge Bench by order dated 28/11/24.
Who's putting act?
Yes.
That what previous notice?
Is stayed by order dated 28/11/2024. My lords would find at page number 45, 46, 47, the order copy.
So the previous one is still pending consideration.
Yes, ma'am. The writ petition is pending. And the said order was again extended on 12/12/24. My lords would find at page number 49. the internet copy. And the case was scheduled on 9/1. It was posted on 9/1/25. So till 9/1/25, the matter is stayed, and on 9/1 also the interim order was extended. Now, the second notice was issued on 30/12/24, would find at page number 41.
The first notice was issued on what date? First one, which is the subject matter of the writ proceeding.
Yes, my lord.
Ah.
That notice was issued on 7/11/24.
So now when was the notice issued?
Now the second notice on 30/12/24.
30,
30th December 24.
24.
Yes.
Ah. So that is more than 1 year, isn't it? If
No,
you
my
take-
lord.
No, your argument is that under 49, there cannot be a second no conflict. That is your argument, is it?
No, my lord.
What is your argument?
Yes. If the Karnataka Gram Samaj Panchayat motion of no confidence against
Ah.
Adhyaksha and Upadhyaksha,
Proviso.
yes, proviso
Ah.
wherein provided where the holding of such meeting is stayed by an order of the court, the assistant commissioner shall adjourn the said meeting and shall hold the adjourned meeting on the date not later than 30 days from the date on which he receives the intimation regarding vacation of the stay.
Correct.
After giving to the members a notice of not less than clear 15 days of such adjourned meeting.
Correct. So this is insofar as the first
First
notice.
meeting,
That is now 7/11/24 is still pending.
yes,
In the event the stay order is vacated,
vacated,
then under this procedure, they have to do it.
yes,
Now that matter is pending in the court still,
yes,
isn't it?
yes,
Now this second time they've done it afresh.
yes,
Now where is the bar for the second one?
yes. The bar, of course, is not to the members. I admit that.
No, what I'm saying, the second time,
The bar is not for the members, but the assistant commissioner, unless and until has the provision of this proviso, till the first adjourned meeting comes to the conclusion or finality, she is the assistant commissioner can't go for the second meeting of no confidence motion unless the first one is attended, because it is adjourned by the order of the court. And the proviso says that the assistant commissioner has to continue that meeting after the stay is vacated.
you appear for?
I appeared for respondent in writ petition, my lord. I will undertake to file the wakalat for private respondent, members.
Correct. Now there's,
Yes, my lord. There was a order of division bench, coordinate bench, in which the lordship was also judge on that bench. It clearly said that there is no bar to move a second no confidence. As soon as the assistant commissioner receives a motion of no confidence, he is bound to issue a notice, my lord. There
correct.
is no bar to.
Correct. No, they are only saying the first one is alive. We don't want to give any legal advice, but you apply your mind and you take your stand. Now, simplest method, he is going to grumble, but simplest method is you give up your first,
Yes, my lord. Please.
that you give it in writing.
First petition will become in
Suppose,
Yes.
first one, they give it up, then the bar would not approve.
Please, please.
That is still pending, my lord.
Correct. No, so
Yes.
it's up to you. I'll have it tomorrow. What you have to do, you do.
Please, please.
My lord,
Pending.
meeting is scheduled tomorrow.
Huh?
Meeting is scheduled tomorrow.
So what you're going to do, you see, now.
My lord,
Either you move the single judge, whatever it is, and report back. I'll only pass over. It's up to you.
with-
Because they have raised a point. There is a point.
There is a point. And there
How
is
you
a-
are going to get over it is your headache
Please.
or strategy. I'll pass over, you see what is to be.
with due permission, my
Yes.
lords. Yesterday, on Saturday, I filed it. By the time the office objection was raised regarding interim prayer, the counter was closed at 12 o'clock.
Ah.
May I submit IA number 1 for the interim stay
Put it.
before, please?
Is taken on record. I'll pass over, you see what is to be done.
Please.
Now you have to get over that. There is some point that he has raised.
Yes,
It requires consideration.
In the
How-
order of single judge, it is clearly observed that the first petition will become infructuous because of the second motion. Master.
So correct.
Yes.
Now that order he has challenged.
Yes, Master.
Now if you have to get over that, you have to bring to a close the first proceeding.
We will file a memo stating that we do, no longer pursues the first motion of no confidence.
That you have to file in the writ proceeding.
Please.
And
There
see-
is a,
Since the London Council has submitted that on 9/11, it has stay was extended, but it was not extended.
No, that's a different matter.
Different.
Now, if that has to be closed, you take whatever steps. I'll pass over. that.
Please.
You want to move the single judge, it's up to you. You see.
Please.
Pass over.
Please.
We'll take it after lunch.
Please.
after lunch.
After lunch.
Number 2.
I may kindly be excused, sir. The serial number 30,
Hmm.
last time I paid for the 2 weeks time, 27th it was fixed.
Hmm.
Ultimately, today it has come. So Pradeep Saukar is coming on 27th. I have already communicated.
May I make one submission?
It
At
may
his
be fixed.
instance only date has been fixed today minutes.
Office objection, what it has mentioned, but already he has explained on that day. However, I will be complying that office objections. 27th, it may be kindly.
Not on submission.
Let us see, that question will have implication on other matters.
Intra-court appeal is not maintainable.
Correct.
No, but
That's why we are
But
saying.
he is coming and he will be arguing and all other matters will.
Let us-
At his instance only date has been fixed today.
Okay, let us. It will have implication on other matters.
Yeah.
30th,
27th.
27. Seal number 30 and 27.
Obvious.
If there are other matters also, you get it
Yeah.
posted on the same day.
Please.
The memo.
Please, man.
So we'll hear everything.
Please,
We can't do it in a hurry, but
Please.
we'll hear it.
obvious.
Much of
Other matters on that point, wherein you are a party, you can move it on this.
Obvious.
Number 2, government advocate.
2 weeks time. At request. On behalf of the appellant. List after 2 weeks.
Number 3, Shivanand Patil.
We list the matter. Date
28.
Hmm.
Number 4, Preeti Patil.
Lords, here in this matter, on 6/4/22, respondents were directed to furnish the, secure the report relating to FIR, my lords. On 6/4/22, respondents were directed to secure the report relating FIR got marked as Exhibit P1 and criminal prosecution and report relating to Exhibit P6 IMV report. These two they were supposed to furnish, my lords, but till today it is not furnished.
For lordship, any short date may be given, we will furnish.
ಹಳೇದು madam, 2 years ಆಯ್ತಲ್ಲ. So we'll fix a date. On that date, whatever you have to do, I have to do.
Please.
So when do you want it?
One day.
Monday?
27.
27 or 20.
This on 27.
Number 5, Ravi B. Patil.
Furnishing Manod, correct address in the office Manod today, kindly reissue notice. Manod.
Counsel for the petition
Also amended cost will also will be filed in the office.
submits that needful will be complete in the course of the day. If needful is attended to, notice to be issued.
Please.
Yes.
Number 6, Sangana Basava B. Patil.
Appearing for the appellant in the first matter, my lords, in the current matter.
I represent the
Yes.
respondents advocate. We have filed our synopsis on 17th.
I have only filed my synopsis, my lords.
Well, synopsis forensics.
We'll pass over and we'll take it by around 12:30. We'll run
Much
through
obliged.
we'll run
12
through the.
May I request at 2:30, my lords?
We have some dictation at 2:30.
No, I have matter before the first court in Bangalore, serial number 17, my lords. That's the reason why.
We'll see what it is. You can start now. We'll see.
Yes, my
Yeah,
lords.
this
I'll
synopsis.
just take 5 minutes, my lords.
Ah.
It's a matter, my lords, where the appellant was married to the respondent in the year 2006. Until 2013, there was no problem. They have a daughter also. And the daughter is still a minor. Now she is studying PUC in Bangalore. First PU.
Just 1 minute. Just 1 minute. NIM synopsis. No?
It is filed on 17 January, my lord. I think I informed the court officer to, it's not put up, my lord.
Huh. Yes.
Yes, my lords. In the year 2006, the marriage of the appellant and the respondent took place in Dharwad. Thereafter, 2013, they had no issues at all. They were living together at Bangalore because the appellant respondent is employed or is having his own software business in Bangalore. Thereafter, in 2013, in the month of November 2013, the respondent went to USA. At that point of time, the parents of the respondent, that is the parents-in-law of the appellant, came to Bangalore, and then there was a rift between them, and which resulted in there are several this thing, and she was physically abused and all that. And after that, also till the respondent came returned from USA, the appellant was bearing with it. When the respondent came back from USA, he narrated everything. He said that he supports his parents only. And thereafter, she was thrown out of the house. And the daughter was remaining with the respondent. And thereafter, the respondent joined the daughter in the residential school matters, not even with him, at Dharwad, somewhere near Dharwad. The appellant started living with her parents in Bijapur. Subsequently, she filed a GNWC case because she was denied even the visiting rights also. GNWC case was dismissed on the only ground that she has no economic independence to support the daughter, and she is relying upon the alimony paid by the monthly alimony paid by the respondent. That's not a ground, my lords. Ultimately, there are several judgments of the Honorable High Court wherein it says that welfare of the child is a must. And if the respondent had taken the child with him, it's a different thing. He has joined her in a residential school. That means the love and affection of both the parents, the child is missing. Thereafter, in the month of summer vacation of 2024, the child came to Bangalore. And then the child never wanted to leave her mother and go back to the father. Then she joined at Christ University in Bangalore for the first PU. And during this time, the respondent says that he has wanted to admit her at Bangalore. And he has paid the fee and all that. But now she is studying at Christ University, and the fees has been paid, everything. And both the mother and the daughter are living in Bangalore only. So that is the reason why the GNWC, the finding given that she has no economic independence and that's why cannot support the child, is not sustainable in law matters. There are several judgments on this point that the issue about the welfare of the child is a must and not any other consideration.
No, the child is now in the hostel or where?
No, with the mother. Mother is living in Bangalore.
When did she come, leave the hostel earlier and come to the mother?
No, April 2024, summer vacation.
Summer vacation. What is the age? What is her age?
She has completed 16 years, my lords.
We want to have the benefit of her interacting with the ward.
Yes, my lords.
So we will interact with the ward once.
Yes, my lords. That's perfect, my lords.
Fix a date.
Fix a date, my lords.
We will interact. And then
The records disclosed on 29th of May. The child.
Mic on ಆಗಿದೆ.
Mic use.
On
May I
20
request for 20th January, my lords? It's a working day for the Honorable High Court.
Just 1 minute, just one. Yes.
But on 29th May, the child, mother and the father were not before this honorable court.
Where before this came.
And not before that, not on 2nd of February, 2024, this honorable court permitted the father to admit the child in an institution in Mangaluru. So thereafter, he made the admissions in March, April. Then 29/5, during the summer holidays, the child was sent to the mother. Then the mother, refused to send her back. Instead, she said, 29/5 is the date fixed before the High Court. I'll bring the daughter to the High Court. And not this honorable court, not the record disclosed. I'm instructed to say, the honorable judges interacted with the mother and the child in the chambers. I think Honorable Justice Rai was also one of the honorable judges, along with Justice Kennedy. There, the mother was adamant. She said that I will not send the child. I will take her to Bangalore and admit her in a different institute. And then, not to that effect, thereafter they filed an application before this honorable court for the expenses to be paid by the father for her education in Bangalore. To that note, I have filed my objections also to show 2nd February, this honorable court permitted him to admit to in the Mangalore institution. Those formalities were completed. In April, she files a petition for enhancement of her maintenance from 20,000 to 2 lakhs under 127 CRPC before a court in Bijapur. We file objections. Now suddenly in May, she changes her stand to take the child to Bangalore. She was aware on 2nd of February also the mother was present before this honorable court when that order came to be passed. The order sheet discloses her presence. So let me kindly see the order dated 2/2/24.
Just a minute.
No, are only the best interests of the child.
Yeah.
Now she's 16 years, isn't it?
Yes.
So she's.
I think she has just become 17. January she has.
So
But
she-
we
she's
are
in
on
a-
the point. We are on the point why the mother is changing the mind of fouling the mind of this daughter. When her education had taken off in correct manner, she was given the visitation rights, and the father was complying with all that. But after this honorable court, Lords permitted in her presence to admit the child in Mangaluru. Then, Lords, in April, she files enhancement application before Bijapur court, and in May she withholds the child with her. On the last occasion, not on the 18th December, when this was considered by this honorable court, the honorable court admonished she was also present before this honorable court, admonished the mother saying that, see, you have violated the court order. Now, therefore, we are only giving you one chance to sit and settle this way or that way. Therefore, mediation was ordered. Mediation was on 6th of January, where she was adamant. And therefore, Lords, we are back, Lord, before the honorable court. Because this honorable court made it very clear to her that the visitation right, you have misused it. After this honorable court permitted all that, now you have retained the child. We are also dear that the child's interest should be protected. The honorable court also said the same thing. In the interest of the child and in your own interest, it is better. My learned friend also agreed that it's a matter for settlement. But in the mediation, she was
You're correct. So what do you suggest? You let us know if there's some constructive suggestion which we can push forward. These are not matters for adjudication, isn't it? So now, nevertheless, there appears to be some court order which she may violate it. Without entering into that, what is the way forward you suggest? Let us see.
But may I make one
Yes.
stand of my client very
Yes.
clearly. From 2013, the divide happened. When he was abroad in three, periods, 1 month, 1 month and 15 days. First two periods, her mother stayed with her in Bangalore because he had built a house, she was alone. That 15 days period, third period, the parents of the husband lived with her. There was some kind of a, now he's a retired headmaster. They expect some kind of adjustment, respect from the daughter-in-law. That was wanting. Therefore, there were some issues there. And therefore, I believe there was a quarrel and in an emotional thing, the father-in-law has, assaulted her. And she left. When the husband came back, he has admonished both parents as well as the wife. Because this is not to be happened because he is doing well. That doesn't mean that in the domestic disturbance should not be there for his progress. All that happened, but she refused to adjust thereafter. 2016, when he purchased a flat for housewarming ceremony. When his parents came, she went away. These are all the things which have added up. In 2019, now they say it's not so easy to push out somebody. She herself goes from 2019 onwards. In fact, from 2013 onwards, mentally they are divided. Though they were under the same roof, they were not living like husband and wife. In fact, the husband was cooking for her. She never used to undertake any household works. But all said and done, the divide is so much now. And now she wants to use the daughter as a pawn to harass the father. That should at least end, is this submission. Now, whatever reasonable the husband is willing to make for the separation to the wife as well as to the daughter. Daughter's responsibility is his. That can't be denied, whether she studies here, there, or wherever. And all that filial, love and affection, the father is, but this person is trying to use the daughter. Because of this domestic issue, near Dharwad, there is a very good residential school. She studied there. Now she was to go to the PU stage. Then he made arrangements. That is frustrated by the mother. For her selfish ends, to see that the father is harassed, and father always, follows her dictates.
But what is the way forward? What is the way forward?
Now my submission to Lordship says, there is a irretrievable breakdown of marriage. Some arrangement the husband is willing to do. If there is a separation, daughter's responsibility will certainly take. He has, I have also advised him, he has also agreed to take. Whatever may be her tantrums of the wife. But the daughter has to be kept free for her studies. Now from the institution in Mangaluru to Christ College in Bangalore, she herself expressed in the mediation that there is no, the standard is not, good. But anyway, it is her choice. And that's what is the situation we are at this stage. So therefore, it is for them to, come one step forward. And we are willing to go 2 steps forward to see that the matrimonial issue as well as child custody issue is resolved.
Yes, what do you say?
Let me make my submission, my lords. Even in the mediation everywhere, the only thing is that she does not want to live with the parents-in-law because they have physically abused her. And my learned friend also has accepted the fact. She wants to live with her husband and daughter. Terms, she has stated that she is not going to give the receipt for their mutual consent. She wants to live with her husband. Only he does not want. He says that you have to live with my parents only. Once a physical abuse has taken place, not once, several times, definitely the egos are hurt. And they are not children, my lords. Elderly people and being physically abused is not a small thing. And she has not filed any case under that one also. She could have initiated the proceedings. She has not initiated proceedings. Only thing is that What he has done is because my learned friend is mixing up both the cases of the dissolution of marriage as well as the GNWC. I am arguing on the GNWC. Even in the matter, this one was dismissed. His MC for dissolution of marriage was dismissed because no cruelty on the part of the appellant present. My client has been proved, my lords. The only issue that he has not, even my learned friend right now has stated that she has not taken care of her parents-in-law. When she is living in Bangalore, and when there is physically abuse, where is the issue of taking care of the parents-in-law, number one. Number two, when the person has physically abused, when he has accepted physically abused, the issue, I think, is more serious than what is there. And it is the respondent who does not want to live with her. My client is ready and willing. Several times she has expressed, even to the honorable court also, she has expressed the view that she wants to live with her husband and lead a happy life. Secondly, my lords, regarding the GNWC, my learned friend's colleague had said that he will file an affidavit to the effect that they have no objection for the child to be with the mother. And suddenly they withdrew this one. That's also on record, my lords. It's on record that they wanted
No,
to
we
file an
want to
affidavit.
correct. Now, what we are asking now, is there any way forward for this? Now we can, deciding is one part of it. Is there any way forward? You let us know, we'll see.
My client is ready and willing to live with her husband, my lords.
With the in-laws, no.
Because of the physical abuse. She has told me they have beaten me so many times. How can I be there at home? She is not a working woman. She is a housewife only. So if she beat me and hit me, what can I do? It has happened several times. That is the only issue, my lords. No cruelty, nothing. My client wants to live happily with her husband and daughter. It's not that as my learned friend 2013, there was no dispute. Only after 2006 to 2013, absolutely there was no problem for 7 long years.
Let us see.
Post-COVID, my lord, the husband has to shift from Bangalore to Dharwad, where his parents are living. Presently, my lords, he is in Dharwad only, he is working from home, he is working in a company. And there are some farmlands he is taking care of because the parents are aged. His other brother is working in Bangalore. And one daughter is married and staying in Bijapur. So he being the eldest, now he has to stay with the parents and he's at Dharwad right now. Because after the COVID lots, everything failed. He had to, come to Dharwad and work from home. And the only house he had in Bangalore, there was a heavy loan on that. He could not service the loan. So he had to sell that house. Today, my lords, he has no base in Bangalore. He is in Dharwad, living with his parents, taking care of his aged parents. Father is 80 years old and mother is 70 years old. And usual, my lords, age-old the ailments are there. That is his responsibility. Now, if the wife says that she is not willing to stay, and that is because of one incident which happened way back in 2013, and he is being harassed lots from every day, economically, emotionally, and using the daughter as the pawn. That, my lords, is something which is beyond the tolerance of the father.
No, correct. But then now if she wants to stay and it's not possible, either to make a separate house or some arrangement next to each other. If she is ready to come.
Now the child is taken to Bangalore, admitted in a hospital, in a Christ college.
So that we'll see. But if she is ready to come to Dharwad, and can you make a separate arrangement?
Well, that is the difficult. That's what was discussed. In fact, in the mediation also. You can say at this age and stage, it is very
next door, some arrangement can be made next to each other. Whether if it is possible.
Because temperamentally, what my learned friend says is a different thing, and what is available on record is a different thing. Temperamentally, she is not going to adjust either with the husband, or it's only the makeup what they are doing it. That's all. Therefore, these kind of things have happened because 2013, 2016, 2019, many a time she has gone away herself. Her only brother and mother tried to console her. She doesn't listen to anybody. And now, because she has taken the daughter to Bangalore, she is canvassing that I have succeeded in the case, therefore, the daughter is with me. It is up to her. But the matter is before this honorable court. And this is the situation not the husband is in. Now, emotion.
May I make a submission, my lords, of the allegations made by my learned friend?
Just wait. Now, Mr. Ramana, in case
Yes, my lord.
your client is really interested in the husband,
Yes, my lord.
really interested, because we don't know, you're living apart. We don't know what has happened in the four walls.
Yes, my lords.
But if she's really interested, then we can see. Otherwise, now they are saying that parents are aged about 80 years. So now we can take undertaking if she's ready to coexist. After 80 years, what physical assault can they do?
No, my lords, I will make only one small submission, my lords. The reason for all these things is my client comes from a very poor family. The respondent is very rich because my client's brother, who is just a clerk in a credit cooperative society, he is a person who is supporting. That's why he comes from a very small family and poor people. That's the reason why all these things issues have come up. The respondents are very rich. They have own houses, everything. All those things. He had his own software company. All that. That is a major problem.
correct,
So
but
it is not that my respondent has no wherewithal or anything like to support her. And he says emotionally she is not willing. For everything, he has an answer. He says that under any circumstance, I don't want to live with her. Because all these suggestions were made. But honestly, the cruelty itself is not proved. She has not done anything. It was the in-laws of the
correct. We'll
appellant.
accept, no, we'll accept all that. But as
Yes,
of
my lords.
now, you find out if she's ready to go.
Yes, my
We'll
lords.
see. And if he's ready to go and he's ready to take, we'll see. Now this.
I'll
issue
find
can-
out, my lords.
You find out.
But
Let us-
during
find
mediation,
out
she made
first.
it very clear
Hmm.
that I'm not willing to stay with that family, husband with his parents. That she has made it very clear in the mediation.
I will make her present before this honorable court, my lords. Lordship can check it out because she has told me even in this morning also, I have no problem with my husband. I want to live with my husband.
No, correct. Now, in case she is ready to come back and stay with the in-laws, and are you still in a position to take her, or there may be some difficulty you find out?
There may be difficult, but I'll find.
So that you find out. Now, Mr. Ramana, you will have to make one sacrifice. Maybe you
Yes,
will
my
have to ask her that if you want the husband, assurances will be made before the court. And since they're above 80, undertakings will be taken. And if you're ready to go and stay along with them, same thing we'll ask on the other side.
Yes, sir.
And we'll have it next week. You can
Yes, my
both
lords.
come on VC. You can come on VC.
Yes, my lords.
Parties presence also on VC. Link can be shared.
Yes, my lords.
And if it comes to that, that there is something, we'll see. And
Yes, my
then
lords.
then we'll decide what is to be done. Anyhow, daughter is with you in effect. So let
I am a
us see.
person who wants that a family system should be saved, my lords, always. Family is
Let
the
us see.
basic unit of society.
Let us
It should always be saved.
So let us see. We'll have it next week. We can all
Lordship,
appear
fix a
to-
date, my lords.
We'll see. Twice before, my lords, both the parents were there, and on one occasion, the daughter was also there. And on the next date, my lords, it was dispensed away. But having regard to the conduct of the wife, that she could defy the court orders also.
That
Not
we'll
the-
see.
That whatever the arrangement with the husband or
No,
parents-in-law.
no, that we will not approve of. We will not approve of it. We don't approve of it. However, we'll have it next week. What if, let him also get back. Mr. Ramana, you can talk to Mr. Patil in advance
Yes, my lords.
and respond to this, what your stand is. Let him take his stand, then we'll see how to move forward.
Yes,
We'll
my
have it,
lords.
We'll have it on next week.
Now, Lordship will give a date, my lords.
Yes, yes. Relist the matter on 28th,
29th, my lords, if it is possible.
29th.
29th, because 27th I had to be for Telangana High Court. I don't know if it spills over to next day, that's why.
Yes, yes.
Not really, initially will appear through VC. my lords, and then
Yes,
we'll
yes.
decide.
Much of that.
Pardon for interrupting, my lord. Seal number.
Yes.
I mean, pardon for interrupting, my lord. Seal number 5, there was an interim order of non-alienation during pendency of the
Order
matter.
review grant is extended to the next. Yes.
Till number 7, Sanjeev Kumar C. Patil.
Around 2 weeks' time may be granted to take steps to, my lord, unserved respondent. There is a
Yes.
R 34 and 35 refused ಅಂತ ಬಂದ್
Or
R 34 and 35 refused ಅಂತ ಬರ್ದೆ.
check ಮಾಡಿ. In light of postal endorsement, postal
Yes.
endorsement as regards R 34 and 35, service is held sufficient. Office to show the name of the said respondents as served in the cause list.
40 and 54 also unclaimed.
40 and 54 also unclaimed ಅಂತ.
Allah, unclaimed, we may not be able to take it as a service.
Then
So
one
the,
is-
the FDP proceedings are initiated?
Yes,
Initiated.
yes.
Then why don't you serve on the council appearing in the FDP also?
May I make one submission?
No, no.
Except respondents 1 to 6. Other respondents are totally absent before the trial court.
Absent.
Yes, ma'am. It is only the respondents 1 to 6 who are the plaintiffs, my lord, they have filed a suit. And other defendants, they were placed ex parte.
So 1 nimsh, 40 and 54
Yes,
were placed ex parte.
ex parte.
Put it.
Yes, ex parte.
Who is R 40 and 50? What is
Kindly
the-
turn to judgment of the trial court.
What is the rank?
My lord, page number 8 of the judgment.
R 40 and 54.
Yes.
They are defend number 28 before the
Defendant number 28 and
28 and 2C, my lord.
Defendants
Defend number
3 to
2C.
6, 11 to 24, 25, 32, 39. They were ex parte.
no, I'm on the point.
Please, my lord.
D 40 is D 28. R 40 is D 28.
Yes.
R 54,
Defend number 2C and
defendant number 2C.
2C.
Both were ex parte before the trial court.
Yes.
Judgment copy alone.
Yes, my lord. Defend number. No, defend number 1, 2.
Defendant number 1 to 21 have contested the matter.
I'm asking whether defendant number 28 and defendant 2C were ex parte or not.
Please.
My lord,
Defendant number 28 was ex parte.
28 was ex
Ex
parte.
parte, my lord. Vidyavati. Even 29 was also ex parte.
Defendant 2 was represented by a council,
Yes, my lord.
isn't it?
yes, yes.
Yes, ma'am.
Ah,
PMR
so-
advocate was appearing for defendant number 2.
D 28 ex parte ಅಂತ ಎಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೇ ನೋಡ್ಬೇಕು.
ಅಲ್ಲ, ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 8 ನಲ್ಲಿ
Page number,
8, my lord.
ಹಾ,
Defendants 1 to 21 by Umashankar B. Jolly advocate. Defendants 3 to 6, 11 to 24, 25, 32 to 39
Expert.
were ex parte.
so 28, we don't know what happened.
No, that is also ex parte, my lord.
Where is it? ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಚೆಕ್ ಮಾಡಿ.
Yes, my lord, Vidyavati.
My lord,
Anyhow, check the TCR.
I will verify it. If they expert, I will file a memo. to that
File a
effect.
memo.
Yes.
There is one more mistake occurred. I have moved a memo for reporting death of respondent number 23. The registry has typed as R3, my lord, which is not correct. I have moved a memo
Ah.
that respondent number 23 is expired. I have given the death certificate also.
So you take steps.
I will take step. On the ಎರಡು ವಾರಲ್ಲ I will take step.
Last year I have given the death certificate, my lord, till today has not taken steps.
You take
My
steps.
FDP is being held up.
Take steps.
Yes.
The appellant is permitted to serve counsel appearing for the respondents who remain unserved by taking out notice on the counsel appearing in the FDP proceedings. This would be in addition to necessary steps to be taken in the present appeal. List the matter on date code. By then you find out what is to
Yes.
be done.
The respondent number 3 may be taken as respondent number 23, my lord, died memo. 3 ಅಂತ wrong type ಆಗಿದೆ. Memo reporting death of respondent number 3 ಅಂತ ಆಗಿದೆ. That is not correct. That is respondent number 23.
Office to rectify the note at field number 3 of the cause list as memo has been filed reporting death of R 23.
R 23.
Relist the matter next week. Date
One date may be given.
ಅಲ್ಲ ಒಂದು
29th.
week after next, one,
Hmm.
2 weeks on 3rd of,
3rd of February.
Monday.
Whatever you have to take, you
Yes.
take, serve on
Please.
the. Yes.
Till number 8. Singh Chawad.
Here for the respondent. We comply the order of the single judgment.
You have complied.
Yes, my lord. Earlier order, my lord, kind see, my lord, in my affidavit, my lord.
No, last time I directed writ petition copy to be produced. Isn't it?
There is a direction to him, my lord, that is not produced. But I will take you, lordship, my lord, page number 10 of my affidavit, my lord. There is already contempt was filed.
Page number.
Page number 10, my lord, Annexure R2. This contempt, my lord, was disposed of, my lord, on 23/10/2021, my lord, directing the authorities to conduct the survey and issue the for number 10.
Just one. Him lawyer in there.
advocate ಅವ್ರು ಬಂದಿಲ್ರಿ.
Advocate ಬರ್ತಾರಾ?
ಇಲ್ಲ ಅವ್ರು ಬೇರೆ
Last occasion, my lord, he changed the advocate. Another advocate, my lord, filed the wakalat.
ಯಾರು?
Or one, my lord, now present name is showing, my lord. Earlier, one Nayak was appeared, my lord. Thereafter,
ಆಯ್ತು, ನಾಳೆ ಕರ್ಸ್ತೀರಾ ನಿಮ್ ಲಾಯರ್?
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಆಯ್ತು, ಹೊಸ ಲಾಯರ್ ಬರ್ಬೇಕಲ್ವಾ? ನಿಮ್ ಲಾಯರ್ ಇರ್ಬೇಕಲ್ವಾ? ಹಾ, ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ?
ಮಧ್ಯಾಹ್ನ
ಹಾ, ಮಧ್ಯಾಹ್ನ ಕರ್ಸಿ ಪಾಸ್.
9. VK Nayak.
4 to 7 of the government.
So contempt, yes, you will take notice.
please, my lord, I will take notice for respond 4 to 7, my lord.
GA accepts notice for respondent 4 to 7.
7.
What is the main matter?
And matter, my lord, the appellant herein has been appointed on contractual basis. My lord, on 13/10/2022, 6th respondent visited the place at about 2:30. And this appellant went to attend the nature call since there is no restroom and there is no water available in the office. He is working in a remote village and show cause notice has been issued for explaining why you remained absent for 1 hour. The explanation has been given stating that I went to attend the nature call. And the show cause, in the show cause notice, a time has fixed within 24 hours, you have to give a reply. The reply has been given within 24 hours. Before the accepting my reply to notice, a recommendation has been made to remove from the service. And I have been removed from the service without consent, written consent and permission of the respondent number 1. That has been challenged before the Honorable Trial Court, learned single judge. Your Lordship, kindly see the order, impugned order, page number 14, my lord, para 12, my lord. A new case has been made out. Para 12 of the learned single judge order. Admitted the petitioner, married, my lord. Admitted the petitioner appointed on a temporary contractual basis on 24/11/2017 for a period of 3 years, which is expired in the year 2020. And thereafter, contract had been extended from time to time from 1 year period. Thus, if the contract were not to be extended for further period, the contract would itself have to come to an end with the expiry of the contract period in the year 2022. The services of the petition having been terminated
though with cause. Now Sri Tengli submitting that the termination could be treated as without the cause by making a payment of 1 month salary in lieu of the compliance of clause 13 of the agreement. I am of the considered opinion that the contract being itself is determinable. Question of setting aside the termination order, termination thereafter the respondent not renewing the contract would not be in the interest of anyone of the including the petition. Well, it is not the case of the respondent that the contract is over, we are terminating. It is their case is, I remained absent for 1 hour, and that's why a show cause notice.
Where
has
is
been-
that order of termination?
Lordship kindly see.
Page 46. Sir.
Please. Fourteen 10/2022, page number 104, man.
Correct, but now what is to be done? They're saying it's contractual.
My lord, this
They
is not
don't
the,
want their service.
my humble submission is this, my lord. The respondent's government is relying upon the termination order that I remained absent for 1 hour. A new case has been made out by the learned single judge that anyway your contract is, you are appointed on contract basis, you can be removed at any time.
But that is the law, is
My lord, the your lordship kindly, I have relying upon the judgment of the apex court, wherein recent judgment in under 226. More relief can be granted.
Whether they want to continue or not is up to them. Now, suppose they
Lord.
were to say, we withdraw the allegation, discharge simpliciter.
My lord, the termination so harsh that my lord, he remained 1 hour for absent for 1 hour.
No, correct.
Then he is a youth, my lord, is already there is an unemployment. He remained for 1 hour.
No, sir, no, correct, but now whether to continue or not, after the contractual period is at their discretion, no doubt we can ask them to expunge the remarks. Now, Mallikarjun.
Please,
You find out in case they are ready to take him on terms.
Please, man.
It's up to them. We can't force. But since it's a recurrent work, if on fresh terms with undertaking, they feel, we leave it to you. We are not going to force the problem of unemployment, not legally they can't ask. You ask, if at all they can accommodate, instead of X, he will do is what.
Please, man, that's what.
Huh?
I will get it.
Let us live with an open mind.
Please.
Nothing personal about it.
Please,
Realist the matter.
Monday.
Good.
Oblige.
Whatever undertaking from him, we'll get it done. It's a matter of livelihood.
Number 10, Ratna and Shivayogi Mat.
My lord, I am humbly praying to drop this contempt here itself, as the interim order passed by in the writ petition is obeyed by the respondents, and allowing a petitioner complainant herein to discharge her duties. So willing to drop the.
Drop.
Yes, ma'am.
We have complied, my lord. It is reported in before the
File a memo. In light of the memo filed by the complainant. And in light of the submission that they do not intend to proceed any further, as the interim order of the single judge in complied, proceedings are dropped. File a memo.
Much.
Yaar Kapil.
R6 and R7. My name may be shown as R6 and R7.
So-
Chaitanya Kumar.
Under appears for R6 and
R7.
R7 and is permitted to file memo of appearance.
Much.
Yes. You file memo.
Yes, ma'am.
Hearing done, serial number 11,
This is corporation's appeal, my lords,
Yeah.
challenging quantum. Though liability has been challenged, my lords, charge sheet is filed against me. The driver of the corporation, charge sheet is filed against me, my lords. One is, my lord, quantum is not the income assessed by the tribunal is on the higher side, my lords.
So you give your calculation, show it to him and give your calculation. Give your calculation.
No, sir, as per chart, they have to consider 11,750 minutes.
11,000.
750 minutes.
Huh.
But the tribunal has assessed 22,000 and 19,500 minutes.
There is no evidence of salary.
Evidence is adduced minutes.
Then?
The employer of the deceased has been has given evidence before the tribunal minutes.
To show that he's paying.
At least the page number 23, my lord,
Huh.
of the judgment, MVC judgment,
Huh.
wherein in para number 28,
Who's the employer?
my lord,
Private or what?
private, my lord,
Private minutes, private.
para number 28, may kindly.
Huh.
The claimants in MVC number 280 have contended that deceased were earning 25,000 per month to support their contention. Furnished the salary certificate and salary slip of the month to July 2018, which are marked as exhibit P8 to 13 to 15.
P8 to?
Exhibit P8 13 to 15. P8 and 13 to 15.
What are those exhibits? Take us through that.
The salary certificate of deceased. The-
Now he has been examined.
Please, Banan, he has been examined.
As PW?
PW3.
PW3. Which are the 13 to 15?
Please, Banan.
What is that?
13 to 15. Salary slip of Duda, deceased Duda.
What else then? So salary, one dispute.
That's one.
You are disputing only salary, isn't it?
That's one.
That's all.
That's one.
What is your other ground?
Not sir.
Salary. The other one is?
Salary minutes, another ground is contributory negligence minutes. But charge sheet is filed against the driver of the corporation.
Corporation only.
Yes, ma'am.
What is? Dismiss. Please don't follow.
No, sir. Interest 9% has been awarded, at least 6%.
6%. It is.
Yes.
Correct. 6%.
Please.
Partly allowed.
Yes, ma'am.
6%.
And deposit in amount in deposit may be transmitted to tribunal.
Transmitted to tribunal.
Yes.
Yes, yes. In saving the interest, you have lost much more interest. Yes, yes, next.
Number 12, Ravi B. Patil.
Here for the respondent, my lord. Now government is passed the order, release the amount, my lord, which is, my lord, agreed before the mediation center, my lord. Beneficiaries agreed to pay that amount. Now that amount is released to the, my lord, beneficiary.
No release ಆಗಿಲ್ಲ ಅಂತ, but
ಆಗಿದೆ.
government has released the funds, it seems, my lord.
So now what? Now the money has to be given to him.
Yes, that has
That
to be,
money
my
has
lord,
to be
after getting the sale deed, direct sale deed from these, my lord, complainants and other owner, landowners, my lord. That amount will be payable to them.
Any
By the
day, my lord, to their convent, we are ready, my lord, we are ready.
So that
Anyhow,
survey,
we have lost the lands, my lord.
that, my lord, sketch has to prepare for getting the sale deed, my lord, registered. This is direct sale, my lord, there is no notification. Learned single judge, my lord, our notification was, my lord, lapsed. Thereafter, my lord, directed us to proceed with the in accordance with law. Now, my lord, there is a direction for that is we not complied, then we filed the contempt. In the contempt, my lord, there is a direction to get it settled before the mediation center. All the officer, including the beneficiary, attended the meeting, they agreed. They will agree to pay that amount, 11,20,000 rupees per acre for dry land, another, my lord, 15 lakh something for irrigation land. All the owners is agreed. Now, my lord, as per that, they written letter to the government, my lord, to release the fund. So that amount is released to them. Now that will be after getting the sale deed, my lord, that amount will be payable to them.
So we'll only adjourn it then.
Please.
Not, my lord, that in persons of this one, murder, our job is over.
Correct, correct.
There is a kindly see the order of the learned single judge.
No, correct. What we are only saying, we will notice this and keep it pending. After it's finally settled, we will.
No, that is, they are entitled only for amount, my lord.
ಹೌದು.
That is the, my lord, amount is released.
ಅದು ನಮಗೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ, ಅವರು ಸೆಡಿಟ್ ಮಾಡಿಸ್ಕೋಬೇಕು. We are always ready, my lord, whenever they are ready. my lord.
So let it come to an end instead of one more round.
ಇನ್ನೊಂದು ಮತ್ತೆ ಆಮೇಲೆ recalling.
We'll notice the memo.
But kindly see, my lord, order of the learned single judge for a moment.
Para 6.
Para 6 is. In view of the above, preliminary notification produced dated so and so at annexure F is lapsed. Insofar as the second prayer of the petitioner regarding consider the representation is concerned, the respondents are directed to consider the representation.
No, the representation was to the effect.
That is, my lord, to acquire that land, pay the.
So now substantially it is complied.
Yes.
So we'll notice that, but let whatever has to happen finally happen. That is one more round of litigation.
Even liberty may be given because, my lord, our, my lord, submission before the court, my lord, beneficiary is not before the lordship, my lord. He made the application for impleading the beneficiary.
That is
But in
my
contempt,
difficulty,
my lord,
my
I
lord,
don't know
beneficiary.
whether it is survival
No,
for that
after acquisition,
or not. Because in the main petition, it's they are not the party. Here, my lord, he wanted to implead the beneficiary as a party.
Last time ಅದು ಇಂಪ್ಲೀಡ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂದಿದ್ದಕ್ಕೆ now, my lord, anyhow at the request of the beneficiary, funds are released. My lord, if some date is fixed, my lord, sale deed will be executed and funds will be released. Because again, my lord, if I have to.
Now you ask the beneficiary to proceed.
ಅಷ್ಟೇ.
They are proceeding, my lord. They are requesting us, my lord. That is the order I produced before lords, my lord. Kindly say, my lord, that is the order. Para 3, my lord. ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ವಿಜಯಪುರ ಇವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ 9/2/2023 ಜರುಗಿದ ಸಭೆಯಲ್ಲಿ ಜಿಲ್ಲಾಧಿಕಾರಿ ಹಾಗೂ ಅಧ್ಯಕ್ಷರು ದರ ನಿರ್ವಹಣೆ ಮಾಡುವ ಸಲಹಾ ಸಮಿತಿ ಹಾಗೂ ಸಂಬಂಧಪಟ್ಟ ಇಲಾಖೆಗಳ ಅಧಿಕಾರಿಗಳು ಮತ್ತು ಭೂಸ್ವಾಧೀನ ಭೂ ಮಾಲೀಕರ ಒಪ್ಪಿಗೆಯೊಂದಿಗೆ ಬೀದರ್ ಜಿಲ್ಲೆ ಬಾಲ್ಕಿ ತಾಲೂಕಿನ ಜಲಸಂಗಿ ಗ್ರಾಮದ ಹತ್ತಿರ ಹೊಸ ಇಂಗು ತೆರೆ ನಿರ್ಮಾಣಕ್ಕಾಗಿ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡ ಶಿವಪುರ ಗ್ರಾಮದ ವಿವಿಧ ಸರ್ವೆ ನಂಬರ್ ಒಟ್ಟು 15 ಎಕರೆ ಒಂದಕ್ಕೆ 11,20,000 ನಿಗದಿಪಡಿಸಿರುತ್ತಾರೆ. ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ ವಿಜಯಪುರ ಇವರ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಕೋರಿರುವಂತೆ ಒಟ್ಟು ರೂಪಾಯಿ ಸೋನ್ಸೋ ಭೂ ಮಾಲೀಕರ ಪರಿಹಾರಧನ ಸಂದಾಯ ಮಾಡಲು ತೀರ್ಮಾನಿಸಿ 2024-25 ಸಾಲಿನ ಆಯೋಗಗಳ ಲೆಕ್ಕ ಸಿರಿಸಿಕೆ ಸೋನ್ಸೋ ಭೂ ಸ್ವಾಧೀನ ವೆಚ್ಚಗಳು ಅಡಿಯಲ್ಲಿ ಅನುದಾನವನ್ನು ಬಿಡುಗೊಳಿಸಿ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. So that amount is released to them. Now, my lord, they have to get the sale deed from them, my lord. They will pay that amount.
Who is the beneficiary?
ನೀರಾವರಿ minor irrigation.
Minor irrigation.
ನಿಮ್ಮವ್ರೇ?
ಇಲ್ಲ. There is separate, my lord. Separate entity, my lord. That is just like KNNL, my lord, like that.
Corporation.
Yes.
So they have to execute the sale deed because when the amount is, my lord, already released to them, my lord, they will do, my lord, that one in occurrence.
Otherwise, we'll record it reserving liberty. We'll only say reserving liberty. And we'll make an observation that the government is also to take appropriate steps to see that the beneficiary implements it expeditiously.
My lord, I have specifically filed an application to that effect also, my lord, to bring, make, my lord, the beneficiary also a party, because, my lord, they were not party in the writ petition because,
No, correct.
since, my lord, acquisition is by the government.
That
Now
is-
they have transferred the project to the beneficiary, and that doesn't mean that government has nothing to do with that.
No, correct. So that observation will make and reserve liberty. Let us see what happens.
My lord, my difficulty is, my lord, if beneficiary doesn't get the sale deed executed immediately, again, my lord, I have to, my lord, file a necessary application recalling and this stage. And now, my lord, everything is resolved. Nothing more survives, my lord.
Any lawyer for the beneficiary entity?
Earlier, my lord,
No, the entity is, what is the entity? Name of
My
the
lord, Sanna Niravarige, Assistant Executive Engineer, Minor Irrigation Department, Subdivision, Nova.
mediation ದಲ್ಲಿ ಯಾರು ಪೇರು?
Our direct officer had come. Before, my lord, the mediation,
No, you
officer
just
had come.
find out, we'll have it next week. You find out what is the rough time frame. Then we'll see how to.
I will ask the one of the officer, my lord,
Yes.
present before lord.
See.
Monday.
Monday. Relist on Monday.
But,
Yes.
30, Ratna and Shivayogi ma'am.
My lord, the complainant herein has is willing to initiate the contempt against the accused because as she presented a representation before the respondents, but they are not ready to accept it. And the representation is about the order passed by the, in the writ petition, my lord, which is about considering the 5% of weightage service for her recruitment.
No, still no order has been passed.
Order is passed, my lord.
No, consideration has
No, my
not.
lord. They are not considering the representation.
Correction only to the responder 3, my lord.
Correct.
But they also made the responder 2. Responder 2 is not, my lord, necessary party.
Now,
R-
who's R3?
R3 is the.
Served, is it?
Yes.
Served.
Third respondent here in.
ಅಲ್ಲ, ಏನಾಗಿದೆ notice?
Notice has to go, my lord.
Has
First
to
time.
go. Issue notice to.
I'll take notice for R1, my lord. Notice may be issued to R3.
Issue notice to respondent number 3. AG accepts notice for respondent number 4.
4.
1, 2, and 4.
Please.
Huh?
Please.
1, 2, and 4. However, as it is noticed that accused number 3 is the answering respondent.
Please.
After notice, R3 is to make its response. Relist the matter on 5th of February. Yes.
First week, I'll better. So next
Next week.
first week, better.
11th.
Please.
40, KM Khate.
Defendants appeal. It's a delay, my lord.
Then you take out notice.
Yes, ma'am.
Issue notice to the respondents. TCR to be summoned forthwith. Notice on main as well as IE.
Please.
Yes.
Number 50, Shivanand Patil.
Pass over. Yes, next.
Till number 60,
And for the respondent.
This is a matter where recovery of money is challenged, my lords. Recovery of money is challenged and learned against the order of the learned single judge. I was before this court. Last occasion, my lord, I have a request of one-time settlement here if their parties are to be kept present and we can sit together and I am ready to make payment also. I'll give an affidavit saying, fixing on the date and I'll make the payment. So I.
Thursday or Friday?
Relist on Thursday.
Thursday.
Grateful.
70, Sridhar Prabhu.
Your Lordship,
appearing for the appellant. This is a fresh matter which was posted for hearing on IA for condonation of delay. Your Lordship, the delay occurred due to the time required to secure and arrange the original document during the winter period, Your Lordship. The delay was neither intentional or deliberate, Your Lordship.
But you'll have to now take out notice, isn't it?
Yes, sir. Let the notice be issued. We'll argue in detail, Your Lordship.
Yes. Issue notice on IA as well as main to the respondents. TCR to be summoned forthwith.
Your Lordship, next date.
Notice must be served week after next date.
Okay.
10th
Obliged,
of
Your
April.
Lordship.
Yes.
Obliged.
You want to take out notice by way of hand summons, we'll permit you. In addition, appellant is at liberty to take out notice by way of hand summons as well. Next.
Obliged.
RJ Pusare.
Preparing for petition.
What do we do?
My lord, since my lord, the matter is covered by the.
Adjudicated on merits.
Yes, my lord. An opportunity we given, my lord, for because the matter is, my lord, squarely covered by the judgment of the Honorable Tribunal, my lord, and under similar circumstances, my lord, the benefit has been extended, my lord, under 41C of the KCSR, my lord. Therefore, my lord, one opportunity may be given and matter may be remanded for fresh hearing.
Technically, there is no.
Correct, we agree. But see, there's no adjudication on merit.
Please, my lord,
Isn't it?
with that observation.
Adukon review. You tell us the facts.
Please.
KCSR.
My lord, the petitioner is the ex-serviceman, my lord.
Yes.
My lord, he retired from service on 1/2/2006.
1/2/2006,
my lord.
Yes.
And my lord, thereafter, my lord, he has been appointed as SDA on 29/6/2017. 29/6/2017.
What does the rule say?
As per 41C, my lord,
Read.
please. 41C3, my lord. 3 and 4.
Read 41C and then go to 3.
Please, my lord. 41C, notwithstanding anything contained in any other roles, where a military officer of the rank of junior commissioned officer or below who is discharged from the military service before superannuation is appointed to a post in accordance with the rules regulating recruitment thereto, his pay in the time scale of the post in which he is so appointed shall be fixed as follows. 1. Where the pay drawn in the military service is equal to a stage in the time scale of the post to which he is appointed, it shall be fixed at that stage. Where the pay last drawn in the military service does not correspond to a stage in the time scale of the post to which he is appointed, it shall be
Roman 3.
3, my lord. Where the 3 and 4 both are relevant, my lord. Where pay last drawn in the military service is below the minimum of the time scale of the post to which he is appointed, it shall be fixed at the minimum. 4. Where the pay last drawn in the military service is above the maximum of the time scale of the post to which he is appointed, it shall be fixed at the maximum. Now, my lord, the petitioner's case has been considered under 41C3 and, my lord, the endorsement has been issued. Whereas, my lord, as per the 7th pay scale, my lord, the pay scale has been revised and he is at, my lord, getting the salary of 28,000. Therefore, he made a representation to consider a representation.
Rule 4.
Rule 4, as per Rule 4, my lord. But the case has been considered under Rule 3, my lord.
Where is the endorsement?
Please. Page number 34. Second para. ಫಸ್ಟ್ ಪ್ಯಾರಾ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ತಮ್ಮ ವಿಭಾಗದ ಕಚೇರಿಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಶ್ರೀ ಸ್ವಯಂಸೋ ಇವರಿಗೆ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮ 41C ಅಡಿಯಲ್ಲಿ ಪ್ರಾರಂಭಿಕ ವೇತನವನ್ನು ನಿಗದಿಪಡಿಸುವಂತೆ ಕೋರಿರ್ತಾರೆ. ವಿಷಯವನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಸದರಿ ನೌಕರರು ಮಿಲಿಟರಿ ಸೇವೆಯಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸಿ 1/2/2006 ಬಿಡುಗಡೆ ಹೊಂದಿರ್ತಾರೆ. ಇವರು ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗದ ಮೂಲಕ ಮಾಜಿ ಸೈನಿಕ ವರ್ಗದಲ್ಲಿ ವೇತನ ಶ್ರೇಣಿ 11,600 71,000 ನೇಮಕಗೊಂಡು ದಿನಾಂಕ 3/7/2017 ಈ ಇಲಾಖೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ಹಾಜರಾಗಿರ್ತಾರೆ. ನೌಕರರು ಮಿಲಿಟರಿ ಸೇವೆಯಿಂದ ಬಿಡುಗಡೆಯಾದ ಸಂದರ್ಭದಲ್ಲಿ ಇವರು ಮೂಲ ವೇತನ 8,000 ಮತ್ತು ಗ್ರೇಡ್ ಪೇ 2,800 ಒಟ್ಟು 10,800 ಆಗಿದ್ದು, ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಾವಳಿಗಳ ನಿಯಮ 41C ಖಂಡ 3ರಂತೆ ಮಿಲಿಟರಿ ಸೇವೆಯಲ್ಲಿ ಕೊನೆಯ ಸಲ ಪಡೆದುಕೊಂಡ ವೇತನವು ಆತನು ನೇಮಕಗೊಂಡ ಹುದ್ದೆಯ ಕಾಲಿಕ ವೇತನ ಶ್ರೇಣಿಯ ಕನಿಷ್ಠ ವೇತನಕ್ಕಿಂತ ಕಡಿಮೆ ಆಗಿರೋದ್ರಿಂದ ಅದನ್ನು ಕನಿಷ್ಠ ವೇತನಕ್ಕೆ ನಿಗದಿಪಡಿಸಿರುವುದು ನಿಯಮಬದ್ಧವಾಗಿರುತ್ತದೆ ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ.
But a revised pay scale was?
Yes, my lord. Page number 32. Serial number 3. Serial number 2, my lord, the last pay drawn, my lord. Serial number 3 is the pay scale as per the 7th pay commission notionally arrived under the revised pay structure corresponding for a format of pay by the employer as both.
No, this was as on the date of your retirement. In the
My lord,
military service.
yes, my lord. The same has been considered, my lord, in several other connected cases, my lord, where one of the lordship, my lord, and the honorable tribunal, my lord, who has passed, my lord, the impugned order is also this same judge, my lord, who has, my lord, passed the order.
So as on the date he left military service,
Yes.
it was revised
Revised, my lord.
to 27,800.
Yes, my lord.
So you are entitled for that.
Entitled for, and that is same considered in one of the another similar circumstances. Para number 9, my lord. Therefore, the respondent is remiss is not considering the recitation of pay based on the revised LPC issued by the military authorities that have been received from the applicant's pay. Applicants' pay have been fixed based on LPC issued at the time of leaving military services, which last pay has been revised subsequent to applicants joining state government service. Rule 41C does not prohibit refixation of pay on appointment to government service
So this
based on.
revision of pay scale
Please.
with retrospective effect.
Yes,
So
ma'am.
though at the time of you leaving,
Yes, ma'am.
it was still less.
Yes, ma'am.
Subsequently, because of revision.
Revision.
It dated back to.
Yes, ma'am.
So
Yes.
your last pay had increased.
Yes, ma'am.
Actually.
Yes, ma'am. That is the case.
That's not taken.
Yes.
Now what happened, you were the single judge.
What happened, my lord, at
Tribunal.
the time of hearing, my lord, the lordship has expressed opinion that, my lord, since that is not applicable to your case, my lord, the land council, my lord, has withdrawn, my lord, under the.
It was dismissed as withdrawn.
Dismissed as withdrawn.
You must never believe anybody on the opposite side. You must never believe anybody on the opposite side. One scrutiny madvaga, you should not listen to the official. Here also, you must take a decision,
Yes,
whatever
my
we
lord,
say.
yes, sir. But
Yes, sir.
that too, my lord, the council has taken a decision without any, my lord, consent from the party, my lord. The same day, my lord, he has withdrawn the application. Thereafter, he filed, my lord, a memo
but-
for being spoken.
Just point out that.
Please, my lord.
ಇವಾಗ ಸ್ಕೂಟ್ನಿ ಎಲ್ಲ ಹಂಗೆ ತಾನೇ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಹಿಂಗ್ ಮಾಡಿ, ಹಂಗ್ ಮಾಡಿ. ಅವ್ರು
Uh,
ಕೇಳ್ಬೇಕು.
Page number 35, my lord.
Page?
Page 35, annexure B. Operative portion, my lord. The applicant's counsel has filed a memo to withdraw the above application. The memo is taken on record and the above application is dismissed as withdrawn. Page number 36. Then, my lord, a memo for being spoken is filed, my lord. Page number 49, my lord. Order sheet dated 26/7/2021. On 22/7/2021, after hearing the learned advocate for the applicant and he having been filed a memo to withdraw the application, taking the said memo on record, we have dismissed the said application as withdrawn. Now by filing memo for being spoken to, he is praying for restoration of the application by rejecting the memo of withdrawal submitted by the applicant and to reconsider the case on merits. In view of the application already been dismissed as withdrawn by filing a memo for.
What happened to the review? Now you take.
Then, my lord, a review order is your lordship, kindly see. Page number 53. Then review application is filed, my lord. Para 3, my lord. At the hearing, learned government pleader has submitted that the application having been dismissed on account of it being withdrawn by the applicant, it cannot be reviewed since the review application has not been made out any legally tenable ground for the review, and there is no error on the face of the record. That is the order which is based on the submission made by the counsel for the applicant through a written memo. We have heard the learned SGGP for respondent state and pursued the application and the amendments made therein. We are in agreement with the pleadings of the learned SCGP that the review application has not made.
Against this you have filed.
Yes, my lord. And this, my lord, I have called in question now, my lord. And in the review application, my lord, I have clearly mentioned, my lord, the order passed by the Honorable Tribunal, my lord, which now, my lord, which is given, that the matter is already covered and sought for review of, my lord. That has not been, my lord, considered.
So what is the real, now what is it that you want now?
Now it may be, your lordship, may be remanded for fresh hearing, my lord, or.
Same officer is same presiding officer or somebody else?
No, now, my lord.
There is.
ಇವಾಗ ಬೇರೆಯವರಿದ್ದಾರೆ ಇವಾಗ ಬೇರೆಯವರಿದ್ದಾರೆ ಒಬ್ಬರು ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಇದ್ದಾರೆ ಬೆಳಗಾಂ ಬೆಂಚ್ ಅಲ್ಲಿ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಮೆಂಬರ್ ಅವರು
ಪೀರಿಯಡ್ ಮುಗಿದು No, we may have to send it back. We may not be able to, because that review order, we may not be able to do. We can send it back with observation. That's the best we can do. Now, we can't allow the review itself here.
Right.
Isn't it?
Yes. Then
go
review should be once again had.
We make some observation.
Please.
That you can take benefit of.
If it is the review order is set aside and my lord, it may be directed to hear fresh.
We can set, correct. If the review order is, what you are saying?
Set aside and matter may be remanded, my lord, for application may be restored, my lord, for fresh hearing.
We'll make some observation that you take benefit.
In the review order, my lord, this application which was, my lord, a similarly placed person was benefited, was not, my lord, mentioned.
ಇಲ್ಲ review application ಅಲ್ಲಿ ಇದೆ.
ಇಲ್ಲ order ಅಲ್ಲಿ ಬಂದಿಲ್ಲ.
Order ಬಂದಿಲ್ಲ, review petition ಅಲ್ಲಿ I have mentioned clearly.
Show that, we'll observe that and see.
That is.
The present petition. Present petition has been filed. What is the other writ petition?
Both are similar, my
They are
lord.
the same
The
ಇದೆ.
parties are different, my lord.
Different parties.
Two different parties, two separate applications. Page 41, your lords.
Page?
Page 41, para 3.
Para 4 ಅಲ್ಲಿ 3 ನಲ್ಲಿ ಬಂದಿದೆ.
Para 3 and 4 ಅಲ್ಲಿ.
Review
it is
petition ಅಲ್ಲಿ
relevant to
ಬರ್ದಿದ್ದಾರೆ.
submit that the honorable court in another application number so and so, that is the same case, my lord. Seeking similar relief has been allowed, directing the authority to consider the application and directed to make payment as per the revised pay scale. It is submitted that in the said order passed by the honorable court, there is no mention with regard to the cut-off date for
The present petition, order 47, review, order 47, has been WP 202537 of 24 has been filed seeking to set aside order of the tribunal dated 22/7/2021 at annexure B, whereby annexure B page,
annexure B 35, page 35.
It's a withdrawal order, my lord.
whereby the tribunal had dismissed the application as withdrawn in light of the memo file, as well as order passed in review application dated 13/7/23, whereby the petition filed seeking review of the order to restore the matter on merits came to be rejected by the tribunal. Full stop. WP 202543 has been filed with identical reliefs.
Yes.
Against identical orders of the tribunal.
Yes.
And accordingly, both matters are taken up together and disposed of by the common order. This is the case of the petitioner that applications were filed before the tribunal seeking for issue of appropriate writ to quash the endorsements, refusing to accept the claim of the petitioners that they were entitled for relief of pay fixation under 41C Roman 4 of the KCSR rules. Full stop. The endorsement was to the effect that their pay was to be fixed in terms of 41C Roman 3 of KCSR at the minimum. Full stop. In the case of the applicants that their pay stood revised by virtue of the recommendation of the Seventh Pay Commission, and accordingly, the last pay taken was erroneous without noticing the revision under the Seventh Pay Commission. Full stop. Applications, however, came to be dismissed as withdrawn. And on further inquiry, counsel for the petitioner submits that the counsel on record under a mistaken notion that the endorsements were correct, had the legal position of entitlement in terms of Rule 47C4 of KCSR. Full stop. It is submitted that subsequently, when the matter was moved for being spoken to, tribunal has refused to take note of said prayer while directing review petition to be filed. Full stop. On review petition being and at annexure
Annexure C.
in both the writ petitions, a detailed review application had been filed in which it was stated in the grounds raised that at para Roman 3
and 4.
Roman 3 and 4, that similar cases of army personnel who had joined service under the state
Yes.
had been extended the benefit of 41C Roman 4, and order was passed in application 6548 and 6549 of 2020. And accordingly, the tribunal ought to reconsider and take up the matter on merits. Full stop. It is a case of the petitioners that while considering the review application, it must that the court could take note of any other sufficient reason. And in the present case, noticing that the withdrawal of the application was a mistaken notion by the council. After taking note of the order passed in an identical factual matrix as regards other employees, the orders passed by the KAT in other matters was a benefit that ought to have been extended to the petitioners, and accordingly, when the matter was not decided on merits, the tribunal ought to have reopened the proceedings by allowing the review petition and heard the application on merits. Next. The above narration of the facts by itself makes out a sufficient ground. It is clear that there is no adjudication on merits. The order, the applications came to be withdrawn in terms of submission of counsel for the petitioner on a mistaken understanding by the counsel on record. Such explanation, if taken note of, it would be clear that adjudication had not progressed in light of withdrawal. Noticing that in identical factual metrics, orders were passed by the tribunal as pointed out at para 3 and Roman 3 and Roman 4 of the review petition. It would meet the ends of justice if the tribunal were to apply its mind afresh and take note of the ground of other sufficient cause for any other sufficient reason, and relook into the matter. Next. It is apparent from the submission made and as noticed above that in the event matter was taken up on merits, perhaps the applicant would have succeeded. Taking note of the same, the order passed in the review has adopted a very technical and conservative approach. We find it necessary in light of the discussion made above to set aside the order and review and remit the matter back to the tribunal for reconsideration of the review applications in light of the observations made above. Accordingly, orders at Annexure
Annexure D, my lord.
Annexure B.
Annexure D.
D in both the matters.
Both the matters.
Annexure D, which are orders passed on the review application, are set aside and matter remitted to the tribunal for fresh consideration in light of the observations made. Yes. AGA accepts notice for respondents.
No, the respondents. All the 1, 2, 3, my lord. All the respondents.
Number 90. Amir Hamaz.
Yes.
My lord, please permit 1 week time.
What is there? Nothing is there.
I am proxy counsel.
When do you want it?
1 week time, 1 week.
Tuesday.
Lord.
Now anyhow you are working, no?
I'm working, Lord. And they need to, Lord, serve a copy on me. I'm a caveat.
Survey copy. Okay. Copy of the petition to be served on counsel for respondent number
4. Caveat 4.
Relist on Tuesday. There's nothing in the matter. Now it's a premature. The court holds it's premature. That's all what you can do. Till 26th they have service. Now where are you working?
Here one.
You know, you have to, they have reported. Okay, Tuesday. Yes, please.
Number 20, Ramachandra K.
Yes.
There was a directions by the single judge to consider the representation within 8 weeks from the date of receipt of order, my lord, which is not considered by the respondent number 1 willfully. The respondents install the electrical tower in the land of petitioner, my lord. Thereby is sustained
Who has to consider?
Respond number one. Just come.
Sure. Who has to consider?
Respond number one.
Notice to R1 for the present. Notice to the only R1.
Yes, respondents. They have installed the electrical tower in the land of the
Correct. How
complaint.
you will decide? Now, you are seeking for loss of those all civil suit ಹಾಕೊಂಡು ನೀವು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಬೇಕು ರೇಡಿಯೇಷನ್ ಅದೆಲ್ಲ ಮಾಡಿ ಹಾಗೆ ರಿಟ್ಟಲ್ಲಿ ಹೆಂಗೆ ಡಿಸೈಡ್ ಮಾಡಿ isn't it? Anyhow, notice to R1. Notice to R1 for the present, please. Release the matter on.
February.
Please.
Number 21, Arun Kumar Amaragundappa.
Lord, this contempt is directed against alleged disobedience of learned single judge order at page 17. Roman 3 is a direction issued to enter the name of my lord, the petitioner, including the respondent number, private respondent number 3 there in the writ petition. Though this order was communicated on 16/10/2024 itself, no steps have been taken.
The Tahsildar.
It is, my lord, in fact, court matters, it is a assistant commissioner who monitors. Of course, direction is issued in to the Tahsildar.
Let us see, let it go to the
Yes.
Tahsildar.
Yes.
So notice. To the accused number 2 for the present. AG accepts notice for R3 pro forma party. Relist the matter on. Yes.
Great.
Number 22, AM Biradar.
Yes.
Kindly
We
pass
seek-
on.
They seek some more time because of the matter pertaining to the land acquisition matter. MAP 2774 of 2021. It is a filed appeal by the claimant before the apex court. The apex court will be remanded to the first appellate, this honorable court to enhance the compensation. The compensation will be enhanced 1,72,630 rupees per acre in the year 1991 notification. 91 notification. Thereafter, the batches of the appeal in the lower Mullam area of claimant, they filed again a SLP before the apex court. They are also remanded to this honorable court to the reconsideration. Again will be enhanced. Now again will once again the KNNL, they filed a SLP contending that they are the beneficiary not made a party as well as quantum. All the batches of matter will be remitted to the and seizes the heard the matter. Meanwhile, the KNNL and the claimant, the advice to the counseling to settle the amicably, they are the matter will be going on this settlement. The government also come forward to some extent will be way up the interest. They will be ready to the matter will be again will be posted in the month of March. That is a
March.
ಯಾವ್ದು? Learner single judge in principal bench.
In some instructions you have, settlement ಆಗುತ್ತಂತೆ.
The KNL is not appeared. He is a government. KNL Sudarshan is appeared.
No, so it has to be adjourned or what?
It is just to adjourn. Meanwhile, if it is settled the matter, I will be move the court.
Let Sudarshan come.
I will be instruct.
Bring him. Pass.
Please.
Pass.
number 23, Hema L. Kulkarni, Sudhir Kulkarni for respondent.
Short accommodation, Millers. I for appeal. 1 week time, Millers, by.
Some settlement is possible.
We have given offer, my lord. I am representing wife. She is working in Mumbai in private service and she has got a small kid. She said, she come and stay there, try for the job. Let us stay together. Aki transfer agala Gulbarga ಬಂದಿರು ಅಂತಾರೆ. ಅಲ್ಲೇ ಬಂದಿರ್ಲಿ, ಅವ್ರ ಅಪ್ಪ ಮನೆ 6 ತಿಂಗಳು ಮನೆಯಲ್ಲಿ ಇರ್ಲಿ, ನೌಕರಿ ಟ್ರೈ ಮಾಡ್ಲಿ ಅಲ್ಲೇ, ಸಿಕ್ಕಳೆ ತಾ ಬೇರೆ ಮನೆ ಮಾಡಿ ಅಲ್ಲೇ ಇರ್ಬೋದು. ದಿಸ್ ಇಸ್ ದಿ ಅವರು ಬರ್ಲಿ ಇಲ್ಲೇ ಬರ್ಲಿ ಅಂತ.
ಅವರೇ ಇಲ್ಲಿ ಬರ್ಲಿ ಅಂತ ಇವ್ರ
ಇಲ್ಲಿ ಏನೋ ನೌಕರಿನೂ ಇಲ್ಲ ಅಂತಾನೆ, ಏನೂ ಇಲ್ಲ ಅಂತಾನೆ. ಸೊ
No.
the petition filed by avanದೆ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. He filed the divorce petition. Cruelty ground ಮೇಲೆ.
Husband is working in.
ಅವ ಏನೋ ಮುಂಚೆ ಎಲ್ಲೋ ಕೆಲಸ ನಿಲ್ ಅಂತ ಬರ್ದಾರೆ.
Earlier he is working, Millers, now.
ಕಾಸ್ಟ್ ನಲ್ಲಿ ನಿಲ್ ಅಂತ ಬರ್ದಾರೆ. ಒಳಗೆ ಪ್ಲೀಡಿಂಗ್ ನೋಡಿದ್ರೆ ನಾ ಕತಾರ್ನಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೆ. ಬಟ್ ಬಂದೆ ಕೋವಿಡ್ ಇತ್ತು ಅಂತ ಏನೋ ಹೇಳ್ತಾರೆ.
Before COVID, he is working at out of country, Millers.
Working?
The difficulty, wife difficulty is, ಆಕೆಗೆ ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಕೆಲಸ ಸಿಗಂಗಿಲ್ಲ ಏನು ಇಲ್ಲ.
Where is she working?
ಅಲ್ಲೆಲ್ಲೋ ಪ್ರೈವೇಟ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಮುಂಬೈದಲ್ಲಿ. ಮುಂಬೈ. Her parents are residing in Mumbai. Mumbai. So let he come and stay with them, still 6-8 months, try for the job. ಆದ್ಮೇಲೆ ತಮ್ಮ ಮನೆ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲೇ ಇರ್ಬೋದು. ಆಕೆಗೂ ಬರ್ತಾ ಇವನು ಸ್ವಲ್ಪ ಏನಾದ್ರು ಸಂಸಾರ ಮಾಡ್ಬೋದು ಅಂತ ದಿಸ್ ಇಸ್ ದಿ.
ಇವ್ರ ತಂದೆ ತಾಯಿ ಬಿಟ್ಟು ಹೆಂಗ್ ಹೋಗ್ಬೇಕಂತ ಇವ್ರು ಇಲ್ಲೇ ಕೆಲಸ ಮಾಡ್ತಾರಂತ ಹೇಳಿ ಇವ್ರು.
List on. See what is to be done.
Please.
In case not possible, then we'll see what is to be done.
Please. Next week
List on date.
Please.
ಯಾವಾಗ?
30. Number 25, Ganesh Kalaburagi.
Also.
Number 26, Ravindra Reddy. Twenty-six, Ravindra Reddy.
ಇನ್ನೊಂದು ಇತ್ತಲ್ಲ ಇದು ತೇಜ್ ಪ್ರಕಾಶ್ ಪಾಠಕ್ ಇನ್ನೊಂದು ಇತ್ತಲ್ಲ ಯಾವ್ದೋ ಒಂದು ಹಾಲಲ್ಲಿ ಇದು ಒಂದು ಮ್ಯಾಟ್ರಿಕ್ಸ್ 23rd ಇದೆ ಅದು. ಲಿಸ್ಟ್ ಆನ್ 23rd. Twenty-third, ನೋಡ. Yes.
Till number 27, GS Birad.
Defendant's appeal, my lord.
Yes, Birada.
My lord, copy not served in.
This is a dependent's appeal, my copy has been given, sir. Not served on almost Moga Sudhakar Rome ಕೊಟ್ಟಿದ್ದು.
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳೋರು.
ಇಲ್ಲ ಆಯ್ತು, ಇನ್ನೂ ಒಂದು ಕೊಟ್ಬಿಡಿ. ಇನ್ನೂ ಒಂದು ಕೊಟ್ಬಿಡಿ.
ಆಯ್ತು.
We'll have it next week.
ಇದರಲ್ಲಿ ಈಗ FDP ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಹಾ.
So they are proceeding. Let the final decree not be drawn.
My lord.
Let
already
the
FDP
proceedings
is
go on.
Stayed, my lord. Already FDP is stayed.
Stayed.
Yes, ma'am.
Check
In WP number, so and so, in WP number, my lord.
ಅಲ್ಲ ಇಲ್ಲಿ RFA ದಾಗ ಸ್ಟೇ ಆಗಿದ್ದೇನ್ರಿ?
WP ದಾಗ stay ಆಗ್ಯದ, same.
ಅಲ್ಲ ಅದು ಅಲ್ಲ RFA ದಾಗ ಸ್ಟೇ ಆಗ್ಬೇಕಲ್ಲ.
RFA ದಾಗ ಆಗಿಲ್ಲ. In WP it is already
WP ದಾಗ ಏನಾಗಿದೆ some other one
ಅದು ಕೊಡಿ ಅದು. ಅದು ಕೊಡಿ, ಅದು ಕೊಡಿ. We know drawing up a final decree. Relist the matter. Now we have to hear it on merits. It has to be admitted.
ಅಡ್ಮಿಟ್ ಆಗ್ಬೇಕು ಅಷ್ಟೇ. RFA ಇದೆ.
Admit ಮಾಡೋಣ.
ಅಡ್ಮಿಟ್ ಮಾಡಿಸಿ.
We'll have to hear it on merits. Appeal is admitted. Paper book to be filed within 6 weeks.
4 weeks.
Within 4 weeks. Yes,
Drawing of final decree be stayed.
yes.
Much.
Meanwhile, copy ಕೊಡ್ತಾರೆ, copy ಕೊಡ್ತಾರೆ.
Copies ಕೊಡಿ.
ನಾ ಕೊಡ್ತೀನಿ. I'll positively give it.
PCR to be summoned.
It may be also recorded. I'll positively hand it.
Copies of,
Copies ಕೊಡ್ತೀನಿ.
copies of appeal memo to be served on counsel for the respondent.
Much.
Yes.
29. Srinivas Shamsundar Rao, BK Hiremat for Arbor.
Most have been Ravindra Reddy, Vinod Sethupathi, again point. Yes.
Small matter, my lord. Question of jurisdiction, the suit is to be tried whether by the family court or civil judge court. This is the point. Last state, my lord.
Correct.
Lord, suit is of 2007. Initially, suit was filed, my lord, before family court.
No, why, some authorities we had asked.
Yeah, yes, sir.
BK Hiremat is there.
BK Hiremat.
Good.
And in this suit, in this matter also, my lord, negative relief was sought. That she is not the wife.
Paragraph.
Paragraph, my lord, 1 and 2, my lord, I read. The appellant instituted a civil suit before the family court, Ambikapur, Chhattisgarh, seeking a declaration to the effect that respondent is not legally married wife. In the present suit also the same question is involved. By judgment dated 28/12/2013, the civil suit was decreed, declaring that the respondent was not appellant legally married wife. Para 2, sir. The respondent being aggrieved, moved the High Court of Chhattisgarh. The High Court, as per the impugned order dated 14/1/2015, allowed the appeal, holding that the family court lacked jurisdiction to deal with the matter. According to the High Court, a negative declaration was outside the jurisdiction of the family court. Then, my lord, sections 7, 8, and 20 have been elaborately discussed. Section 7, so far B is concerned, my lord. After establishment of the family court, even they are produced in the order itself, para 3 nulli, sir. Para 4 nulli. B is important, my lord. Be deemed for the purpose of exercising such jurisdiction or such law to be a district court, or as the case may be, such subordinate civil court for the area to which the jurisdiction of the family court extends.
So you're reading?
Para 4, sir.
Para 4.
4. Section 7 has been reproduced here.
Correct.
So I am referring to B, sir. Subclause B. That is applicable. Be deemed for the purpose of exercising such jurisdiction or such law to be a district court, or as the case may be, such a subordinate civil court for the area to which the jurisdiction of the family court extends.
Explanationally D.
How, sir?
Done. explanation ಅಲ್ಲಿ B and D.
ಹೌದು ಸರ್.
Huh? Statement B, suit or proceeding for declaration as to validity of a marriage or as to the matrimonial status of any person. And then D, a suit or proceeding for order of, no, B. So B, explanation B. Huh?
Please, sir.
Then what does it,
Then section 8, my lord. Come to section 8, para 5, sir. Para 5 of the judgment, section 8. Section 8 of the Act deals with the exclusion of jurisdiction, which reads as follows. Exclusion of jurisdiction of the pending proceedings.
Now go to para 7.
Please, sir.
Para 7 only.
That is para 7 is the most important factor, my lord.
Read it.
Under section 7(1) explanation B, a suit or a proceeding for a declaration as to the validity of both marriages and matrimonial status of persons is within the exclusive jurisdiction of the family court. Since section 8, all those jurisdictions covered under section 7 are excluded from the purview of jurisdiction.
Correct, it's covered. Now you bring Hiremat, we'll finish it up.
Pardon?
Hiremat idare andre.
Last time, sir, last time, file kottaranತ what submission he made, my lord. I remember last date he made a submission. He has already handed over the file.
Hello, once phone ಮಾಡಿ ಇದ್ರೆ
Please.
You come, we'll close it.
Please, sir.
It's squarely covered.
Please, sir. He's there, my lord.
Huh?
He's there, my lord. I will ask him.
Kursi.
Please.
He's always very pleasant.
Because the parties are litigating, my lord, from 2007.
No, correct.
Suit is of 2007. They are going here and there.
No, we agree with you.
Ultimately, they are not getting justice.
Correct.
Number 27, Ravindra, 26, Ravindra Reddy.
Appearing for the respondent, private respondents, no? He is saying that, my lord, one more connected matter is on the 27th or 28th.
27th.
28th. Date.
28th. That Halali is matter.
So Amrish Roja and Ravindra Reddy is same matter, same university, my lord.
Same kind.
Posts are different.
But changing the rules of the
Yes,
game.
yes. Your lordship has directed them to file a synopsis. This is
So
also.
relist on 28th.
Yes.
28th. 28th.
Yes.
There is one more matter of Mr. Halali. You also find out.
Yes.
We'll have all the three on the same day.
Please. Yes.
We'll have it on 28th.
Yes.
28th. Have you gone through that Tej Prakash?
Yes.
Which para, etc.
Yes. Our contention is it's not applicable to
Not
present case. Not their contention is it's applicable.
Let us.
Squarely applies as per.
Let us.
Yes.
Yes.
Number 31, Mahantesh Patil.
Yes.
I'm
kindly
I'm
pass
appearing
on.
for respond number 4.
Which 31.
31, kindly pass over, my lord. Sorry. Kindly pass over.
What is the matter?
My lord, here, my lord, petitioner, my lord, and myself, my lord, we are appointed, my lord, as bill collector. My lord, for, my lord, selection to the post of, my lord, secretary grade 2 and equivalent to second divisional account assistant in the panchayat. My lord, it is with regard to, my lord, both belong to the same category, my lord, and claiming for rural. My lord, now KAT has, my lord, we had, my lord, approached KAT. My lord, KAT had allowed, my lord, application with regard to, my lord, insofar as, my lord, it was my contention, my lord, that, my lord, he, my lord, has not studied, my lord, in the rural area from 8th standard to 10th standard. And, my lord, KAT, my lord, has allowed our application. And thereafter, my lord, in the present writ petition, my lord, there is an interim order. By, my lord, the interim order has been given effect to, and, my lord, now he has been given appointment order. And my lord,
You are saying that he was not qualified.
yes, my lord, he is, my lord,
He had not studied in a rural.
rural area, my lord, for the entire 10 years, from 8th standard to 10th standard. And my lord, that is the, my lord, crux of the matter.
KAT has accepted your.
KAT has accepted our contention. And my lord, it is with regard to, my lord,
You had challenged his appointment before the KAT?
yes,
Shortly thereafter or?
yes, my lord, immediately thereafter, immediately. Immediately, my lord, and my lord, thereafter, my lord, it was allowed. And even, my lord, I was given that, my lord, and thereafter, my lord, after this interim order, I was reverted. And now, my lord, I am working in the, my lord, the lower post. Now, my lord, he has been given promotion by virtue of interim order.
Pass.
Please.
Seat number 32, Mahesh Patil.
My lord. It's matter, my lord. The petitioner,
Yeah.
my lord, is working, my lord, as inspector, police inspector, my lord, in Karnataka State Industrial Security Force. In, my lord, in the High Court here, my lord, at Kalaburagi. My lord, my lord, the next, my lord, it is a feeder cadre, my lord, for the promotion to the cadre of assistant commandant. My lord, this police inspector, my lord, is a feeder cadre, my lord, to the.
No, but his name is also police party.
Please.
His name.
His name is also police party, yes. And my lord, the feeder, it is a feeder cadre, my lord, to the post, my lord, for the promotion to the post of assistant commandant. Now, my lord, in terms of, my lord, the guidelines laid under my lord, Article 371J, my lord, even, my lord, in cases of, my lord, deputation, my lord, the reservation, my lord, under Article 371J, my lord, has to be given effect to, even in cases of deputation also. There is a circular, my lord, which is, it is not disputed. The circular, my lord, is at page 40, annexure A3.
Which is circular?
My lord, page page 40, annexure A3. Clause 9, clause 6, my lord, sorry, page 41, clause 6. Clause 6. ನಿಯೋಜನೆ ಮೇಲೆ ತುಂಬ ಹುದ್ದೆಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಿಗದಿಪಡಿಸಲಾದ ಮೀಸಲಾತಿ ಹುದ್ದೆಗಳನ್ನು ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಪ್ರದೇಶ ಅರ್ಹ ಸ್ಥಳೀಯ ನೌಕರರಿಂದಲೇ ತುಂಬಬೇಕಾಗಿದ್ದು, ನಿಯೋಜನೆ ನೀಡುವ ಸಂಸ್ಥೆಯು ನಿಯೋಜನೆಗೊಳ್ಳುವ ನೌಕರರು ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಪ್ರದೇಶದ ಸ್ಥಳೀಯ ವ್ಯಕ್ತಿಗಳೆಂದು ಖಾತ್ರಿಪಡಿಸಿಕೊಂಡು ನಂತರವೇ ನಿಯೋಜನೆ ಆದೇಶ ಹೊರಡಿಸತಕ್ಕದ್ದು. So, this is not disputed by the respondents.
So this is for deputation.
Even in the cases of deputation, my lord, they are required to, my lord, implement Article 371J, and a person, my lord, belonging to Hyderabad, Karnataka region, my lord, has to be taken into consideration by from the overall cadre strength, my lord, of the KK region. And now, my lord, accordingly, my lord, now they, my lord, issued a notification which is at page 51, annexure A7. They notified, my lord, 4 posts.
For what?
My lord, for reservation, my lord, in the cadre of assistant commandants. Now, my lord, I am working, my lord, in the cadre of police inspector. That is at page 51, annexure A7. Lordship may kindly see, my lord, at, my lord, column number 4.
Where are the rules to show the feeder cadre, etc.?
My lord, that is page. My lord, my lord, I'm just coming to that, my lord. Okay. And now, my lord, these are the, my lord, the 4 posts are notified, my lord, insofar as assistant commands are concerned in HK region. Now, my lord,
this has to be filled from promotion.
My lord, this has to be filled from by promotion from the cadre of police inspector.
Police inspector to assistant commandant.
Assistant commandant. Assistant commandant is equivalent, my lord, post of DYSP. And now, my lord, in the meanwhile, what had happened, my lord? My case, along with my senior colleagues.
What is the reservation?
Please.
Hyderabad, Karnataka.
Hyderabad, Karnataka. That is
correct. Now what is the case now?
Now, my lord, here, my lord, while, my lord, notifying these 4 posts, my lord, they have not taken into consideration one vacancy of assistant commandant, my lord, which is existing in Bidar Airport, My lord, this is a force, my lord, wherein, my lord, they provide, my lord, their, my lord, security to vital, my lord, installations like dams, my lord, and various other, my lord, like airports, my lord, the High Court, and, my lord, the prisons.
What now? 4 posts are reserved.
4 posts are reserved.
So
Now, my
what
lord,
is-
here, my lord, 5 posts have to be reserved. Instead, my lord, they have notified only 4 posts.
How do you say?
Yes, my lord. Lordship, may kindly, my lord, come to page. My lord, page 43, annexure A4. My lord, this is the first initial communication, my lord, when the Bidar Airport, my lord, came into, my lord, existence, before the Bidar Airport came into existence. My lord, there was a communication, my lord, by the Bureau of Civil Aviation Security, my lord, wherein, my lord, they had laid, my lord, certain standards, and, my lord, they had approved, my lord, the strength of, my lord, 63 in, my lord, in various different ranks, my lord, wherein, my lord, they will have to, my lord, post in Bidar. So in terms of, my lord, this communication.
No, but where do you get this extra 1 post?
My lord, I'm coming from the, my lord, lordship, may give me some 3 minutes time. My lord. Page 47, my lord. Page 47.
Yes.
My lord, page 47. My lord, serial number 1, supervisory officers. This is, my lord, the sanctions, my lord, the strength, my lord, supervisory officers. Adralli, last column, DYSP level officer antide. My lord, last in serial number 1. So, my lord, 1 DYSP level officer, my lord, that is equivalent to assistant commandant. My lord, they, my lord, are required to, my lord, posted Bidar. Accordingly, my lord, they, my lord, posted, my lord, DYSP level, my lord, officers, my lord, at Bidar. And, my lord, still they are working. Annexure A6. Annexure A6. Page, my lord, this is one such, my lord, deployment. Page, annexure A6, page 49, serial number 3. Kalaburagi ವಿಮಾನ ನಿಲ್ದಾಣ ಮತ್ತು ಬೀದರ್ ವಿಮಾನ ನಿಲ್ದಾಣ.
And then what happened?
Then, my lord, suitable deployments were made, my lord, from time to time, even till today, my lord, 1 officer, my lord, of assistant commandant, my lord, is working, my lord, at Bidar. And, my lord, and it is also not disputed, my lord, by them as to, my lord, they have provided, my lord, that information. Even, my lord, in the, my lord, the question, my lord, raised before the, my lord, the Vidhan Parishad, at page 78, annexure C. Annexure C, page 78, for a moment. This is the strength, my lord, provided by the government, my lord, at, my lord, at column serial number 8, my lord, serial number 8, my lord, Bidar Vimana Nildana, my lord, in respect of all cadres, my lord, the strength, my lord, has been provided. Insofar as, my lord, the assistant commandant, 1 post is shown, my lord, at Bidar, AC, 1 anta ide, AC column.
Column AC.
AC ante, assistant commandant.
1.
one ide. So, my lord, even till today, my lord, it is, my lord, and lordship may kindly come to page 81 also, page 81, which is clear, my lord, by the records of the very own respondents, page 81. My lord, serial number 42. There, my lord, airport Bidar, my lord, and Your lordship may kindly, my lord, also. This is with regard to, my lord, the PIs also at page 82. So, my lord, it is not disputed, my lord, that the one post, my lord, of working, my lord, of assistant command, my lord, is working, my lord, in Bidar airport also. My lord, now, my lord, in terms of, my lord, the guidelines issued under Article 371J, even, my lord, in, my lord, even the cases of deployment, my lord, they, my lord, need to, my lord, the reserve post, my lord, for the Hyderabad Karnataka region. By way of notification, my lord, only 4 posts are, my lord, reserved. Now, my lord, the department, my lord, took up, my lord, my lord, the promotion, my lord, the DPC. Lordship may kindly see. Wherein?
No, now state your
My lord,
instructions.
my lord, here, I take instructions insofar as, my lord, arguments of my friend, my lord. Para 9 is of the KAT order is answer, my lord. It is the state government which was issued annexure A7, wherein the posts are reserved. And insofar as Bidar airport, there is admittedly 1 post is, only 4 posts are reserved and 4 fill up, or 4 posts are filled up, my lord. Now he cannot ask the government to take for his name for the promotion. Those directions cannot be issued. It's a policy decision. The government, as per the annexure 7, the posts are reserved and it was given. For therefore, my lord, this reason, the application is
Para 7,
9,
page.
page 75. Since the Bidar airport is very old, my lord, there is a Air Force, my lord, it is not a civilization. it is
Civil-
airport. For
civilian
that
airport.
reason, my lord, posts are, my lord, sanctioned to the Bidar. Insofar as Kalaburagi is concerned, only, my lord, it is a civil aviation purpose, my lord. ಇರ್ಲಿಕ್ಕಿಲ್ಲ ಆ ಪೋಸ್ಟ್ಗಳು DYSP ಮತ್ತೆ ಇದ್ರದ್ದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಾಂಡೆಂಟ್. ಬಟ್ ಅದಕ್ಕೋಸ್ಕರ ಇಲ್ಲಿನೂ ಒಂದು ಗುಲ್ಬರ್ಗಕ್ಕೂ ಶಾಂಕ್ಷನ್ ಮಾಡಿ ಕೊಡ್ರಿ ಅಂತಂದು ಇವ್ರು ಕ್ಲೇಮ್ ಮಾಡಕ್ ಬರಲ್ಲ.
I'm not claiming that.
But that is, those lists are, my lord, brought to your lordship's notice. Then wherein it Kalaburagi is concerned, 0. Sanction ಆಗಿಲ್ಲ ಪೋಸ್ಟ್ಗಳು. 4 ಆಗಿದೆ, 4 ಕೊಟ್ಟಿದ್ದಾರೆ. Admittedly, his name is at serial number 5.
ಇಲ್ಲ ಕಲಬುರ್ಗಿಗೂ ಒಂದಿದೆ, ಕಲಬುರ್ಗಿಗೂ ಒಂದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಾಂಡ್.
I will take instructions. These are the facts.
So let him complete, we'll see on the next day.
Please, my lord.
But prima facie annexure A7, there ends the matter.
Yes, my lord.
So firstly, secondly, promotion is only a matter of consideration, no vested right.
Yes, my lord, absolutely, yes.
So you are in the queue. So
Yes.
next, as soon as
Yes, my lord. Yes, my lord. When he is
Maybe-
eligible, he will get.
anybody is elevated, you come in the zone.
Yes, my lord, I do understand, my lord, here I am not seeking, my lord, that I'll have to be, my lord, promoted to that post. What I am seeking, my lord, that one post, my lord, they'll have to, my lord, take into consideration and thereafter consider my case for promotion. It's not that, my lord, once, my lord, my lord, only by, my lord, if I am eligible, my lord, automatically, my lord, I will be, my lord, promoted. That is a different, only for the sake of consideration of promotion, not, my lord, I'm.
Okay, that one post you find out, you get
Please.
your complete your instructions. Relist the matter on. Good. 29th.
Please, my lord.
And there is an, my lord, interim order, wherein, my lord, it is directed, my lord, not to precipitate and, my lord, and not to post anyone, my lord, there is an interim order.
Not to post anyone where?
My lord, there is an interim order, my lord, issued, not to precipitate and not to appoint anyone, my lord, in either airport. That was the, my lord, the interim order issued.
Let us see. You complete it, we'll see. It's an administrative issue, it must not be kept pending,
Please, my lord.
either way. Yes. ಹೈಕೋರ್ಟಲ್ಲಿ ಒಬ್ರು ಇರ್ಬೇಕು ಅಂತ ಹೈಕೋರ್ಟಲ್ಲಿ ಒಬ್ರು ಇರ್ಬೇಕು ಅಂತ ಅವ್ರು ಹೇಳ್ತೀವಿ. ಎಸ್. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್. Yeah. Okay.
29.
My brother is there. not-
It appears to be,
ಇಲ್ಲ ಸರ್ ಫೋನ್ ಮಾಡಿ ಕಳ್ಸನ ನೀವು ಸಾಹೇಬ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡೋದು ನಾನೇ ಹೇಳಿ ಸರ್ ಒಂದು ಸಬ್ಮಿಷನ್ ಸರ್ ಇದ್ರೊಳಗೆ ಫೋನ್ ಮಾಡಿ ಸರ್ ರಿಸೀವ್ ಮಾಡಿಲ್ಲ ಸರ್ ಸೊ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಇಟ್ರೆ ನಾನು
what we are
ಇಲ್ಲ
saying,
ಕರೆಕ್ಟ್
it appears to be covered by the apex court.
ಕರೆಕ್ಟ್ ಇಲ್ಲ ಒಪ್ಪದೆ ಸರ್
Where
ನಾನೇನು ಇಲ್ಲ ಅಂತ ಅನ್ನಲ್ಲ ಬಟ್ ತೋರಿಸಿದಾರೆ ಮಂಡೇ ಇಟ್ಬಿಡಿ ಸರ್ ಅದಾಗ ಪಾರ್ಟಿ ಫೋನ್ ಮಾಡಿ ಏನಾರು ಕನ್ಕ್ಲೂಷನ್ ಬಂದು
ಹ್ಮ್.
ಯಾಕಂದ್ರೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟಿಗೆ ಹೋರ ಅವ್ರು ಇನ್ನೊಬ್ರು ಜಲ್ದೇ ಸರ್ ಅಂತ ಇದಾರೆ ಅವ್ರಿಗೆ ಇಂಟಿಮೇಷನ್ ಮಾಡಿ ಆಟೋಮೆಟಿಕ್ ಬಂದು
Right.
ಅವ್ರಿಗೆ ಪ್ಲೀಸ್
we'll list the matter in the orders list.
27
Orders list. Orders list on Monday.
ಎಸ್ ಮ್ಯಾಮ್
Third counsel for the appellant submits that issue is covered by the judgment of the apex court in Balram Yadav versus Phul Manya Yadav in civil appeal number 4500 of 2016
Please.
for say of the respondent.
Yes.
Yes.
Oblige.
ನಾವು ಅವ್ರಿಗೆ ಹೇಳ್ತಿದ್ವಿ ಹಿರೇಮಠ್ ಇಸ್ ಆಲ್ವೇಸ್ ಪ್ಲೆಸೆಂಟ್.
ಇಲ್ಲ ಇಲ್ಲ ಸರ್ ಅದ್ ಒಂದ್ ಲಾಸ್ಟ್ ಇದು ಸರ್ CRP ಇತ್ತು ಇಬ್ರು ಕೆಮಿಕಲ್ ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಹೋಗ್ಬೇಕಂತ ಮಾಡಿದೆ ಹೆಣ್ಮಸ
No, even as, sir, there is dispute between husband and wife. We are ready to pay 20 lakhs rupees. Irrespective of the fact, my lord. She contends on 10/10/1987, she married with me. But we have produced records, my lord. In 2001, with one Bhimraya, my lord, she was married. She obtained interim order for maintenance in 125 proceedings. And apart from that, 13B petition is filed, consent divorce, in 2001. When she takes divorce with the earlier husband in 2001,
Let us see. We'll resolve the legal issue.
yes,
You try to settle it outside.
because this issue will not be resolved, sir, because
Huh?
they are fighting since long, my lord, for this.
ಅಲ್ಲ, ಅದಕ್ಕೆ legal issue will resolve.
Please, please.
Yes. ಮಾಡ್ಬಿಡುದು.
Previous matter, my lord, it was passed over.
Which one? 31.
Yes, yes, ma'am.
Huh.
Council was not.
Mahantesh versus
Now he has-
Mahesh.
Now yes.
What is the matter?
My lord, it's the. Regard to the, my lord, the
So
rural.
regarding, lords, the present petitioner herein, he claimed, my lord, sir, he was given a promotion under the scheduled caste rural.
Yeah.
As a panchayat secretary, grade 2, my lord.
ಏನು ಕ್ಯಾಶ್ ಸರ್ಟಿಫಿಕೇಟ್ ರಾಂಗ್ ಅದ ಏನು ಇದು ಅದೇ ಇಶ್ಯೂ ಅಲ್ಲ ಹಾಕೊಂಡು ನೀವು ಓದಿಲ್ಲ ಅಂತಾರೆ
Yes.
Not see. The petitioner herein appointed, my lords, as a bill collector in the Gram Panchayat on 5/10/2006, my lords.
510.
2006. Then, my lords, the respond number 4, who was appointed, my lords, on 24/4/2007 as a bill collector, my lords.
Petitioner was appointed on 510.
5/10/2006. Respond number 4 appointed on 24/4/2007, my lords. Then, my lords, on 19/9/2022, my lords,
No, this is a matter relating to seniority.
seniority. Not seniority, my lords. My claim for reservation, the promotion list was published, my lords, wherein I have been included, my lords, under the scheduled caste rural reservation. He filed an objection, respond number 4, alleging that, my lords, my certificate, I am not eligible to claim as a rural, and my certificate cannot be issued. I am not cannot be given as a promotion under the SC rural. This is what in nutshell, my lords, he says. The certificate, once in form number 2, under the regular rules, my lords, were issued, only that certificate has to be questioned before the appropriate forum to set aside. That is not been done. Once he has filed the objections before the authority, my lords, the authorities have conducted the proceedings, and to verify that, his main allegation is that to say that, my lords, I am not eligible for claiming rural reservation is that, my lords, from 10/4/1991 to my lords, 3/6/1988 to 10/4/1991, I studied 8th standard to 10th standard.
Correct. Your contention is that the authority cannot go beyond the certificate.
Yes, my lords.
If at all there is any grievance.
Then that certificate has to be set aside and the validity has to be tested. Because it's a.
There is a procedure.
How?
Huh?
How?
For setting it
How?
aside. Under the.
Because it's a reservation. It will give certain benefits to the candidates, and it violates civil rights of others also. Because once I have taken the benefit under any reservation by issuing a certificate, unless it is set aside by proper following the procedure.
No, that is issued under what act?
There are several circulars and procedures are there.
What do you say on the preliminary submission? Please, the preliminary submission that we can't go beyond the certificate. Just as caste certificate. You'll have to go and challenge it. You can't raise a collateral attack in other proceedings. That is the legal position is what is.
My lord, when my lord, they have my lord, produced my lord, to the my lord, the recruitment authority. My lord, the recruitment authority, my lord, have my lord, they will my lord, test the my lord, the genuineness my lord, of this document. And my lord, they my lord, they are required to my lord, verify as to my lord, whether my lord, either one of us my lord, whether we have my lord, really studied in the because they are providing my lord.
Isn't the certificate conclusive of that? Now suppose you are aggrieved, then you have to challenge it is what he's saying under the act or provision. You can't raise a challenge to the certificate once it is issued, as long as it is not revoked.
My lord, here, my lord, it is produced, my lord, before the recruiting authority.
Correct, but whether the authority can go beyond that certificate is a question.
My lord, they can very well, my lord.
Authority have upheld my eligibility.
No, that's okay. But I'm saying whether the authority can go beyond the certificate.
My lord, they can, my lord, very well, because my lord, they are the employer.
So that on the legal position, you get some authority. Because in caste certificate, normally, we say you go under the
provisions of
hierarchy and challenge it. We will not, we cannot go, there are judgments to that effect. On this point, you clarify and you come back next.
My lord, now, my lord, they have come up, my lord, with this contention, my lord, now, my lord, for the first time. My lord, now, before, my lord, and my lord, the KT, my lord, has allowed our application. My lord, if they could, my lord, say, my lord, that the validity of the, my lord, the certificate, my lord, has to be challenged first. My lord, then, my lord,
you give whatever legal authority on that point.
When I raise that contention before.
Correct, you get a legal authority, let us.
And even that also, not even that is negated. The law on the point that this is covered by the 2-3 judgments of this honorable court, wherein division bench has held that what is the requirement to get a rural certificate is that once the population, as per the circular 2000, my lord,
if they chose to argue,
if the other side, even if we will verify it first ground.
That's we now. Why should we enter into the merits? If a certificate is given by a competent authority, unless it is challenged, prima facie, we don't want to enter into whether you are eligible, etc.
That is what this court.
Correct, but you give an authority on the point.
I will give it. In one of the judgments, that issue has that aspect has been considered, and the court, this court held that, my lords, again and again during his service career, it can't be re-verified.
You produce it.
I will file it with along with this
next week. And
And who has to issue, what is the procedure also you have to point out. Release the matter, date.
Next week, any date,
29
please.
But I request 30th,
on 30th.
but interior order may kindly be extended.
Interim order in operations extended to the next day.
Dictating judgment, say number 33, Santosh Kumar B. Biraj.
Passed over yesterday.
Serial number 15, Lords.
Huh.
It's an appeal. There's a delay of 200 days in that filing appeal.
Huh.
So if notice is order, I would take out notice on the respondents.
Issue notice on
Pass
IA,
over.
IA as well as main.
Yes,
PCR to be summoned forthwith.
bless.
Yes.
These four appeals by the convicted accused number 1 to 5 are directed against the judgment of conviction and order of sentence passed in SC number 108 of 2014 dated 31/5/2017 by the Court of Third Additional Session Judge Vijaypura, wherein the learned session judge convicted the appellant/accused for the offenses punishable under sections 143, 147, 148, 302, 307, 201, and 120B, Red V section 149 of IPC, and sentenced them to undergo rigorous imprisonment for a period of 4 years and to pay a fine of rupees 20,000. In default of payment of fine, the accused shall further be sentenced to undergo rigorous imprisonment for a period of 1 month for the offense punishable under section 143 of IPC. Further, further, the accused are sentenced to undergo rigorous imprisonment for a period of 1 year and to pay a fine of rupees 20,000 default of payment of fine, they shall further undergo rigorous imprisonment for a period of 2 months for the offence punishable under section 147 of IPC. Full stop. The accused further directed to undergo rigorous imprisonment for a period of 2 years and to pay a fine of rupees 20,000. In default of payment of fine, they shall undergo rigorous imprisonment for a period of 3 months for the offence punishable under section 148 of IPC. Full stop. They also directed to undergo imprisonment for a period of 5 years and to pay a fine of rupees 50,000. In default of payment of fine, directed to undergo rigorous imprisonment for a period of 1 year for the offence punishable under section 302 of IPC. The accused directed to undergo rigorous imprisonment for a period of 4 years and to pay a fine of rupees 30,000. In default of payment of fine, they shall undergo rigorous imprisonment for a period of 4 months for the offence punishable under section 307 of IPC. They directed to undergo rigorous imprisonment for a period of 2 years and to pay a fine of rupees 20,000. In default of payment of fine, further directed to undergo rigorous imprisonment for a period of 1 month for the offence punishable under section 201 of IPC. The accused also directed to undergo rigorous imprisonment for a period of 7 years and to pay a fine of rupees 20,000. In default of payment of fine, they shall undergo rigorous imprisonment for a period of 3 months for the offence punishable under section 120B of 120B read with the 149 of IPC. The full stop. It is also directed that the sentence passed against the accused shall run concurrently. Full stop. ಬೇಕಿದ್ರೆ ಕೂತ್ಕೊಳ್ಳಿ. The next one, the abridged facts of the case, prosecution case are as follows. The complainant, PW1, Sri Tamanna, is the son of deceased Basappa and Rangava. The mother of Rangava, that is Nagava, wife of Hanumantappa Kumatagi, had no sons. Full stop. The deceased Rangava and her sister Bhimava are the only daughters to their mother Nagava. Full stop. Since the father of Rangava, that is Hanumanta Kumatagi, did not have any male issues through his first wife, he married one Nagava of Kalaburagi village, and due to the said wedlock, 4 sons, namely Mallappa, Paramananda, Malappa, Paramananda, Mureppa, who are none other than accused bracket, who are none other than accused number 1, 2, 3 in the present appeal, were born. Full stop. The 4 sons, 3 sons, 4. The mother of deceased Rangava, namely Nagava, before her demise, gave 9 acres of land to deceased Rangava and her sister Bhimava equally, full stop. Thereafter, the father of deceased Rangava and Bhimava, that is Hanumanta Kamatagi, along with the son through his second wife, started claiming share in the said 9 acres of land, full stop. Owing to the same, the deceased and Bhimava approached the civil court and succeeded, full stop. Further, the appeals before the district court and high court, this court did not, high court did not yield.
Yes.
Correct, huh?
Yes.
Did not yield any positive results to Hanumanta and his three sons. Full stop.
They were not party to only that Hanumanta was party.
Positive results to Hanumanta and his 4 sons. So any Hanumanta is the son. As the father.
Hanumanta.
Yes.
Because
Hanumanta anta.
please.
That is the father of accused number 1, 2, 3. Hanumanta, father
Please.
of accused number 1, 2, 3. Full stop. On account of this issue, Hanumanta and his 3 sons were nourishing ill will against Rangava. Full stop. Later, Hanumanta passed away. The complainant's elder sister, namely Dyavamma, alias Lakshmi,
Yes.
was being given in marriage to one Basappa, that is son of Amog Kumutagi, Amog Kumutagi of Hanumaneri of Badami Taluk. Full stop. The accused number 4, Krishnappa, was not in good terms with the complainant and his parents. That is the deceased.
Yes.
In connection with some property matter pertaining to the family of this said Dyavamma. Therefore, the accused number 4 had extended his support to accused number 1 to 3 against complainant's family.
Yes.
Full stop. Full stop. Against this backdrop, on 5/1/2014, Rangava and Basappa, along with their grandchildren, Rangava and Basappa, once again bracketally deceased, along with their grandchildren, Kalmesh and Pooja visited the house of Dyavamma at Hanumaneri village on a motorcycle bearing registration number KA28U 4608 and on 7/1/2014, while they were returning to their village on the said motorcycle, the accused number 1 along with the accused number 2 and 4 were in a cruiser jeep bearing registration number KA23/N 1758, and the accused number 3 and 5 were on TVS Star City motorcycle, followed and dashed the motorcycle of Basappa near Nandi International School, and eventually they fell on the ground. Full stop. Further, the accused persons got out of their vehicles and assaulted Basappa and Rangava with the club, iron rod and lead ball. Full stop. Further, the accused number 5 caught hold of deceased Basappa's legs, and accused number 2 drove the cruiser jeep on the head of Basappa and thereby murdered Basappa, thereby committed the murder of Basappa and Rangavu. Full stop. Further, the accused persons also attempted to commit the murder of Kalmesh and Pooja. Full stop. However, they managed to flee from the spot, full stop. Further, the accused persons with an intention to destroy the evidence of their act, took the jeep bearing registration number KA23/N1758 away from the spot and instead parked one Mahindra jeep bearing registration number KA28/A7173.
Mahindra Max.
Mahindra Max, sorry.
Yes.
Mahindra Max anta. 28/A7173 on the spot to make it appear as if said Basappa and Rangava died in road accident. Etc. Full stop. Next one. Subsequently, the grandson of deceased Basappa and Rangava, Kalmesh, that is PW, examined as PW6, called his father PW1 Tamanna.
The father is a paternal uncle.
His paternal uncle.
Yes.
Paternal uncle Tamanna.
Tamanna. PW1.
Paternal uncle Tamanna. Tamanna through mobile phone and narrated the incident. Full stop. Hence, PW1 rushed to the spot and shifted PW6 to the hospital and thereafter lodged a complaint before the respondent police against the accused persons as per exhibit P1. Full stop. On the strength of complaint exhibit P1, an FIR came to be registered in crime number 2 of 2014 against the accused number 125 for the offence punishable under section 120B, 143, 147, 148, 307, 302, 201, read with 149 of IPC, dated 7/1/2014 at about 10:30 p.m. 10:30 p.m. by PW 14, the then PSI of the respondent police.
Yes.
Full stop. On the next date, that is on 8/1/2014, the investigation officer PW 12 visited the spot, conducted the spot measure. Thereafter,
morning he conducts inquest in a hospital.
Conducted the inquest Panchanama on the dead body of deceased.
Yes.
Also the spot measure. Full stop. Subsequently, on 17/1/2014, he arrested the accused and recorded their voluntary statements, and based on the same, the vehicle MO number 10 and 20 said to have MO 10 and 20 said to have been used for commission of the crime, the weapons, that is MO 12, 15 and 18.
Please.
18 and the clothes, that is MO 3, 13, 14, 16 and 17. Worn by the accused at the time of commission of the time of perpetrating the crime, were seized at their behest as per exhibit, under exhibit P15. P15,
Yes.
full sure.
Vehicle is under P13 and remaining are
10 and
P15.
20, MO 10 and 20 under exhibit P13. ಕೆಳಗೆ ಮಟ್ಟ weapons ಇದೆಯಲ್ಲ, ಉಳಿದ
MO
rest of the weapons.
MO 10 is under P13, my lords.
MO 10 under
P13.
10 and 20.
ಇಲ್ಲ 20 ಇಲ್ಲ.
MO 10 under
P13
P13, 20.
under P15. Remaining all 15. Remaining all.
P20,
Yes.
MO 10 under exhibit P13, MO 20, that is the
Motorcycle.
vehicle.
Yes.
Next, the weapons 12, 15, 18 and clothes. All under exhibit P15.
15.
Exhibit P15, full show. Later, recording the statement of witnesses and obtaining necessary documents from the concerned authorities, PW12, the investigation officer laid the charge sheet against the accused for the offense punishable under section 143, 147, 148, 302, 307, 201 and 120B, read with section 149 of IPC before the committal court. Full show. Next paragraph. After committal of the case before the sessions court, the learned session judge framed the charges against the accused for the aforementioned offences, and the same was read over to them. However, the accused denied the charges leveled against them and claimed to be tried. Full stop. Next. In order to prove the charges leveled against the accused, the prosecution collectively examined 14 witnesses as PW 1 to 14, marked 45 documents as exhibit P1 to P45, and identified 20 material objects as MO 1 to MO 20. Full stop. The defense has not adduced any oral evidence. However, exhibit D1 to D16 are marked for the on behalf of the accused. Full stop. The next, on completion of the prosecution evidence, the learned session judge read over the incriminating evidence of material witnesses to the accused as stipulated in section 313 of CRPC. However, full stop. However, the accused denied the same. The defense of the accused is of to absolute denial and that of false implication.
Yes.
Full stop. Following the assessment of oral and documentary evidence, evidence placed before the session court, the learned session judge convicted the appellants/accused for the charges leveled against them and sentenced them as stated supra. They set the judgment of conviction and order of sentence is challenged in these appeals.
Yes.
Full stop. The challenge in these appeals by all the 5 accused. 5 accused by way of filing separate appeals. By way of filing separate appeals. Full stop. More particularly, accused number 1, Mallappa, and accused number 3, Mureppa.
Yes.
Have filed criminal
Appeal
appeal number 200173 of 2017.
Please.
Accused number 2, Paramananda,
200169.
has filed criminal appeal number 200169 of 2017.
Please.
Accused number 4, Krishnappa, has filed criminal appeal number 200072 of 2020. Correct. 2020. Whereas accused number 5, Revanna Siddhappa, has filed criminal appeal number 200062 of 17. Correct, Alva?
Yes.
17. Next further. The contention in detail have been advanced by Shri Santosh Kumar B. Biradar, Shri Arun Chowda Purkar, Shri Sanjay Kulkarni, and Shri Kadalur Satyanarayana, the learned counsel for the respective appellant. Where changes idea?
Santosh Kumar and Sheikh Sood was there.
Santosh Kumar illa ನೀವು ಮಾತ್ರ ಅಲ್ವಾ?
ಇಲ್ಲ, instead of Santosh Kumar, Sheikh Sood ಅಂತ ಇದೆ.
Correct. Santosh Kumar ಬಿಡಿ, advanced by Shri
Sheikh Sood.
Shri Sheikh Sood. Sheikh Sood ಹಾಕೊಳ್ಳಿ. Arun Chaudapur, Sanjay Kulkarni and Shri Kadalur Satyanarayana. The learned counsel for the respective appellant / accused and and additional state public prosecutor Shri Siddhalingayam P. Patil for the respondent state. We have also we have perused the records made available before us. Next, to summarize the arguments advanced by the learned counsel for the appellant accused are that ಒಟ್ಟಿಗೆ ಹಾಕೊಳ್ತೇನೆ ಒಮ್ಮೆ ಮತ್ತೆ separate. To summarize the arguments advanced by the learned counsel for the appellants / accused are that the judgment of conviction and order of sentence passed by the session court in the impugned judgment suffers from perversity and illegality. The learned session judge has grossly erred while convicting the appellant without duly appreciating the evidence and documents on record placed before him. Full stop. The learned counsel contended that the prosecution suppressed the genesis of the crime since there is an inordinate delay in registering a FIR by PW1.
Yes.
Though the incident was allegedly caused at
4 p.m.
at about 4 p.m. on 7/1/2014, the FIR was registered
At 10:30
late at 10:30 p.m. on the same night. Despite the police station is situated close by. Full stop. In order to prove the charges leveled against accused, the prosecution predominantly relied on the evidence of PW6. PW6, a child witness, a child witness who is the grandson of deceased and
close relative of this complaint.
And a close relative of PW1 who is said to have been an injured witness to the incident.
Yes.
To the incident. However, according to the wound certificate of PW6, he was brought to the hospital with a history
of road accident. Exhibit P20.
By one Sri Shaila.
Sadapagol.
Sri Shail Sadapur, who has not been cited as a charge sheet. Full stop. According to the complaint lodged by PW1 and the evidence of PW5 and 6, the sister of PW6, one Pooja, who had accompanied the deceased and PW6 on the date of incident on the same motorcycle, while they were returning from Hanumaneri to Gundal, witnessed the incident. However, she being the elder sister of PW6, aged about 13 years at the time of incident, on the date of incident, the prosecution neither cited her on charge sheet nor examined her before the court.
Yes.
Also, even there neither is whispered about her treatment nor wound certificate after the incident. Full stop. Hence, non-examination of the Sri Shail
Sadapgod,
Sri Shail Sadapgod and the injured Pooja clearly creates a doubt in the genesis of the crime. crime and proves totally fatal to the prosecution case, prosecution, full stop. They further contended that according to PW6, the motorcycle in which he was traveling along with the deceased and Pooja was dashed by a cruiser, comma, due to the impact, all of them were tossed on the road, and due to the same, he sustained injuries. After sustaining such injuries, he witnessed the accused getting down from the cruiser, full show. Hence, he fled the spot and hid in a nearby bush. From where he witnessed the incident, full show. However, on perusal of the spot sketch prepared by PW13, as per exhibit P44, exhibit P44, there were no trees and bushes at the place of incident. Further, according to PW6, after the incident, he called his father, PW1, by borrowing the mobile phone of a tractor driver.
Yes.
Tractor driver who was passing by the alleged spot. But nowhere in the charge sheet, the investigation officer recorded the statement of the said person who handed over the mobile phone to PW6. So also the call detail to that effect.
Yes.
Full stop. Further, there are contradictions and omissions in the statements and evidence of PW6, the statement and evidence of PW6, the child witness. Full stop. According to the learned counsel, counsels, it is hard to believe that 8-year boy after sustaining 5 to 6 injuries in a road accident, who fled the spot and hid behind the bush and witnessed the incident for about half an hour and observed the specific overtake of all the accused, full stop. As such, according to the counsels, the evidence of PW6 appears to be tutored and traces of exaggeration and embellishment. Full stop. The learned counsels further submit that though the prosecution projected PW5 as a eyewitness to the incident, on perusal of his evidence, it could be easily gathered that he is a planted / chance witness to the incident. According to PW5, on the date of incident, deceased met him at Dodda Galagali
at 3 p.m.
village in front of a cutlery shop. Kirani Angadi. It's a provision store.
Provision store would be appropriate.
Provision store at about 3 p.m. Full stop. Thereafter, they left the spot and after 10 minutes, he followed them in the same direction. However, he has not stated where was the destination of his travel. Further, according to him, he had witnessed the incident 100 to 100-150.
50 to 150 distance.
50 to 150 feet away from the incident. As admitted by him, he being a close relative, made any attempt either to save the deceased or
Shifting
at least to pacify the quarrel. Full stop. Further, he had not accompanied PW6, the injured boy, to the hospital and lodged no complaint before the police.
Police.
He did not even inform to PW1 about the incident.
Yes.
Full stop. If he was really present at the scene of incident, then he would have informed about the incident to PW1. Further, his statement was recorded on the next day, that is on 8/1/2014
8/1/2014.
by the police, and there is no mention of his presence in the spot at the time of incident in exhibit P1.
P1.
P1 complaint lodged by PW1. The learned counsels also submitted that though the incident occurred at 4 p.m. on 7/1/2014 on the main road of Chikkagalagali and Osur, none of the police officials visited the spot immediately.
Yes.
Nevertheless, even after lodging the complaint by PW1 at about 10:30 p.m. On the same night, the police were not visited the spot till next day, that is on 8/1/2014. It is not enumerated in the charge sheet as to who shifted the
Dead bodies.
two corpuses.
Yes. Two
Corpus to the hospital or from the hospital from the alleged spot. They, according to the doctor who treated PW6, that is PW9, alva, that is PW9.
Yes.
Informed about the incident to Galgali police outpost at about 5:30 p.m., that is immediately after the incident. However, police never visited the spot.
Yes.
Visited the spot. The learned counsel visited the spot. The learned counsel also contended that no witness have been examined by the prosecution to prove immediately prior to the incident there was a meeting of minds. Of the accused to hatch the conspiracy. To commit to murder the deceased.
Yes.
According to the learned counsel, the recovery of the further, they also emphasize the aspect that the recovery of the weapons used for the said to have used for the commission of crime is not as per law, that is within the ambit of section 27 of Indian Evidence Act. And also as per the law laid down by the Honorable Apex Court. Also. The recovery of weapons and clothes at the instance of accused are joint recovery.
Yes.
Joint recovery under exhibit P15. 15 Mahasar. And PW4 is the only witness.
Only witness.
13 and P15. Exhibit P13 and 15 and that. PW4 is the only witness for all the recovery allegedly affected from the accused.
And he is also close relative.
Full shot. Moreover, the said witness also a close relative of the
Deceased.
complainant family. Complainant and deceased family.
Yes.
Full shot. The learned counsel also contended that the cruiser jeep and motorcycle which the accused traveled and used while perpetrating the crime, does not belong to the accused.
Yes.
And the police made no efforts to trace the
Records.
owners.
Yes.
Owners of the said vehicles.
Yes.
And to obtain the IME report.
Yes.
IME report.
Yes.
Report to identify the damage and further details of the vehicles. ಇಷ್ಟೇ ಅಲ್ವಾ ಬೇರೆ ಏನಾದ್ರೂ ಇದೆಯಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತಲ್ವಾ ಎಲ್ಲರದು
Presence of, though PW5 was present, he named the A5 to PW1, but he did not mention in complaint. That is fatal. That is suppression. PW5 was present, my lords. He mentioned the name of A5 to PW1. In spite of that, he did not mention
the
it in
learned
complaint.
counsel also would contend that, as per as per the complaint exhibit P1, the witness PW6 was very much present in the spot.
Five.
PW6, PW
Five was present at the spot.
5 was present in the spot, and he informed.
A PW1
He informed PW1
about participation of A5.
about the
Participation of
participation of A5.
A5.
However,
He did not mention it in
PW1 failed to mention the same in exhibit P1.
P1. That's
Exhibit P1.
yes.
Aitalva?
Yes.
Yes. With these submissions, the learned counsel for the appellants prays to allow the appeal by setting aside the impugned judgment of conviction and order of sentence. In order to buttress their argument, the learned counsel for the accused number 1, 2, 3 relied on the following judgments of the Honorable Apex Court. Judgments of the Apex Court. 1, 2, 3.
Two judgments regarding point.
These are the judgments.
That's one and three.
1 and 3 Sanjay alva?
Yes, yes.
1 and 3. Idanella hakoli. Suresh and another versus State of Haryana 2018. Number 1 hakoli. Suresh and another versus State of Haryana. Report in 2018, volume 18, SCC 654. Number 2, Ram Jag and others versus State of UP. 1974 Criminal Law Journal 479. Number 3, Hamza versus Mahmoud Kutti
alias
Mani
and others.
Report in 2013, volume 11, SCC 150. Mohinder Singh, number 4. Mohinder Singh and another versus State of Punjab and others. Report 2004, volume 12, SCC 311. Number 5, State of Karnataka versus TS Shivakumar and others. Bracket L, Criminal Appeal number 1256 of 2016. Bracket DB. Number 6, Arshad Hussain versus State of Rajasthan, 2013, volume 14, SCC 104.
I mentioned the paragraph for what reason also. Please.
Next, the learned counsel for appellate number
4.
4 alva, Satyanarayana 4, also relied the following judgments. Bashir Begum, number 1, Bashir Begum versus Muhammad Ibrahim and others. Bracket 2020, volume 11, SCC 174. Number 2, Imrat Singh and others versus State of MP 2019, volume 14, SCR 1047. Number 3, Manveer Singh versus State of MP, bracket Criminal Appeal 1141 of 2007. Number 4, Manoj Kumar Soni versus State of MP 2023, SCC online SC 984. Number 5, Shivakumar versus State of MP 2022, volume 9, SCC 676. 676. Next. Refuting the above submission. Sorry.
Kindly. Serial number 43, I seek for 2 days accommodation. Matter was heard, sir.
43,
my lords. Adral synopsis prepare my citation.
Please, relist on
2 or Thursday, my lords.
Thursday.
Please.
My lords, in the morning I submitted memo, my lords. Tomorrow I want to, I can kindly post for the final hearing, my lords. Senior is coming physically from Bangalore to argue on the matter.
You have moved a memo.
Yeah, my lords.
We will take it, but we will take up if it is possible. We can't say. That's a chance. You can come through VC, that is okay. Physical, we can't say. Okay. Because every 2:30 we are taking up criminal appeal. You can take your chance.
Indeed, my lords.
Court officer?
ಹೇಳ್ರಿ sir.
Court officer. Court officer, madam.
ಹೇಳಿ ಸರ್. ಹಲೋ
ನಮಸ್ಕಾರ ಸರ್.
ಸರ್, ನಮಸ್ತೆ ಹೇಳಿ.
ಸರ್, ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 35 ಅದೇ ಬಾಲಾಜಿ ಅಂತ ಹೇಳಿದ್ದಲ್ಲ ಸೋಮವಾರ ತಗೊಳ್ತೀವಿ ಅಂತ ಸಾಹೇಬ್ರು.
ಸರ್, ಡಿಕ್ಟೇಟಿಂಗ್ ಆಗ್ತಾ ಇದೆ, ಆದ್ಮೇಲೆ ತಗೊಂತಾರೆ.
ಇಲ್ಲ, ನೆಕ್ಸ್ಟ್ ನಮ್ದೇ ಇರೋದಲ್ಲ ಈಗ.
ಡಿಕ್ಟೇಟಿಂಗ್ ಜಜ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ.
ಅದೇ ರೀ, ಅದೇ ಡಿಕ್ಟೇಟಿಂಗ್ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ನಮ್ದೇ ಇರೋದು ಕ್ಯೂರ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
ನೋಡ್ಬೇಕು ಸರ್.
ಸರಿ, ಅಂದ್ರೆ ಬೇರೆ ಕೋರ್ಟ್ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತು, ಅಪೇರ್ ಹೋಗ್ತಾ ಇದ್ವಿ, ಅದಕ್ಕೆ ಕೇಳ್ದೆ ನಾನು ಅಪೇರ್ ಮತ್ತೆ ಹೀಗೆ ಅಂತ.
ನೋಡಿ ಸರ್, ಡಿಕ್ಟೇಟಿಂಗ್ ಆಗ್ತಾ ಇದೆ, ನೋಡಿ.
ನನಗೆ ನೋಡಿದೆ, ಆಗ್ಲೇ ನೋಡಿದೆ ನಾನು. ಓಕೆ.
Aftermath, serial number 1, arrest, Kadagant.
Yes.
Yes, my lord. Anyhow, my lord, the first writ petition was, there were several orders which observed that there was signature of the PDO on the representation. For that reason, the writ petition were allowed. So if the first petition may be kindly allowed and the second petition is also the second motion of no confidence that is scheduled to be tomorrow, that should be allowed to be passed. Will be.
The first. No, writ appeal only one is before us.
Yes, my lord.
Okay.
Yes.
Now writ petition, what is the status now? What is your stand?
That is pending, my lord. But as previously there were several orders which allowed the writ petition in the favor of the Adhyaksha. So if that writ petition may allowed and second writ petition, this second motion of no after allowing the writ petition, the first motion of no confidence will be quashed, my lord. So it will the second no confidence will be passed without any hindrance, my lord.
Petition is filed by them.
Yes, my lord. Adhyaksha, both.
Challenging the.
No confidence motion.
That was already passed.
That was already, that was pending before the Assistant Commissioner. Notice was issued for meeting.
It was not put to vote.
Not.
Okay, so that no confidence motion was moved by you.
No, my members, my lord.
Members.
Yes.
You are a part of those members.
Yes.
So if you are going to say, you are not going to precipitate that.
Please.
In light of the second, you file a memo.
Please, ma'am. Please, ma'am.
They're not good. They're going to give it up. They're waiving the rights. No doubt there's a motion of no confidence, but they're going to give up and not go ahead with it.
But that writ petition is still pending for the disposal.
Correct.
To my understanding, with the pardon to Honorable Court, that undertaking has to be before the learned single bench. And until that writ petition is disposed of, and the stay which is there is vacated, under the proviso, the AC can't continue the second meeting.
No, you
It
move
is a question of vacating of the stay.
Okay.
After that.
Okay, you move the matter.
Yes, my lord. That writ petition may be allowed. No problem in that.
Correct. We can't order.
Yeah, that is what.
So you move the bench there, stating tomorrow this is there. We'll have this tomorrow. You move it and get it closed.
Well, that's that.
Today it is not possible to move the matter.
Move ಮಾಡಿ you must make an effort. 2:30 you could have moved it.
Yes, my lord, but already the bench is convened.
4:30 you move the matter. 4:30.
Try my chance to.
Other than that also, in this present case, there is an allegation as far as in the motion that is moved with some 8 points there are with full of the allegations.
Correct. That we will clarify.
That as per this Honorable Court, my Lord's judgment
Correct.
at Bangalore bench, wherein this Honorable Court was pleased to, in Purnima Sundin case in 2018, wherein that notice was quashed and liberty was given to the respondent to move again. So here also in my case, there is an allegation. And that judgment was mainly on the basis of writ appeal number 844/2018, which was detailed in that there was mentioning that when an allegation is there in a meeting, the Adhyaksha can't express or anything can be done. So that is not correct. So 49(2) is no more there. It has been omitted. Under that circumstances, with these allegations also, this notice doesn't stand. It has to be squashed with the fresh direction to move them again. And also with that, the interim order is still in existence. This can't be done. There are 2 points which are legally for me.
Where is the notice? Let us have a look.
My lords, in the present, yes. At page number 42. Even my lords, when the matter is pending before the court,
If this is done, in every case, the stay will be obtained and other representation will be given. A stay will be obtained and other representation will be given. What will be the sanctity of the stay, which is granted by the Honorable High Court?
No, correct. Now they'll have to
The
close.
question becomes that, my lords, this will be in routine in every cases.
No, that they'll have to close it, that we will see.
Yes.
Now here, where is the allegation?
Let's say it is 3-4, paragraph 3-4, that especially para 8, these are all the allegation against me stating that I have not conducted the meeting. The houses which were sanctioned have gone back. I have not conducted meeting. Everything is there under in this entire allegations are there. If this is taken, I can't prove myself to be innocent in the resolution, in the meeting. In fact, I've called the meeting was not attended by.
What is the judgment, let's say?
Yes.
No, but your this long back, the position of law is clear. Then why do you again make allegation and give notice?
The members.
Correct.
Yes.
But the law is, it should be one simplicity.
A simple no confidence motion will be suffice, my lord. But anyhow, it is the reality that the Adhyaksha is not conducting any meeting.
No, that's a different matter.
Yes,
Last two paragraphs of the judgment are
Last.
very 22 and 23. Given that prima facie there has been specific allegation made by the members, the motion must be deemed to be one moved under section 49(2) of the Act. In the absence of the member specifying as to whether it is a motion under 49(1) or 2 of the Act, given the observations of the division bench in para 43, a debate becomes necessary as to these allegations, a task which is not possible given in the absence of the rules. Even today, the rules is silent. The respondent members have offered to give up the allegations. However, the only option open to the members to do so is through a fresh notice. Accordingly, the writ petition is allowed by setting aside the order of Annexure G with the liberty to the members to move a fresh notice under 49(1) of the Act.
Now, do you have a copy of the writ appeal? 844.
No, it's 150 page, wherein in that judgment, what is stated is, since 49(2), when there are allegations, as far as, yes,
Act. So 49(2) has been omitted. No?
Omitted.
What remains is only 49(1).
1.
Ah.
49(2) ಅಲ್ಲಿ ಏನಿದೆ ಸ್ವಾಮಿ ಅಂದ್ರೆ there is a clause saying that if there is a specific allegations ಅವಾಗಿತ್ತು ಸ್ವಾಮಿ, that is being now omitted.
So it should not bother them that whether we made allegation or not. It is immaterial. The intention is only for the members to move the no confidence motion.
And that will always be to me as a mark of allegation in my lifetime. Since I can't clear it when on the day when the no confidence motion is moved, because no one has to speak on that day as per the rules framed. It is only the meeting, it is a voting on that day.
And in many of the cases, my lord, this court has taken a stand that Adhyaksha does not have any locus standi to challenge the motion of
That
no
is
confidence.
there, but now it has to be a motion of no confidence.
My serious concern is with the interim order of the.
Simpliciter, my lord. It does not bother him whether
But
they
it's not,
but
your notice is not simply, suppose it's passed as it is. Then it will
but
be.
the
that-
AC will not consider whether the allegations are made or not.
Correct, but what is passed is the motion of no confidence with stigma.
Stigma, it is not a stigma, my lord, because it is the right of the members. And
Not
the
with
Adhyaksha
allegation.
cannot challenge that, no, I will continue in the office.
No, correct.
However long I will,
No doubt, but you can't have allegation in your note.
allegations,
And-
it is, my lord, but the
And
intention is
wherever
for
there
no
are,
confidence motion.
wherever there is second motion, the first thing is, the first petition is either disposed of or it attended the finality, then the second cause of action comes. Keeping pending the first one with that proviso and the order in operation of this honorable court, the second one is impermissible.
We'll have it on Tuesday or Wednesday.
Or otherwise, I will mention before this.
That's one part.
Please.
The second part also you have to look. So you decide whether in the first round you have a better case or this. Now here admittedly it's one with allegation. So if it's one with allegation, there's a problem because 49 only says, though it doesn't say anything, it's understood now it has to be one that is simpliciter. So it should be a one sentence motion of no conflict.
Yes.
So all you have a number of problems, you decide. I'll have it on Tuesday or Wednesday. But then you decide whether that writ petition you have a better case or this.
In that writ petition, my lord, I honestly submit that it is almost identical representation was given, my lord. So
Identical to the one which
again,
is
again
here.
the same problem will arise. But my submission will be, irrespective of the allegation, the intention is very clear, my lord. Members do not want him to be continued as Adhyaksh.
Correct. So then you do one simpliciter, that's all. You withdraw this also. You file one simpliciter, one line one, and let it come up. We'll reserve liberty. Think about it. We don't want you to hurry up. We'll have it on Monday or Tuesday.
Tomorrow?
Tomorrow we'll have it.
Please.
You take your call on it. But then tomorrow the meeting cannot go on.
Yes.
Meeting, but as the writ petition is dismissed, the preparation will be to conduct the meeting, my lord. So at
So
the,
that you apply your mind and you decide whether the writ petition is better or this is better, or you want to withdraw, you want to come afresh. You make your statement. Suppose you want to withdraw, we'll have no objection, we'll record it, reserve all liberty. We'll have it tomorrow.
tomorrow.
Tomorrow on top of the list.
Please,
Because there's a
my lord.
top of the list.
Please, my
What time is the meeting?
3 o'clock. 3 o'clock.
3 o'clock.
My lord,
The matter. Tomorrow on
until
top
then,
top of-
until then, the same, till tomorrow, it's, yes,
Tomorrow we'll pass some order.
Please, my lord.
till tomorrow, the interim order may be granted.
Let tomorrow. One,
The very purpose of mine filing a writ appeal,
From
writ
the-
petition,
Tomorrow, we will communicate to the government, who will telephonically inform. Tomorrow we'll hear, suppose they say, we are not going to press, give us liberty, there ends the matter. The whole thing goes, liberty is reserved, suppose he says.
may I submit?
Ah,
May I? The first one which is pending,
ah,
it is identical with the same allegation,
hmm.
which is signed by the PDO.
He may withdraw that tomorrow.
Yes, ma'am. After withdrawing that also, if this is continuous, this is also with the allegation,
He may give up this also, there ends the
then
matter.
what happens is the third motion with the liberty. The only remedy that will be for moving them, the fresh under 49(1).
Yes.
So even that can be done now with the liberty for them to move, at least,
So that let him take a call.
yes, ma'am.
Let him take a call. Tomorrow,
With all side, it comes to,
let us see tomorrow.
Please.
by
It is-
then, till then, my lords.
Tomorrow we'll see, please. It looks like you may get relief depending on what he says. We'll see tomorrow.
Please.
Relist tomorrow on top of the list.
Much of it. Much.
If he concedes, he gives you the relief. There ends the matter. If he concedes tomorrow for reserving liberty, whole thing is a washout. Let us see. Let them take a decision, can come tomorrow.
Much of it.
May I?
Office to show the name of
We can do it.
so and so for respondents number
214.
6 to 14. Government advocate accepts notice for
1 to 5.
1 to
4.
1 to 4. Yes. Yes, next.
Okay.
ಹೇಳಿ.
Appear for the respondents.
Ravi, please.
ಹಾ?
Actually, you want to file a part in person, my lord.
Hmm.
So my name may be deleted, my lord. He's not giving instruction to file wakalat or whatever, my lord.
So then he has to get permission for under the.
Yeah, part in person, he can proceed with the part in person.
ಇದು ಅಫಿಡವಿಟ್ ಪಟ್ಟಿದ್ದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡು ಅಂದಿರಲ್ಲ.
ಆಯ್ತು, ಅಲ್ಲಿ ಪರ್ಮಿಷನ್ ತಗೊಬೇಕು. ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಪರ್ಮಿಷನ್ ತಗೋಬೇಕು. Supposed to delete the name of learned counsel. Ravi.
Bhim Singh Chavan.
Counsel as a party who is present submits that he is going to, he intends to appear in person. Necessary permission to be obtained by the party. Relist the matter. Date.
Tomorrow, your lordship, no. We already complied this murder.
Permission to only note.
Monday.
Date code.
Madam.
27th, 27ನೇ ತಾರೀಕು. ಆರ್ಡರ್ ಶೀಟ್ ಸೈನಿಂಗ್ಸ್. ಲಿಸ್ಟ್ on 27. Order sheet signings. Yes.
Till number 22, AM Biradar.
Informed to Sudarshan advocate.
Huh?
Already informed to Sudarshan advocate.
Will next week,
Next week.
Next week.
It is not a date, is not given the date of the London single judge. Whenever a matter will be settled, will be moved in court and.
Matter is adjourned. In light of the submission, both parties are exploring possibility of settlement.
Till number 25, Ganesh Kalaburagi.
Inner counsel is held up in.
Alaitu, but either we have it on some other day or after the dictation in the criminal appeal.
After dictation, Your Lordship. Senior
Okay,
counsel
let
wants
us
to
know,
make some
right.
submissions.
Next.
Others will repeat it tomorrow, day after tomorrow.
Please, madam.
I'll seek instructions, Your Lordship. Senior counsel wants to make some submissions in this
Correct.
matter.
ಆಯ್ತು, 4:15 ಅಷ್ಟಕ್ಕೆ ಈ ಡಿಕ್ಟೇಷನ್ ಆದ್ಮೇಲೆ.
Yes, sir.
Dictation ಆಗುವಾಗ no disturbance.
Yes.
You must intimate him and
Refuting the above submission, the learned additional SPP on the other hand submitted that the prosecution has clearly established the guilt of the accused and no exception can be taken to the reasons indicated by the trial court under the well-reasoned judgment. Full stop. The evidence has also been analyzed in great detail by the session court, and therefore no question of any interference is called for with the conviction recorded in the impugned judgment by the session court. Full stop. He further contended that the prosecution has proved the charges leveled against the accused by placing the evidence of the injured child witness PW6, Kalmesh, who was traveling along with the deceased on a motorcycle at the time of incident. So also the evidence of PW5, who is an eyewitness to the incident, full stop. PW6 in his evidence, according to learned SPP, PW6 in his evidence categorically stated that the accused dashed the motorcycle in which he, his sister and deceased duo were traveling. Thereafter, all the accused assaulted the deceased duo with the MO 1, 12, 13 and 15, full stop. Thereafter, accused number 5 held the deceased Basappa, and accused number 2 drove the jeep on his head, full stop. Later, later he called PW 1 through 4, full stop. This evidence of PW 6 clearly corroborated with the evidence of PW 5, Narayana, who is the eyewitness to the incident. First, full stop. Further, the evidence of both these witnesses also corroborate to the medical evidence. That is, the evidence of PW 9, the doctor who treated PW 6. So also the evidence of PW 10, the doctor who conducted the autopsy on the corpus of the deceased, full stop. According to the learned SPP, the prosecution also successfully established the motive for the alleged incident by examining PW 1, 7 and 8, who have clearly stated that owing to civil dispute between the deceased Rangava, that is the deceased Rangava, and the parents of accused number 1, 2, 3, the accused have committed their murder, full stop. Further, 4 months prior to the incident, that is on 8/8/2013, the deceased Rangava had lodged a complaint against the accused for giving them life threat owing to the property dispute, full stop. Moreover, the prosecution also placed the documents to that effect. That is Exhibit P2 to P4, full stop. The learned SPP also contended that the prosecution proved the circumstance of recovery of weapons used for the commission of crime by the accused under Mahazar Exhibit P15, since PW4, the punch witness for that clearly supported the case of prosecution. PW, full stop. According to the learned SPP, PW 1, 7 and 8 have visited the spot immediately after the incident, and they have been informed by PW 5 and 6 about the incident, full stop. As such, they have to be treated as res gestia witness as contemplated in section 106 of Indian Evidence Act. 106 of Indian Evidence Act. 6. PW 5 and 6.
No, my lords. Evidence Act 6.
Sorry, section 6 of Indian Evidence Act, 6 of Evidence Act. Hence, the prosecution has successfully proved the guilt of the accused beyond all reasonable doubt, and the appeal is liable to be dismissed. Full stop. With this submission, the learned SPP pays to dismiss the appeal. Appeal. Next. Having heard the learned counsel for the parties, and also upon comprehensive perusal of the evidence on record, the points that surface for our consideration are: number one, whether the judgment under this appeal, these appeals either suffer from any perversity or illegality. Number two, whether the judgment, whether the learned session judge is justified in convicting the appellants / accused for the offense they charged. Next. As common narration and consideration are involved in the appeal on hand, we take the liberty to address the above raised points for consideration in the foregoing paragraphs. Full stop. In order to prove the homicidal death of deceased, that is Basappa and Rangawa, the prosecution predominantly relied on the evidence of PW10 Dr. R.C. Patil, the assistant professor, Al Amin Hospital, Vijayapura, who conducted the autopsy of the corpus. Full stop. He conducted the autopsy of deceased Basappa and identified 13 external injuries and 4 internal injuries, and issued his final opinion as to cause of death. Death is due to hemorrhage as a result of head injury sustained, close, and issued the post-mortem report as per Exhibit P22. According to him, if a person assaulted with the MO 8, 12, and 15, and also fall from moving bike and passing of a jeep wheel on head, the injuries found in the dead body could be caused. Full stop. He also, the PW10 also conducted, later PW1 also conducted, although subsequently PW10 also conducted the autopsy of the deceased Rangawa and noticed 13 external injuries, and opined that the death was due to hemorrhagic shock as a result of injury sustained overhead. Close. He issued the post-mortem report as per Exhibit P23. Full stop. He also opined that the injuries found on the corpus of Rangawa could be caused by assault from wooden club MO5 and due to fall from moving bike. Full stop. Further, PW10 doctor stated that all the injuries found on the corpus are ante-mortem in nature. Full stop. Though the defense made an attempt to dispute the death of that they both died due to road traffic accident, and suggestions made to PW10 to that effect, however, PW10 denied those suggestions and specifically stated that the injuries noticed on Exhibit P22 and 23 cannot be caused due to road traffic accident. Full stop. Further, the depressed fracture, the injury caused to deceased Basappa, also not possible in road traffic accident. Full stop. Apart from this evidence, PW12, the investigating officer, stated on 8/1/2014, he conducted inquest Panchanama on the corpus of deceased as per Exhibit P6 and P7. Full stop. PW2 is the punch witness for the same, himself and PW12 have identified the injuries on the corpus of both the deceased. Full stop. Even in the inquest Panchanamas, the question number 11 answered that the death of both deceased are homicidal due to the act of accused. Full stop. In such circumstance, we are of the view that the prosecution has proved the homicidal death of both the deceased beyond reasonable doubt. Full stop. Next, in the instant case, the prosecution, albeit the prosecution examined 14 witnesses, prosecution 14 witnesses to prove the charges leveled against the appellant accused, it is not necessary to dwell into detail of individual evidence of all the witnesses. To bring home the guilt of the accused, the prosecution primarily relied on the evidence of PW 1, 4, 5, 6, and 7. Full stop. On careful scrutiny of the evidence of these witnesses, PW 1 being the son of deceased, said the son of the deceased, PW 1 the close relative. PW 1 being the son of the deceased, set the criminal law into motion by lodging complaint as per Exhibit P1. Exhibit P1. Full stop. According to him, on 7/1/2014, in the evening hours, his son PW6 informed him through mobile phone about the incident. Full stop. Immediately, he rushed to the spot and saw the dead bodies of his parents. On inquiry, PW6 informed that himself, the deceased and his sister Pooja, the dear deceased, his sister Pooja, while coming from Hanumaneri to Gundalwada, near Nandi School, Chikkagalagali, the accused dashed the cruiser jeep to the motor bike. As a result, all of them were tossed and fell on the road. And thereafter, the accused committed the murder of his parents by assaulting with MO 12, 13, and 15. Full stop. Later, he shifted PW6 to hospital and lodged the complaint. On perusal of the complaint, complaint exhibit P1, admittedly, PW1 has not whispered about the presence of PW5, the eyewitness to the incident. Full stop. The said complaint was lodged at about 10:30 p.m. on 7/1/2014. According to PW1, his son, PW6, PW6 is relative PW6.
Sister's son.
His sister's son, PW6 Kalmesh, was injured due to the accident and he was got admitted in the hospital. Full stop. Hence, the evidence of PW1 has to be treated as hearsay evidence for the reason that he has reached the spot after 2 hours after the incident. Full stop. That is at about 6 p.m. And before he reaching the spot, PW6 was already shifted to hospital about to 5:10 p.m. Full stop. As per the evidence of PW9 doctor, as 5:10, as per the evidence of PW9 doctor who treated him. Full stop. On perusal of Exhibit P1 complaint, it is stated by PW1 that while he reaching the spot at about 6 p.m., PW6 was weeping in front of the corpus of the deceased. On inquiry, he revealed the name of accused and also the assault made by them. Further, in his evidence, also he reiterated the said aspect. However, as stated supra, PW9 categorically stated on 7/1/2014 at about 5 p.m. one Sri Shaila had brought PW6 to his hospital and he treated him. To further substantiate the same, on perusal of exhibit P20 wound certificate of PW6, the same reveals that the date and time of his examination by PW9 is at about 5:10 p.m. on 7/1/2014. As such, the version of PW1 in exhibit P1 and its evidence before the court that PW6 was present in the scene of occurrence at about 6 p.m. and he narrated the incident to him is doubtful. Full stop. Hence, the evidence of PW1 cannot be considered as a registered witness as contended by learned SPP. Full stop. Coming to the evidence of PW6, the child witness who is injured eyewitness to the, who is also an injured eyewitness to the incident, he has deposed that on the date of incident, he along with his sister Pooja and they were deceased, while returning from Hanumaneri in a motorcycle, the accused dashed the motorcycle by a cruiser jeep, due to the impact, all of them were tossed and fell on the road, and he sustained injuries on his person. Thereafter, accused got down from the jeep and assaulted his grandparents with MO 12, 13, and 15. Due to afraid, himself and his sister Pooja hid in a bush near the spot and witnessed the incident. Full stop. Subsequently, he called PW1 through mobile phone and informed about the incident. Full stop. Thereafter, PW5 visited the spot. PW12 and one Sri Shaila shifted him to the hospital. This witness identified MO10 and MO19, the vehicles used by the accused. So also the motorcycle of the deceased, that is MO20. On careful perusal and analysis of evidence of this witness, at the outset, this witness being a child witness, aged about 8 years at the time of incident and 11 years at the time of evidence, the learned session judge totally failed to make a proper preliminary examination of the minor by putting appropriate questions to ascertain whether the minor is capable of understanding the questions put to him and is able to give rational answers. Full stop. It is the duty of a judicial officer to ask preliminary questions to the witness with a view to ascertain whether a minor can understand the questions put to him. Full stop. In this case, the learned session judge has stated that he has satisfied that the minor is able to understand the questions and know the difference between truth and untruth. Except such observation, no preliminary examination of the examination of the minor is conducted. Hence, at the outset, we are of the view that the learned session judge has failed to do his duty on the count for the on that count, for the reason that it is for the reason that it is a settled principle of law, settled principle that corroboration of the testimony of a child witness is not a rule, but a measure of caution and prudence. Full stop. A child witness of tender age is easily susceptible to tutoring. Full stop. However, that by itself is no ground to reject the evidence of a child witness. Full stop. The court must apply its mind to the apply its mind to the question whether there is a possibility of the child witness being tutored. Full stop. Therefore, scrutiny of the evidence of a child witness is required to be made by the court with care and caution. Full stop. Our view is fortified by the judgment of the Honorable Apex Court in the case of Pradeep versus State of Haryana in 2023, SEC online 777. Full stop. Further, on perusal of the evidence of this child witness, a doubt creates in the mind of this court about the narration of the incident by this child witness was aged about 8 years at the time of incident, moreover, according to him, while the deceased riding the motorcycle, in total 4 of them were in the said motorcycle, and due to the accident caused by the accused to their motorcycle, all of them fell on the road and all of them were tossed and fell on the road, and he had sustained as many as 6 injuries on his person. Full stop. It is hard to believe that in the said situation, by running from the spot and hiding near the bush, he has witnessed the entire incident. That is the specific overtact committed by each of the accused, and also identifying the weapons used by the accused. Full stop. Further, the evidence recorded before the court after lapse of 3 years, in the year 2017, this witness narrated the 3-year-old incident verbatim to the prosecution case by withstanding the test of cross-examination. It is hard to believe that 8-year-old boy, without knowing or acquaintance with the accused, naming them and stating their individual overtime after 3 years without any variation to the prosecution case. Moreover, as discussed supra, the evidence of PW1 is a parrot-like version which creates a doubt about the presence of this witness in the spot at about 6 p.m. and narration of the incident to PW1 as stated in the complaint Exhibit P1. Full stop. The Honorable Apex Court in the case of Radhesham, in the case of Radhesham versus State of Rajasthan, reported in 2014, Volume 5, SEC 389, para 12 held as under, full stop, 12 according, as under. Next, as per the findings of the Honorable Apex Court in the above referred judgment, it is concluded that the judgments concluded that the evidence of child witness must be subjected to close scrutiny to rule out the possibility of tutoring, and as a rule of prudence, corroborative evidence is required to rely on the evidence of child witness. Full stop. Next part. Though the prosecution examined PW5, another eyewitness in the instant case, as a corroborative evidence to the evidence of PW6, on PW6, the child witness, on scrutiny of the evidence of PW5, according to him, on the date of incident, the deceased met him at a place called Doddagalagali, and after deceased leaving the said place, he also traveled behind them in the same direction in a motorcycle, and thereafter witnessed the incident. Full stop. According to him, he is a close relative of the deceased. Admittedly, he has not, admittedly at the time of incident, he has not made any attempt to rescue the deceased from the attack of accused, nor pacified the row. Full stop. Being the close relative, he has neither shifted the injured PW6, a 8 years boy, to the hospital, nor lodged any complaint to the police about the incident till 10:30 p.m. That is till the time of PW1 lodging the complaint. Full stop. Further, he has not called PW1 immediately after the incident, in spite of PW6 sustaining injuries in the incident and the death/murder of the deceased. Full stop. Nevertheless, his statement was recorded on the next day, that is on 8/1/2014. This conduct of PW5 creates a clear doubt about his version that he was present in the scene of occurrence at the time of incident. Full stop. To substantiate this aspect, perusal of the inquest Panchanama, exhibit P6 and P7, the column number 4 depicts that the deceased were finally seen by PW6 Kalmesh. Full stop. Moreover, there are serious infirmities in the evidence of this witness compared to his 161 statement. Full stop. Exhibit D1 to D14 got marked in his evidence. That is the portion of omission/contradiction in his evidence against his 161 statement before the police. Full stop. As stated supra, as discussed supra, the non-lodging of complaint by this witness, and also not mentioning of the presence of this witness by PW1 in exhibit P1. Exhibit P1, creates a serious doubt in his evidence. Full stop. The Honorable Apex Court in the case of Daya Singh versus State of Punjab. Daya Singh was State of Punjab, AIR 1965, 328, held in para 19, 19 and 20 as under. 19 and 20 as under Akoli. 19 and 20 as under, full stop. On careful perusal of this evidence, he witnessing to the incident as claimed by him under serious doubt, and he appears to be a chance witness to the prosecution, who appeared suddenly in the scene of occurrence and then disappeared after noticing the occurrence about to, which he called later to give evidence. Full stop. Hence, we are unable to accept the evidence of this witness as a gospel truth to prove the guilt of the accused. Full stop. Next part. Though the prosecution relied the evidence of PW 1, 7, and 8 to prove the motive for the commission by the accused, that there was a civil dispute between the deceased Rangava and the parents of accused, and was placing exhibit P2 to P4, the said documents clearly reveals that the civil dispute between the parties, between the deceased and parents of the accused, culminated in the year 2005, 2006 itself. 2006 itself. That is 9 years prior to the date of incident. Full stop. We are aware about the position of law that in a case based on the evidence of eyewitness to the incident, the motive will not play a vital role. However, as discussed supra, since the prosecution failed to place believable evidence of eyewitness, the circumstance of motive also not established by the prosecution. Next, coming to the circumstance of recovery relied by the prosecution, recovery evidence relied by the prosecution, that is the recovery of MO 12, 13 and 15 under exhibit P15, admittedly the Mahazar exhibit P15 drawn in the backyard of the house of accused number 123. The prosecution failed to place any documents to establish that the said house belongs to accused number 123. Further, this recovery, as rightly contended by the learned counsel, this recovery is a joint recovery at the instance of accused number 123. PW4 is the only witness for all these mahazars, recovery mahazars. On perusal of exhibit P15, the same reveals that PW15 along with the police moved from one place to other by conducting the mahazars and recovering the articles under exhibit P13. Conducting the mahazar, full stop, conducting the mahazar. The exhibit P13, the recovery of cruiser jeep initially, that is exhibit P13, the cruiser jeep initially, thereafter exhibit P15 and exhibit P19.
15
exhibit P13, the recovery of cruiser jeep initially, and all the weapons were used under exhibit P15, exhibit P15. Thereafter, exhibit P19 was drawn. That is the place where the conspiracy held by the accused to commit the crime. Full stop. According to PW4, on the date of Mahazar, the police called him to the police station at about 10:30 p.m., 10:30 a.m. And thereafter, police took him to conduct all the above Mahazars. As stated supra, the police were failed to obtain the registration certificate of the vehicles which used for the commission of crime. Further, the recovery of weapons used for said to have used for the commission of crime also not affected as per the law laid down by the Honorable Apex Court. Full stop. The Honorable Apex Court in the case of Subramanya versus State of Karnataka reported in 2023, volume 11 SCC 255 held in paragraph 78 as if it is say if it is say of the investigation officer that the appellant accused while in custody on his own free will and volition made a statement that he would lead to place where he had hidden the weapon of offense, the site of burial of the dead body, clothes, etc. Then the first thing that the investigation officer should have done was to call for 2 independent witnesses at the police station itself. Once the 2 independent witnesses would arrive at the police station, thereafter, in their presence, the accused should be asked to make an appropriate statement as he may desire in regard to pointing out the place where he is said to have hidden the weapon of offense, etc. Full stop. When the accused while in custody makes a statement before 2 independent witness, bracketally punch witness, the exact statement or rather the exact words uttered by the accused should be incorporated in the first part of the Panchanama that the investigation officer may draw in accordance with the law, full stop. This first part of Panchanama for the purpose of section 27 of the Evidence Act is always drawn at the police station in the presence of the independent witnesses so as to lend credence that a particular statement was made by the accused expressing his willingness on his own free will and volition to point out the place where the weapon of offense or any other article used in the commission of the offense had been hidden. Full stop. Once the first part of the Panchanama is completed, thereafter the police party along with the accused and 2 independent witnesses would proceed to the particular place as may be led by the accused. If from that particular place anything like weapon of offense or bloodstained clothes or any other article is discovered, then the part of entire process would form the second part of the Panchanama. This is how law expects the investigation officer to draw the discovery Panchanama as contemplated under section 27 of the Evidence Act. Full stop. If we read the Panchanama, Evidence Act, section 27 of Evidence Act, full stop. On careful perusal of Exhibit P 13, 15 and 19, the police have failed to recover the incriminating articles within the ambit of section 27 of Indian Evidence Act as held by the Honorable Apex Court the judgment referred supra, full stop. On careful perusal of the entire material placed by the prosecution, in this case, we are this case, comma, we are constrained to we are of the view that the prosecution also failed to prove the recovery of incriminating articles at the instance of the accused. Full stop. As discussed supra, comma, the evidence of PW6, the child witness, not recorded as per the law settled by the Honorable Apex Court, and much credence cannot be given to the evidence of PW6, the child witness, since the version of PW6 not corroborates with the contents of Exhibit P1. So also the evidence of PW1. Full stop. It's also full stop. Further, we are already discussed the evidence of the PW5, who is a planted / chance witness to the prosecution case. Since the version of PW5 clearly creates a doubt in the mind of this court, since he has failed to lodge any complaint, or at least failed to lodge any complaint till 10:30 p.m. on the date of incident, and even to inform PW1 about the incident, at least to inform PW1 to the incident. Full stop. Incident. Moreover, according to PW5, he has not revealed the incident even to his at his house, to his family members. This strange conduct of PW5 once again creates a doubt in his version. In such circumstance, the prosecution has failed to place a cogent evidence to prove the guilt of the accused beyond reasonable doubt. Full stop. On a careful perusal of the entire material placed by the prosecution, in this case, we are constrained to express our displeasure about the manner the casual investigation conducted by the respondent police. Though 2 murders have been committed on the highway road at about 4 p.m. on 7/1/2014, and in spite of MLC by Dr. PW9, the police does not venture to visit the spot immediately. Full stop. Unfortunately, after lodging of complaint at about 10:30 p.m. by PW1, the police, even after that, the police failed to visit the spot and commence the investigation. Full stop. As per the charge sheet materials, the prosecution, the respondent police commenced the investigation only on 8/1/2014 by visiting the spot. Full stop. Nowhere in the charge sheet, it is forthcoming who has shifted the dead body to the mortuary to conduct inquest and postmortem. Full stop. Postmortem. Nevertheless, the investigation officer totally failed to record the statement of the person, statement of one Sri Shaila who allegedly shifted the injured PW6 to the hospital. who must be an eyewitness to the incident. Eyewitness to the incident, full stop. The investigation officer also failed to record the statement of a sister of PW6, one Pooja, who was along with the deceased and PW6 at the time of incident and also sustained minor injuries, full stop. The non-examination of this material witness fatal to the prosecution case, full stop. Not only fatal to the prosecution case, but also creates a doubt in the presence of doubt in the doubt about the presence of PW6 in the spot as claimed by PW1 and as claimed by the prosecution, full stop. Prosecution. The casual conduct of the investigation officer in a serious offense of double murder, caused serious prejudice to the prosecution case, full stop. Be that as it may, on overall perusal of the evidence of witness discussed supra, and also the faulty investigation conducted by the investigating officer in the case, in totally creates the doubt about the genesis of the crime, full stop. It is the cardinal principle, cardinal rule of criminal jurisprudence that the burden in the web of proof of an offense would always lie upon the prosecution to prove all the facts constituting the ingredients beyond reasonable doubt, full stop. If there is any reasonable doubt, the accused are entitled for the benefit of the said reasonable doubt, full stop. At no stage of the prosecution case, the burden shifts, burden to disprove the fact would rest on the defense, full stop. The Honorable Apex Court in the case of Moham Singh versus Singh Roy versus State of West Bengal, reported in 2003, volume 12, SCC 377, has made an observation in respect of moral conviction that, wandering on strong suspicion is not an option to decide a case by the session court, and held in paragraph number 27 that it is no doubt a matter of regret that a foul, cold-blooded and cruel murder should go unpunished. There may also be an element of truth in the prosecution story against the accused. Considered as a whole, the prosecution story may be true, but between maybe and must be, there is inevitably a long distance to travel, and the whole of this distance must be covered by the prosecution by legal, reliable and unimpeachable evidence before an accused can be convicted. Next, the golden thread which runs through the web of administration of criminal justice is that if two views are possible on the evidence adduced in the case, one pointing out the guilt of accused, and the other point, other two is innocence, comma, the view which is favorable to the accused should be adopted. Full stop. Placing reliance on the above judgments discussed, judgments discussed above. So also on a meticulous examination of the entire evidence on record, comma, we are of the considered view that the learned session judges erred while convicting the accused for the charges leveled against them. Hence, interference is required in the impugned judgment passed by the session court. In that view of the matter, comma, these appeals succeed. These appeals succeed, and accordingly, we answer the point number 1. We answer the point number 1 in the affirmative and point number 2 in the negative, and proceed to pass the following order. The criminal appeals number 200169 of 2017, comma 20000062 of 17, comma 200173 of 17, and 200072 of 2020 are allowed. The judgment of the conviction and order of sentence dated 31/3/2017 passed in SC number 108 of 2014 by the third additional session judge Vijaypura is set aside. The accused are acquitted. Accused by appellants are acquitted from the charges for the offences punishable under section 143, 147, 148, 302, 307, 201, and 120B, read with section 149 of IPC. 4. The jail authority is directed to release, the concerned jail authority is directed to release the appellant/accused forthwith if they are not required in any other cases. The registry is directed to communicate this order to the jail authority, the concerned jail authority.
So please. So for one sentence of our child witness is concerned. The version of child evidence is my lords contrary to exhibit P44. Bush anta ಹೇಳ್ತಾರೆ exhibit P44 ಅಲ್ಲಿ ಇರೋದು.
P44.
Yes, that has to be added.
P44, huh?
P44 sketch map.
Yes, P44.
Bush anta ಹೇಳ್ತಾರೆ, it was not.
In the bush.
Yes, that is not there.
P44 ಕೆಳಗಡೆ ಬರುತ್ತೆ.
Oh, bless.
Number 36, Shambhulinga Saliman.
Phone ಮಾಡಿದ್ದೆ. ಸಂಜಯ್ ಪಾಟೀಲ್ಗೂ ಒಂದು ಫೋನ್ ಮಾಡ್ಬೇಕು. ಗೆಟ್ ರೆಡಿ ಅಂತ.
Yes, Mr. Girish Patil. You ready? Fully ready ಆಗಿದ್ದೀರಿ? Ready ಆಗಿದ್ದೀರಿ?
Sir, unmute.
Unmute ಮಾಡ್ಕೊಳ್ಳಿ. Unmute your mic.
Yes. Serial number 35, I'm fully ready, my lord. I'm ready to argue right now.
Fully ready?
Yes.
You are?
Same. I'm submitting the judgments.
Girish,
Please.
Yes. Yes, sir.
ಬೆಳಿಗ್ಗೆ ಫೋನ್ ಮಾಡಿ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರ
May I submit, my lord?
Yes.
My lords, I am the appellant in this case, my lord. I have been convicted under section 302 and 498A, my lords. Under 498A, I have been convicted for only 1 year. And under 302, I have been convicted for life imprisonment till the rest of my life. My lord, now I will be arguing on.
Just a minute. ರೆಡಿ ಇದ್ದೀರಿ ಶಂಬಳಿ ನಿಮಿಷ ರೆಡಿ ಇದ್ದೀರಿ ಎಷ್ಟೊತ್ತು ಬೇಕು ನಿಮಗೆ 15 minutes ಸಾಕಾ
ಲೀಗಲ್ ಸೆಲ್ ಮ್ಯಾಟರ್
ಹಾ
ಲೀಗಲ್ ಸೆಲ್ ಮ್ಯಾಟರ್ ಇದೆ
ಲೀಗಲ್ ಸೆಲ್ ಮ್ಯಾಟರ್
ಅದರಿಂದ ಜಾಸ್ತಿ ಇಂಟ್ರೆಸ್ಟ್ ತಗೊಬೇಕು. ಫೋರ್ ಪರ್ಸನ್ಸ್ ಅಂದ್ರೆ ವಿ ಶುಡ್ devote more interest and more time. Big people have big lawyers.
Please.
It's only for the people who really don't have means. Yes. Genuinely, we have to extend more attention. Yes.
Please.
If you're ready, we'll take it.
ಗಿರೀಶ್ ಪಾಟೀಲ್ ಬಿ ದೇರ್
Yes, ma'am.
ನಾವು ಇದನ್ನು ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೀವಿ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಗ್ಬೋದು ಸ್ವಾಮಿ. ಪಬ್ಲಿಷ್ಡ್.
ಲೀಗಲ್ ಸೆಲ್ ಆದ್ರೆ 15 minutes, ನಿಮ್ಮ ಅಪೀಲ್ ಆದ್ರೆ 1 hour.
No, my lord.
ನಿಮ್ಮ ಮೇಲೆ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಲೀಗಲ್ ಸೆಲ್ ನವರು, ನೀವು ನಡೆಸಬೇಕು ಕೇಸ್ ನೀಟಾಗಿ.
ಹೌದೌದು. Complaint is page number 2, my lords. I will read it in Wednesday. I have read it. Complaint. One more read it, I will read it.
ಆಯ್ತು, ಇನ್ನೊಮ್ಮೆ ಓದಿ ನೋಡೋಣ.
Please.
ರಿಲೆವೆಂಟ್ ಸೆಕೆಂಡ್ ಪಾರ್ಟ್, ಪ್ಯಾರಾ ನಂಬರ್ 2.
ಪ್ಯಾರಾ ನಂಬರ್ 2. ಇಂದು ದಿನಾಂಕ 16/9 ಸಾಯಂಕಾಲ 6:30 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಾನು ನಮ್ಮ ಅಕ್ಕಳ ಮಗನಾದ ಹನುಮೇಶ್ ಮನೆ ಹತ್ತಿರ ಹನುಮೇಶ್ ಮತ್ತು ಈತನು ಹೆಂಡತಿ ಪದ್ಮಾವತಿಯವಳೊಂದಿಗೆ ಮಾತನಾಡಿ ಕುಳಿತಿದ್ದೇವೆ. ಪದ್ಮಾವತಿ ತಾಯಿಯಾಳ ಹನುಮಪ್ಪ ಗೋರೆಯವರು ಹಾಗೂ ಅವರ ಮೈದುನ ದೇವಣ್ಣ ಬೋರೆಯವರು ಇವರು ಸಹ ಬಂದಿದ್ದರು. ಆಗ ನಮ್ಮ ಅಕ್ಕನ ಮನೆಯಲ್ಲಿ ಅಡುಗೆ ಮಾಡಿ ಮುಂದಿನ ಕೋಣೆಯಲ್ಲಿ ಕುಳಿತಿದ್ದಳು. ರಾತ್ರಿ 7:30 ಗಂಟೆಗೆ ಆಗಿರಬಹುದು. ಆಗ ನಮ್ಮ ಅಕ್ಕ ಗಂಡನ ಮಾದಪ್ಪ ಅವನು ಹೊರಗಿನಿಂದ ಮನೆಯೊಳಗೆ ಬಂದು ನಮ್ಮ ಮಕ್ಕಳಿಗೆ ಕುಡಿಲಿಕ್ಕೆ ಹಣ ಕೊಡು ಅಂತ ಕೇಳಿದ್ದ. ಆಗ ನಮ್ಮ ಅಕ್ಕ ತನ್ನ ಗಂಡನಿಗೆ ದುಡಿಯಲು ನಾವು ದುಡಿದ ತಂದ ಹಣವನ್ನು ಖರ್ಚು ಮಾಡುತ್ತಾ ಹೋದ್ರೆ ಸಂಸಾರ ಹಾಳು ಮಾಡಿ ಬಿಡುತ್ತೇವೆ ಅಂತ ನಮ್ಮ ಮಾವ ಮಾದಪ್ಪನ ಮೇಲೆ ಸಿಟ್ಟಿನಿಂದ ಮತ್ತು ಎದ್ದು ನಮ್ಮ ಅಕ್ಕ ಈರಮ್ಮಾಳು ಒಲೆಯ ಕೊಳವೆ ಕೂಡಿಕೊಂಡು ಹಣ ಕೊಡಲಿಲ್ಲ ಅಂದರೆ ನಿನ್ನನ್ನೇ ಕೊಂದು ಬಿಡುತ್ತೇನೆ ಅಂತ ಆಗ ನಮ್ಮ ಅಕ್ಕನ ನೀನು ಮಾಡಿದ್ದಾದ್ರೂ ಏನು, ಇವತ್ತು ನಿನ್ನಲ್ಲಿ ಹಣ ಇಲ್ಲ,
ಅಂತ ಅಂದಾಗ ನಮ್ಮ ಮಾವ ಮಾದಪ್ಪ ಕಬ್ಬಿಣ ಉದ್ರೋಳದಿಂದ ತೆಗೆದುಕೊಂಡು ನಮ್ಮ ಅಕ್ಕನ ಈರಮ್ಮಳಿಗೆ ಹಣೆ ಮತ್ತು ಮೊದಲೇ ಮೇಲೆ ಮತ್ತು ಬಲ ಮಗಲಿ ಮೇಲೆ ಜೋರಾಗಿ ಹೊಡೆದನು. ಆಗ ನಮ್ಮ ಅಕ್ಕ ಅಂತ ಕೆಳಗೆ ಬಿದ್ದಳು. ನಾನು ಹತ್ತಿರ ಹೋದಾಗ ಸದರಿ ನಮ್ಮ ಮಾದಪ್ಪ ಮನೆಯಿಂದ ಮನೆಗೆ ಹಿಂತಿರುಗಿ ಬಂದರೆ ನಿನಗೆ ಕೊಂದು ಬಿಡುತ್ತೇನೆ ಅಂತ ಅದನ್ನು ಹೇಳಿದ್ದ. ಆಗ ಸ್ವಲ್ಪ ಹೊತ್ತಿಗೆ ಹೊರಗೆ ಹೋಗಿ ನಿಂತವು. ಅಷ್ಟರಲ್ಲಿ ಜನರು ಬಂದು ಆಗ ಸರಿಯಾದ ಮಾದಪ್ಪನವನಿಗೆ ಹೊರಗಡೆ ಬಂದು ಓಡಿ ಹಿಡಿದುಕೊಂಡು ನಮ್ಮ ಊರಿನ
ಹೊರಗಡೆ
ಆಗ ಊರಿನವರಾದ ಗೌಡಪ್ಪ ಸೋಯಣ್ಸೋ, ಈರಣ್ಣ ಸೋಯಣ್ಸೋ ಇತರರು ಹಿಡಿದುಕೊಂಡು ಮರಿಯಮ್ಮ ಗುಡಿ ಹತ್ತಿರ ಕೂಡಿಸಿಕೊಂಡು, ನಂತರ ನಾವು ಒಳಗೆ ಹೋಗಿ ನೋಡಿರಲು ನಮ್ಮ ಅಕ್ಕ ಆ ಈರಮ್ಮಳು ಮೃತಪಟ್ಟಿರುವ ಹೆಣವನ್ನು ಮೊದಲೇ ಬಾರಿ ರಕ್ತ ಗಾಯವಾಗಿರುವುದು ರಕ್ತ ಬಂಡೆ ಮೇಲೆ ಸುರಿದು ಸದರಿ ನಮ್ಮ ಮಾವ ಮಾದಪ್ಪ ತನ್ನ ಕುಡಿಯಲಿಕ್ಕೆ ಹಣ ಕೊಡಲಿಲ್ಲ ಅಂತ ನಮ್ಮ ಅಕ್ಕ ಈರಮ್ಮಳಿಗೆ ಕಬ್ಬಿಣ ಉದ್ಗೋಳದಿಂದ ಹಣೆಯ ಮತ್ತು ಮೊದಲಿಗೆ ಜೋರಾಗಿ ಹೊಡೆದು ಕೊಲೆ ಮಾಡಿರುತ್ತಾನೆ ಎಂದು ಸದರಿ ಮಾದಪ್ಪ ಅವರನ್ನು ವಯಸ್ಸು 55 ಇವರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸುವ ವಿನಂತಿ ಮೇಲೆ. And my lords is complaint is deceased brother, my lords. And also
witness ಪೆದ್ದಮ್ಮನ ತಾಯಿಯಾದ ಹನುಮಮ್ಮ ಮೈದುನ ರೇವಣ್ಣ ಗೋರೆಬಾಳ.
ಹೌದು.
ಯಾರೆಲ್ಲ ಐ ವಿಟ್ನೆಸ್?
ಐ ವಿಟ್ನೆಸ್ is my lords. I witness is my lords. It is Hanumesha and Anjanaya.
Only two.
1 and 2.
Only two.
2 is Hanumesha, my lord. I witness.
PW5 is also.
PW5 also, my lord.
What about others?
My lords, others is my lords in PW 18. Please.
File ಓದಿದ್ದೀರಿ?
ಇಲ್ಲ my lord.
ಇಲ್ಲ. ಮತ್ತೆ ಏನ್ ಮಾಡಿದ್ದು ಇಷ್ಟು ದಿವಸ?
No my lord, ನಾನು
ಸ್ವಲ್ಪ ಬರ್ತಾ ಇದ್ದೀರಲ್ಲ, ಏನ್ ಮಾಡಿದ್ದು ನೀವು ಫೈಲ್?
ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡಿದ್ದೀನಿ my lord.
ಸ್ವಲ್ಪ ನೋಡಿದ್ರೆ ಸಾಕಾಗುತ್ತೆ. ಸ್ವಲ್ಪ ನೋಡಿ ಇಲ್ಲಿ DB ಅಲ್ಲಿ ನೀವು ಅಪೀಲ್ ನಡೆಸುವುದಾ? ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್?
ಇಲ್ಲ my lord.
ಮತ್ತೆ
ನಾನು ನೋಡಿದ್ದೀನಿ.
ತಮ್ಮಿ ಕೇಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಲೀಗಲ್ ಸೆಲ್ ಅವರು. ಸ್ವಲ್ಪ ನೋಡಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸ್ವಲ್ಪ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ?
ಇಲ್ಲ my lord.
PW 1, 2, 5, 6, 7, 8, 9 and 23 are the eyewitness.
ಹೌದು.
ಇಷ್ಟು ಜನ eyewitness ಇದ್ದಾರೆ.
ಹೌದು ಮೇಡಮ್.
ಮತ್ತೆ
it is my lords in eyewitness is PW 8 and 19 is hostile my lords. Hostile ಆಗಿದ್ದಾರೆ. ಅವ್ರ ಮಗಳು ಮತ್ತೆ ಅವ್ರ ಇದು ಇಬ್ರು hostile ಆಗಿರೋದಿದೆ. Kindly see that in
PW8 has supported the case of the prosecution.
PW 14 and 17 turned hostile.
Yes, my lord. Who caught all the accused, PW8. Yes.
What is your case? What is your contention?
my contention is my lords, it is a senior citizen accused my lords. 55 years ಆಗಿದೆ. ಈಗ 10 years ಅಂದ್ರೆ 60 above ಮೇಲೆ ಆಗಿದೆ, 69. ಅವ್ರಿಗೆ ನಡಿಲಕ್ನೂ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. That's the reason my lords.
That is the ground.
ಅದು ಸೆಂಟೆನ್ಸಿಂಗ್ ಅಲ್ಲಿ ಏನೋ ಹೇಳಿದ್ರೆ ಆಯ್ತು, ನೀವು ಹಂಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ.
ಎವಿಡೆನ್ಸ್ ಓದ್ಕೊಂಡು ಬರ್ಬೇಕು. ಏನ್ ಡಿಸ್ಕ್ರಿಪನ್ಸಿ ಏನಂತ ಏನು ನೋಡ್ಲಿಕ್ಕೆ ಇಲ್ವಾ ಕೇಸ್?
ಹೌದು, ನೋಡ್ಕೊಂಡು ಬಂದಿದ್ದೀನಿ ಸ್ವಾಮಿ. ದಟ್ kindly see that in page number evidence in PW1. Page number 49 my lords. PW1. In para number approach para number 2 my lords. ದಿನಾಂಕ ಸಂಜೆ 6 ಗಂಟೆ ನಮ್ಮ ಅಕ್ಕ ಹನುಮೇಶ್ ಮತ್ತು ಇತರರು ಮಾತನಾಡಿ ಮನೆಗೆ ಹೋಗಿದ್ದೇವೆ. ಆಗ ಮನೆಯಲ್ಲಿ ಆರೋಪಿಯು ಪಕ್ಕದ ಮನೆಯಲ್ಲಿ ಇದ್ದ. ಅಲ್ಲಿಂದ ಮಹಂತೇಶ್ ಅವರು ಮನೆಯ ಮುಂದೆ ನಾನು ಪದ್ಮ ಮತ್ತು ಮಹಂತೇಶ್ ಮಾತನಾಡಿಕೊಂಡು ಕುಳಿತಿದ್ದೇವೆ. ಆಗ ಹನುಮಂತಪ್ಪ ಮತ್ತು ದೇವಣ್ಣ ಸಲ್ಗಾರ್ ಅವರು ಬಂದಿದ್ದರು. ನಾವೆಲ್ಲರೂ ಮಾತನಾಡಿ ಕುಳಿತಿದ್ದಾಗ ಹನುಮೇಶ್ ಅವರು ಮನೆಯಲ್ಲಿ ಬಂದು ಮುಂದೆ ಆರೋಪಿಯು ಮನೆಯಲ್ಲಿ ಲೈಟಿನಲ್ಲಿ ಬೆಳಕಿತ್ತು. ಆರೋಪಿಯು ಮನೆಯಲ್ಲಿ ಆರೋಪಿಯ ಮತ್ತು ಇತರ ಮತ್ತು ಆತನ ಹೆಂಡತಿ ಇದ್ದರು. ಆರೋಪಿಯು ಕೂಡಿಕೊಂಡು ತನ್ನ ಹೆಂಡತಿ ಹಣ ಕೊಡುವ ಜಗಳ ಮಾಡುತ್ತಿದ್ದ ಎಂದು ಕೇಳು ಬರುತ್ತಿತ್ತು. ದಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಐ ವಿಟ್ನೆಸ್ ಮೈ ಲಾರ್ಡ್ಸ್. ಅವರಿಬ್ರು ಜಗಳ ಆಡೋದು ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್ಸ್. ಈರಮ್ಮ ಇವಳು ಹತ್ತಿರ ಹೋಗಿ ಹಣವಿಲ್ಲ, ಕುಡಿಯಲು ಹಣ ಹಾಳು ಮಾಡುತ್ತಿ ಸಂಸಾರ ನನಗೆ ನಡೆಯಬೇಕಾಗಿ ಕುಳಿತುಕೊಂಡಿದ್ದಾರೆ. ಅದನ್ನು ಕೇಳಿ ನಾವೆಲ್ಲರೂ ಕೈಂಡ್ಲಿ ಸಿ ದಟ್ ಇನ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಪಾಯಿಂಟ್ಸ್. ಅದನ್ನು ಕೇಳಿ ನಾವೆಲ್ಲರೂ ಆರೋಪಿಯ ಮನೆಗೆ ಹೋದೆವು. ಆಗ ಆರೋಪಿಯು ಮನೆಯಲ್ಲಿ ಲೊಟ್ಟಿನಿಂದ ಬೆಳಕಿನಡೆಗೆ ಅಷ್ಟರಲ್ಲಿ ಆರೋಪಿಯು ಈರಮ್ಮಳಿಗೆ ಹೊಡೆದನು. ಆಕೆ ಹಣ ಕೊಡದಂತೆ ಕೇಳಿರುವ ಆರೋಪಿಯು ಕೈಯಲ್ಲಿ ಇದ್ದ ಉದ್ಗೋಳನ್ನು ಇತ್ತು. ಆರೋಪಿಯು ನೀವು ಸಮೀಪದ ಬಂದರೆ ನಿಮಗೆ ಹೊಡೆದು ಹಾಕುತ್ತೇನೆ. ದಟ್ಸ್ ನೋ ಮೈ ಲಾರ್ಡ್. ಅದು ಇನ್ಸಿಡೆಂಟ್ ಆದ ತಕ್ಷಣ ಬಂದಾರ ಮೈ ಲಾರ್ಡ್ಸ್. ಕಂಪ್ಲೇಂಟ್ ನಾಗ ಹೇಳ್ತಾರೆ ನಾವೆಲ್ಲ ಅಲ್ಲೇ ಕೂಳ್ತಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೋಗುವಷ್ಟರಲ್ಲಿ ಆರೋಪಿ ಈರಮ್ಮನಿಗೆ ಹೊಡೆದಿದ್ದನು. ಆಕೆಗೆ ಹಣ ಕೊಡುವಂತೆ ಕೇಳುತ್ತಿದ್ದನು. ಆರೋಪಿಯ ಕೈಯಲ್ಲಿ ಊದುಗೊಳವೇ ಇತ್ತು. ನೀವು ಸಮೀಪ ಬಂದರೆ ನಿಮಗೂ ಹೊಡೆಯುತ್ತೇನೆ ಅಂತ ಹೇಳಿದನು.
ಕೈಂಡ್ಲಿ ಸಿ ದಟ್ ಇನ್ ಕಂಟಿನ್ಯೂ ಮೈ ಲಾರ್ಡ್ಸ್. ಈರಮ್ಮನ ಹಣೆಯ ಮೇಲೆ ತಲೆಯ ಮೇಲೆ ಪಟ್ಟಾಗಿತ್ತು. ಈರಮ್ಮನ ನೆಲದ ಮೇಲೆ ಬಿದ್ದಳು. ಅಲ್ಲಿ ರಕ್ತದ ಬಿದ್ದು ಆಕೆ ದಟ್ ಇಸ್ ನಾಟ್ ಅಲ್ಲಿ ಬಿದ್ದು ಆಲ್ರೆಡಿ ಸತ್ತು ಹೋಗಿದ್ದಳು ಅಂತ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಹೇಳ್ತಾರೆ ಮೈ ಲಾರ್ಡ್ಸ್. ಇಲ್ಲಿ ಹೇಳೋದು ಡಿಫರೆನ್ಸ್ ಇದೆ ಮೈ ಲಾರ್ಡ್ಸ್.
ಯಾರು ಹೇಳಿದ್ರು ಸತ್ತು ಹೋಗಿದಾರಂತ?
ಆಲ್ರೆಡಿ ಹೇಳಿರೋರು ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಹೇಳ್ತಾರೆ. PW1 ಅವನೇ ಹೇಳ್ತಾನೆ.
ಏನಂತ?
ನಮ್ಮ ಮಾವ ಕಬ್ಬಿಣ ಉದ್ಗೋಳನ್ನು ತೆಗೆದುಕೊಂಡು ನಮ್ಮ ಅಕ್ಕನ ಹಣೆಯ ಮೇಲೆ ಮತ್ತು ಮೊಲದ ಮೇಲೆ ಮೊಗದ ಮೇಲೆ ಬಲ ಮೇಲೆ ಜೋರಾಗಿ ಹೊಡೆದು ಅಕ್ಕ ಅವಳು ಕೆಳಗೆ ಬಿದ್ದಳು. ಕೆಳಗೆ ಬಿದ್ದು ಸತ್ತು ಹೋದಳು ಅಂತ ಹೇಳ್ತಾರೆ ಮೈ ಲಾರ್ಡ್ಸ್. ದಟ್ ಇವ್ರು ಹೇಳ್ತಾರೆ ಬಾಜು ಮನೆಯಲ್ಲಿ ಇದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ಅವರಿಬ್ರು ಜಗಳ ಆಡೋದು ಕೇಳ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ.
ಆಯ್ತು. ವಾಟ್ ಅಬೌಟ್ ಯುವರ್ ಪ್ರೆಸೆನ್ಸ್?
My presence is my lords. My presence is Madappa is already has to be drinked. That reason it may be incident ಆಗಿರ್ಬೋದು. ಬಟ್ ಅದು ಇನ್ಸಿಡೆಂಟ್ ಅವ ಹೊಡಿಬೇಕಂತ ಹೊಡೆದಿಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್. ದಟ್ ರೀಸನ್ ಮೈ ಲಾರ್ಡ್ಸ್. ಅದ್ರ ನಂತರ ನೀವು PW
ಏನ್ ಮಾಡ್ಬೇಕು? ಹೊಡೆದಿಲ್ಲ ಅಂತ ಹೊಡೆದಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು?
It may be trial court has to be set aside the judgment my lords. ಅವನು ಅಷ್ಟು ಆಕ್ಚುಲಿ ಅವನಿಗೆ ಅರುಣೇ ಇರ್ಲಿಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್.
ಕುಡಿದು ಬಿಟ್ಟು ಹಾಗೆ ಏನಾದ್ರು ಹೊಡೆದ್ರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕಾಗುತ್ತೆ? ಏನ್ ಮಾಡ್ಬೋದು ಕೇಸನ್ನು?
ಆಸ್ ಪರ್ ದಿ ಅಪೀಲ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ಬೇಕು.
ಸೆಟ್ ಅಸೈಡ್ ಮಾತ್ರ ಮಾಡಿ.
ಅಪೀಲ್ ಸೆಟ್ ಅಸೈಡ್ ಇಲ್ಲ. ಇಟ್ ಇಸ್ ಮೇ ಬಿ CC has to be SC has to be set aside. My praise.
ಇವ್ರದ್ದು ಒಬ್ಬರದ್ದು ಉಳಿದವ್ರ ಐ ವಿಟ್ನೆಸ್ ಏನು?
ಉಳಿದವ್ರ
ಅದರ್ ಐ ವಿಟ್ನೆಸಸ್ PW 2, 5, 6, 7, 8, 9 and 23 ಅವರನ್ನ ಏನಕ್ಕೆ ಡಿಸ್ಬಿಲೀವ್ ಮಾಡಬೇಕು?
ಅವರಲ್ಲೂ ಸೇಮ್ ಇದೆ ಮೈ ಲಾರ್ಡ್ಸ್.
ಎಲ್ಲರನ್ನ ಏನಕ್ಕೆ ಡಿಸ್ಬಿಲೀವ್ ಮಾಡಬೇಕು? ನಿಮ್ಮ ಮನೆಯಲ್ಲಿ ಆದದ್ದಲ್ವಾ ಇನ್ಸಿಡೆಂಟ್?
ಹೌದು,
ನಿಮ್ಮ ಮನೆಯಲ್ಲಿ ಆದದ್ದು.
ಹೌದು.
ಏನಕ್ಕೆ ಡಿಸ್ಬಿಲೀವ್ ಮಾಡಬೇಕು? ಎಲ್ಲರ ಎವಿಡೆನ್ಸ್ ಅನ್ನು ಎಲ್ಲರೂ ಸುಳ್ಳು ಹೇಳಿದ್ದಾರೆ.
ಅನ್ವೇಷ್ ಇಸ್ ಡಿಸೀಸ್ ಸನ್ ಮೈ ಲಾರ್ಡ್ಸ್. PW2 is son my lords.
ಉಳಿದವರು ನೈಬರ್ಸ್ ಇದ್ದಾರಲ್ವಾ?
ಹೌದು,
ನೈಬರ್ಸ್ ಇದ್ದಾರಲ್ವಾ ಉಳಿದವರೆಲ್ಲ?
ಹೌದು.
ಸೊ ಎಲ್ಲರೂ ಸುಳ್ಳು ಹೇಳಿದಾರೆ ಅಂತ ಹೇಳ್ಬೇಕಾ? ಏನಂತ? ಹೇಳಿ ಏನ್ ಮಾಡ್ಬೇಕಂತ?
ಇವರೆಲ್ಲ ರಿಲೇಷನ್ ಅರ ಮೈ ಲಾರ್ಡ್ಸ್, ಆಲ್ ರಿಲೇಷನ್ ಅದ ಮೈ ಲಾರ್ಡ್ಸ್.
ಇಬ್ಬರು ಇದ್ದಾರಲ್ವ, ಏನ್ ರಿಲೇಷನ್, ಯಾರು ರಿಲೇಷನ್?
ಈ PW2 ಸನ್ ಇದಾನೆ, ಡಿಸೀಸ್ ಸನ್ ಇದಾನೆ,
ಉಳಿದವರು 5, 6, 7, 8, 9 and 20.
ಅವ್ರನ್ನು ರಿಲೇಷನ್ ಇದಾರೆ ಮೈ ಲಾರ್ಡ್ಸ್.
ಯಾರು ಎಲ್ರು ರಿಲೇಷನ್ ಇದ್ದಾರೆ?
ಹೌದು ಮೈ ಲಾರ್ಡ್ಸ್. PW2 ವೈಫ್ ಆಫ್ ದಿ ಸೋ ಅಂಡ್ ಸೋ ಅದರ್ ಮೈ ಲಾರ್ಡ್ಸ್.
5 ಯಾರು ನೋಡಿ 5 ಯಾರು?
5 ಈಸ್ ಮೈ ಲಾರ್ಡ್ಸ್,
ಹಾ,
ಅಲ್ಲ ಉಳಿದೋರ್ ಅಂತಲ್ಲ, PP ಇದಾರೆ, ಆಮೇಲೆ ಐ ವಿಟ್ನೆಸ್ನು ಇದಾರೆ. ಸೊ ದಟ್ ರೀಸನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ಕೂಡ ವಿಟ್ನೆಸ್ ಇರಲ್ಲ.
7 ಇಲ್ಲ ರಿಲೇಟಿವ್. 7 ರಿಲೇಟಿವ್ ಇಲ್ಲ.
ಕನ್ವಿಕ್ಷನ್ ಲೈಫ್ ಆಗಿದ್ರೆ ಅದನ್ನ ಬೇರೆ ಏನಾದ್ರು ತರ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ ಏನಂತ ಓದ್ಕೊಂಡು ಬರ್ಬೇಡ್ವಾ? ಏನ್
ತ್ರೀ
ಬರುದಾ?
ನಾಟ್ ಟೂ
File ತಿಳ್ಕೊಂಡು ಸೀದಾ ಬರುದಾ?
302 ನಲ್ಲಿ ಲೈಫ್ ಮಾಡಿದ್ದಾರೆ. 504 ನಲ್ಲಿ 6 ಮಂತ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್ ಸೆಂಟೆನ್ಸ್.
ಬನ್ನಿ. ಮಾಡಿಬಿಡೋಣ ಈಗ. Yes, ಬನ್ನಿ. This appeal.
Yes.
This appeal by the convicted accused directed against the judgment of judgment and order of sentence dated 22/2018 passed by the principal district and session judge at Raichur, wherein the learned session judge convicted the accused for the offence punishable under section 302 and 504 of IPC and sentenced the appellate accused to undergo rigorous imprisonment for life and to pay a fine of ₹10,000 for the offence punishable under section 302 of IPC. Full stop. In default of payment of fine, the accused shall undergo simple imprisonment for 6 months. Further, the accused also sentenced to undergo rigorous imprisonment for 6 months and to pay a fine of ₹2,000 for the offence punishable under section 504 of IPC. In default of payment of fine, the accused shall undergo simple imprisonment for 2 months. Full stop. Further, it's directed that the substantive sentence shall run concurrently. Full stop. Next, the abridged facts of the prosecution case are that the deceased in this case, Irama, is the wife of accused appellant, residing at wife of accused appellant, residing at Kuda village in Lingaspur Taluk. Full stop. The accused is addicted to bad habits, always used to pick up quarrel with his wife, demanding money for his bad vices, and there used to be a quarrel, and he used to quarrel, and there used to be a quarrel between the accused and deceased. Full stop. Full stop. On this backdrop, on 16/9/2015, at 7:30 PM, the accused picked up a quarrel with his wife, at that time, the complainant, PW1, was sitting on the katta of the house, sitting outside the katta bracket of the house, house, and was talking with his relatives. Full stop. At that time, the deceased Irama was inside the house. Full stop. Accused picked up quarrel with her and demanded money for consuming alcohol, when she refused to give money, saying that he is not earning anything and he is wasting money earned by her. Full stop. Being enraged by it, the accused abused her in filthy language and assaulted and by picking up a blowing pipe, bracket ಅಲ್ಲಿ ಊದುಕೊಳವೆ ಅಂತ ಹಾಕೊಳ್ಳಿ, blowing pipe, from the said place, assaulted the deceased Irama on her parietal region and also on her forehead.
forcibly. Full stop.
Right forehead.
Huh?
Right forehead.
Right forehead. Forehead forcibly, full stop. Due to the assault, she fell down. The complainant and others went near the house of the accused at that time, near the spot. Went near the spot, at that time, the accused threatened them that if they come inside the house, he would kill them. Full stop. He killed them. Thereafter, the accused fled away from the spot. Full stop. Spot. Later, the complainant PW1 lodged the complaint before the respondent police against the accused as per exhibit P1 and exhibit P1 and based on the same, the then PSI of the respondent police, PW20 registered the FIR against the accused for the offense punishable under section 302 offense 302 and 504 of IPC in crime number 266 of 2015 dated 16/9/2015. Full stop.
At about
2000
9:30.
Huh?
At about 9:30.
16/9/2015 at about
30 a.m.
9:30 a.m. Full stop. 9:30 a.m. Full stop. Subsequently, the PW12 conducted the inquest Panchanama on the corpus of the deceased as per exhibit P2, and the corpus was sent for post-mortem examination, and the accused was arrested. By the respondent police, by the respondent police on
Arrested of the 17/9/2015.
on 17/9/2015, that is on the next date of the incident, and based on his voluntary statement, the investigation officer recovered MO1, the blowing pipe, which said to have used for the commission of crime, and the clothes of the accused as per MO5 and MO6 under the Mahazar exhibit P6, full stop. Later, by obtaining necessary documents from the concerned authorities, the PW concerned authorities, the investigation officer PW23, PW23 laid the charge sheet. Laid the charge sheet against the accused for the aforementioned offences before the committal court. Next para. After committal of the case before the session court, the learned session judge framed the charges against the accused for the aforementioned offences and read over to him. However, the accused denied the charges and claimed to be tried. Full stop. In order to prove the charges leveled against the accused, the prosecution in total examined 23 witnesses as PW1 to PW23. So also got marked 23 documents as exhibit P1 to P23 and identified 6 material objects as MO1 to 6126. Full stop.
On submission,
After-
investigating officer is PW16 minutes.
The investigation.
Not
officer,
23.
PW16 on top of it.
Yes.
PW16 late charge sheet.
Please.
Yes. Next, after assessment of the post-assessment of the oral and documentary evidence placed by the prosecution, the learned session judge convicted the accused for the charges leveled against him and also sentenced him as stated supra, full stop. The said judgment is challenged in this appeal, full stop. We have heard Shri so and so for the appellant. So also the learned Shri Patil learned additional SPP for the state, full stop. It is the primary contention of the learned counsel for the appellant that the learned session judge, the appellant that the judgment under this appeal suffers from perversity and illegality, full stop. The learned session judge failed to appreciate the evidence of the material witness in the right perspective, full stop. According to the learned counsel, the eyewitness examined by the prosecution, that is PW 1, 2, 5 to 9 and 23, 23, 23, in their evidence, there are material contradictions and omissions. As such, their version cannot be believed to convict the accused for the charges leveled against him, full stop. He would further contend that the eyewitness have categorically stated that after the assault made by the accused, they reached the spot and witnessed the same, full stop. Further, witnessed the same, full stop. Further, the prosecution also failed to prove the recovery of MO 1, 5 and 6 under Exhibit P6, since the evidence of PW, evidence of PW4, the Mahazar witness,
He supported the case. He supported the case.
yes, suffers from severe infirmities, full stop. Infirmity. The prosecution failed to examine the any other witness to prove Exhibit P6, full stop. P6. The learned counsel also contend that full stop. Content that the prosecution, though the prosecution stated prosecution alleged that the accused, the motive for the commission of the crime is that the accused was involved in bad vices and for the same he used to quarrel with deceased prior to the incident itself.
Yes.
However, there is no such the said aspect was not stated by any one of the witnesses. In such circumstance, the motive for the commission of the crime is also not proved. For sure. Next part. Alternatively, accordingly, he prays to set aside the impugned judgment of conviction. Alternatively, the learned counsel submits that, even if the entire evidence adduced by the prosecution taken into consideration on the face of it, the prosecution failed to make out the case, this case squarely falls within the ambit of section exception 4 to section 300 of IPC, and the accused is liable to be sentenced for the offense punishable under section 304 part 1 of IPC, part 1 of IPC, instead of section 302 of IPC, According to the learned counsel, the entire incident of assault caused in a spur of moment, in a grave and sudden provocation, sudden provocation but in the house, in the sudden provocation due to the row between row between the accused and deceased in the house, full stop, in the house. Accordingly, alternatively, he prays to modify the sentence imposed by the trial court, full stop. Per contra, the learned additional SPP, per contra, Shri Patil learned additional SPP would submit that the judgment under this appeal does not suffers from any perversity or illegality, since the learned session judge meticulously examined all the evidence of all the witnesses on record, full stop, record, and passed a well-reasoned judgment, full stop. He would contend that the prosecution has placed the evidence of eyewitness to the incident, that is PW1 229, 25, 629 and 23, all of them have categorically stated that the accused stated that on the fateful day, the accused quarreled with his wife, deceased Iramma, and assaulted her in a blowing pipe, assaulted her on or assaulted her head on in a blowing pipe, and caused her the injuries on her. Thereafter, she succumbed to the injuries, full stop. They succumbed to the injury. This evidence of PW, the evidence of these eyewitnesses, clearly corroborates to the medical evidence, that is the evidence of PW11, the doctor who conducted the post-mortem, who conducted the autopsy on the dead body, autopsy on the corpus, and issued the post-mortem report, exhibit P8, full stop. He would further contend that the recovery mahazar exhibit P6 is clearly proved by the evidence of PW4 and PW12, full stop. PW12. Further, the prosecution also sent these articles, these material objects for FSL and on scientific examination, the officer has opined that the blood found on these articles are of human blood of O group. The said comparison made, the said blood comparison, the said examination made, the scientific officer made examination of the clothes of the deceased, MO224 also.
Yes.
224 also, full stop. In such circumstance, there is a clear corroboration of medical oral evidence led by the prosecution to the medical evidence. Accordingly, the learned SPP prays to dismiss the appeal. Full stop. You would contend that on facts and evidence placed by the prosecution, this case does not fall within the ambit of section exception 4 to section 300 of IPC, and the learned session judge has rightly convicted the accused for the offense 302 of IPC. Full stop. Having heard the learned counsel for the appellant, so also the learned SPP,
Sorry. Whether that the opinion of the doctor who has conducted the PM, that is.
Yes, Bhartan.
Please.
Heard the counsel for the appellate, so also the learned SPP, the point that would arise for our consideration. Number one, whether the judgment under this appeal suffers from any perversity or illegal. Number two, whether the learned session judge is justified in convicting the accused for convicting and sentencing the accused for the offense punishable under section 302 and 504 of IPC. Full stop. Though the prosecution in total examined prosecution in total examined 23 witness in the, in this case, comma, it is not necessary to examine, not necessary. We are of the view that it is not necessary to examine all the witnesses examined by the prosecution. Suffice to discuss the evidence of the material witness relied by the prosecution, full stop. On careful perusal of the full stop. Next part. In order to prove the homicidal death of the deceased in this deceased Irama in this case, comma, the prosecution mainly prosecution predominantly relied the evidence of PW11, the doctor who conducted the autopsy on the corpus of the deceased and the postmortem report issued by the doctor as per Exhibit P8. On Exhibit P8, full stop. On careful perusal of Exhibit P8, comma, the doctor has
24.
The doctor has opined that
26.
the doctor has opined that as to cause of death that the death is due to hypovolemic shock secondary to multiple fractured wounds. Close. Wound, full stop. The full stop. The doctor, full stop. He also gave his opinion. Opinion as per Exhibit P9 that the injuries found on the dead body of the deceased could be caused if assault made by MO1 as per Exhibit P9, full stop. Exhibit P9. The prosecution also relied the inquest panchanama conducted on the corpus of the deceased by PW12 as per Exhibit P2. Full stop. PW3 is the witness for the same. On full stop. On perusal of the evidence of PW3 and PW12, comma, they both categorically stated that the deceased had sustained 3 injuries. They have noticed 3 injuries on the corpus of the deceased. Full stop. Corpus of the deceased. Nevertheless, there are as many as 9 eyewitness to the alleged incident. All of them have clearly stated that they have witnessed the assault made by the accused with on her head with the MO1. In such circumstance, we are of the considered view that the prosecution has successfully proved the homicidal death of the deceased Irama. Full stop. In order to connect the accused in the for the homicidal death of the deceased, the prosecution mainly relied on the evidence of PW1, the complainant, and PW2, 5, 6 to 9, and 23 were the eyewitness to the incident. On perusal of the evidence of these witnesses, all of them have categorically stated that on the date of incident, that is on 16/9/2015, at about 6:30 p.m. The accused came to his house and he was talking with and picked up a quarrel with his wife, the Irama, and demanded money for drinking alcohol. And when Irama refused to give the same, being enraged with the same, the accused abused her in filthy language and also assaulted on her head on her head with blowing pipe MO1 on her parietal region and on her forehead.
Right
Full
forehead.
shot, right
Right
forehead, full shot. Forehead. Thereafter, forehead, and the deceased full shot. Due to the same, the deceased, she is succumbed. Succumbed to the injuries on the spot, alwa? On the spot, full shot. This on the spot. This consistent version of the eyewitnesses, PW1, eyewitness, the above mentioned eyewitnesses. Eyewitness also corroborates to the complaint lodged by PW1, exhibit P1, at the earliest point in time before the respondent police, full shot, respondent police. More respondent police, full shot. Moreover, the prosecution also examined PW22, the junior engineer of JESCAM,
Who prepared sketch.
JESCAM, to establish that on 16/9/2015 at about 7:30 p.m., there was electricity supply to the house of deceased and accused. Full stop. The said certificate is marked at exhibit P16, full stop, P16. The P16. In such circumstance, there is no reason to disbelieve the testimony of the eyewitnesses, full stop. Eyewitness. Moreover, among the eyewitnesses, PW 6, 7, 8,
5 also.
5, 6, 7, 8, 9, and 23. 23
Yes.
are the neighbors.
Yes. Neighbors and villages.
Are the neighbors and villagers. Full stop. Are the villages.
Yes.
There is no reason for them to depose falsely against the accused. Even otherwise, though the prosecution, though the defense cross-examined these witnesses at length, nothing worthwhile has been elicited from their mouth to discard their testimony,
Yes.
Full stop. Nor it is suggested that the accused suggested that the accused they have falsely deposed against these accused persons. Full stop. In such circumstance, full stop. Persons, full stop. As rightly contended by the learned SPP, the evidence of the eyewitness PW1, 2, 5 to 9 and 23 corroborates to the medical evidence.
Yes.
Medical evidence, that is the evidence of PW 11 doctor. On perusal of exhibit P8 and P9, on perusal of exhibit P8. Exhibit P8, there are 3 injuries sustained by the deceased on her forehead and temporal region.
Right forehead and front.
Temporal region, full stop. Next, further, the doctor has also given the opinion that those injuries could be possible to cause with the if an assault made with MO1 as per exhibit P9.
Yes.
Exhibit P9. In such circumstance, the oral testimony of the eyewitnesses clearly corroborates to the medical evidence. Hence, there is no reason to. Hence, the evidence of eyewitness are believable and trustworthy trustworthy and rightly appreciated by the learned session judge. Full stop. The prosecution also proved the recovery of the weapon MO1, under Exhibit P6 Mahazar, full stop, B6 Mahazar. On careful perusal of the evidence of PW4 and PW12, both these witnesses have categorically stated that the accused led them to the place where he kept kept the MO1 after the incident. After the incident, full stop. Accordingly, the same was recovered at his instance. Full stop. Moreover, they said the MO1 and MO5 to 6, that is the clothes worn by him at the time of incident, was recovered. And the bloodstains were found on these three articles. Full stop. The prosecution, the prosecution also seized the clothes worn by the deceased at the time of incident, as per MO2, 3 and 4. And all these articles were sent for FSL, and on scientific examination of these article by PW21, the scientific officer, all these articles are, the PW21 found that these PW21 all these articles were stained with the human blood of O group. Accordingly, he issued the certificate Exhibit P21 in P21. In such circumstance, fear of the considered view that the prosecution has clearly proved the circumstance of recovery of the weapon used for the commission of the crime at the instance of accused. Full stop. The instance of full stop. The prosecution also proved the spot Mahazar, that is Exhibit P3, Exhibit P3, Exhibit P3 by the evidence of the investigation officer. Full stop. Investigation officer. Further, the evidence of the eyewitnesses clearly, clearly corroborates to the testimony of the investigation officer PW 16. Full stop. In such circumstance, so we are of the consensus view that the prosecution has successfully established the aspect that the accused, the perpetrator of the crime, and due to the assault made by him in MO1 to the deceased, she sustained such injuries and succumbed thereafter. The said aspect was properly full stop. The same said aspect full stop. Next aspect. Coming to the full stop. As far as the alternative contention raised by the learned counsel for the appellant, that this case squarely falls within the ambit of section exception 3 to section 300 of IPC, which is punishable under section 304 part 1 of IPC, is concerned, we have, on careful perusal of the evidence of PW1 and the other witnesses, so also the contents of Exhibit P1 complaint lodged at the earliest point of time, depicts that the incident was caused in a spur of moment, the accused and on the fateful day, the accused came to the house after consuming alcohol and also and further started and picked up a quarrel with the row with the deceased and demanded money for to consume alcohol, to consume more to consume liquor. At that time, the deceased also deceased refused and abused him. Also abused him. In such circumstance, all of a sudden he enraged by the same and picked up the handy weapon, which was lying in the house and assaulted on the head of the deceased, full stop, head of the deceased, full stop. The head of the deceased, this head of the deceased, full stop. On perusal of evidence, all the eyewitness PW 1, 2, 5, 6, 7, 8, 9, and 23, all these witnesses have stated that the incident was caused all of a sudden in the house, and the accused was in a intoxication condition, full stop, There is no such preparation or intention or preparation on the part of the accused to do away the life of the deceased. The quarrel was full stop. The quarrel started all of a sudden and on a grave provocation, on a grave and sudden provocation, the accused committed the incident, full stop, They committed the incident. Even after the incident, the accused, even after the assault, the accused not behaved in a cruel manner with the deceased, full stop, deceased. In such circumstance, the full stop. Further, the medical evidence also establishes that the deceased sustained injuries on her head, on her forehead,
Right forehead.
right forehead, full stop. Though it is the contention of the learned SPP that the accused given three repeated blows on the deceased, repeated three blows to the deceased. As such, the act of the deceased cannot be termed as a sudden provocation. But the Honorable Apex Court in the case of case of so and so held that the blows that Honorable Apex Court in the case of Dhruvaram Nirmalkar and the repeated blows, the blows are the number of blows given by the accused cannot be a ground to discard his plea for cannot be considered, cannot be come in the way of invoking section exception to section 300 of IPC. Further, the Honorable Apex Court in the case of Dhruvaram Nirmalkar versus State of Chhattisgarh,
reported in AIR 2022 SEC 362020 para 14 held as under, para 14 as under, 14 by relying on the judgment of KM Nanavati, held as under. Full stop. On as under. On careful analysis of the law laid down by the Honorable Apex Court in the judgment referred supra to the supra and the same is applied to the fact and circumstance of this case. We are of the consider view that the entire incident caused in a spur of moment and on a grave and sudden provocation and the act of the accused and as such the act of the accused falls well within the ambit of exception 4 to section 300 of IPC. 300 of IPC. In 300 in that view of the matter, 300 of IPC. That 300 of IPC. As such, we are of the view that the conviction imposed or by the learned session conviction imposed by the learned session judge for the as such the conviction imposed learned session judge is liable to be modified for the offense punishable under section exception 4 section 300 of IPC and the accused is liable to be sentenced liable to be punished under section
304 part 1.
304 part 1 of IPC part 1 of IPC full stop. On the question of sentence the learned counsel for the appellant submits that the accused is under incarceration for 9 years.
9 years, my lords.
9 years.
9 years.
9 years for 6 months.
9 years, 6 months.
Please.
9 years, 6 months. 9 years, 6 months. Full stop. In such circumstance, we are of the view that the punishment for the offense under section 3.
9 years, 3 months it is. 3 months.
9 years, 3 months. For the offense punishable under section 304 part 1 of IPC, the sentence already already undergone by the accused is suffice by imposing the reasonable fine amount. Full stop. Reasonable fine. In that view of the matter, the appeal partly succeeds and accordingly we answer the point raised above, point number 1 in the affirmative and point number 1 in the negative, perverse or illegal negative, and point number 2 partly affirmative and proceed to pass the following order. Number 1, the criminal appeal number 200128 of 2018 is allowed in part. The judgment of conviction and order of sentence imposed by the learned session judge imposed against the accused by the learned session judge for the offense 302 of IPC is modified for the offense punishable under section section 304 part 1 of IPC.
Yes.
Next para. The accused is sentenced to undergo the accused is the period already undergone by the accused, that is 9 years.
3 months.
3 months of imprisonment is imposed as a punishment for the offense 304 part 1 of IPC. In addition to that, the accused shall pay a fine of rupees. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ ಎಷ್ಟು ಹಾಕಿದ್ದಾರೆ?
My lords, 10,000 and 2,000.
ಏನ್ ಮಾಡ್ತಾನೆ ಅವ? What is he?
Oh, it is ಕೂಲಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ.
Drunkard ಕೂಲಿ.
Additionally, 10,000 fine amount. He shall pay fine of rupees 10,000.
in default of payment of fine, he shall undergo 3 months imprisonment, simple imprisonment, full stop. 3 months simple imprisonment. Next, however, the sentence imposed for the conviction and sentence imposed for the offence 504 of IPC by the learned session judge is kept intact, full stop. The next para. If the accused either on either on payment of the fine amount or undergoing the default sentence, the accused shall be released. Accused shall be released. The accused shall be released. Released forthwith if he is not required in any other case. Accused shall be released forthwith better if he is not required in any other cases. Any other case. Full stop. Where another idea? Any other cases? Operative portion better. Fine amount got to be. Fine amount got to be. Madam, number of sentences. Surendra Kumar versus Union Territory and Chandigarh. 1989, according to SCC 217. 217. Start with paragraph.
Much more.
ಓದ್ಕೊಂಡು ಬಂದು ಅಪೀಲ್ ನಡೆಸಬೇಕು.
Please, please.
ಒಂದು ಲೀಗಲ್ ಸೆಲ್ ಇಂದ ಬಂದು 15 ಮಿನಿಟ್ಸ್ ಅಂತ ಹೇಳುದಲ್ಲ, ಓದ್ಕೊಂಡು ಬರ್ಬೇಕು.
No, madam. ಓದ್ಕೊಂಡ್ please.
Let's tomorrow.
ನಾಳೆಗೆ ಯೂಸ್ ಮಾಡೋಣ. Get ready tomorrow. Please, I'll
Inform madam.
ನಿಮ್ಮ ಎರಡಿಗೆ ಎಲ್ಲ
ಹೇಳಿದ್ದಾರೆ 32 ಮಾಡ್ತಾರೆ.
ready to.
Yes, Mr. Girish Patil, we'll take up your matter tomorrow, 2:30 ಅಥವಾ any time. Tomorrow. ನಾಳೆ ನಿಮ್ದೆ ತಗೊಳ್ಳೋದು.
ಆಯ್ತು, obliged.
Serial number 35. Serial number 35.
Sir, madam 35. SPP ಹೇಳಿದ್ರು. Ready ಆಗಿ ಬನ್ನಿ SPP.
Yes.
35.
Yes.
35 ಮಾತ್ರ ತಗೊಳ್ಳೋಣ ಮತ್ತೆ 35.
Day after tomorrow, I will also celebrate.
ಅವ್ರದ್ದು ಆಪರೇಟಿವ್ ಕ್ವೆಶ್ಚನ್. ಒಂದು ನಿಮಿಷ ನೋಡಬೇಕು. ನಿಮ್ದೇ ಇಲ್ಲ
Still 42 taken up day after tomorrow. If tomorrow it may not reach. Already 2 matters.
Be ready.
Yes.
ಗೆ ರೆಡಿ ಯಾವಾಗ ಆಗ್ತೀರಿ ನೀವು? 36 ಆಯ್ತು ಈಗ 38ಗೆ.
My lord, 38ಗೆ next month.
ನೆಕ್ಸ್ಟ್ ಮಂತ್
ಹೌದು.
ಏನಕ್ಕೆ?
I'm not here on, I'm going on.
ಎಲ್ಲಿಗೆ ಹೋಗ್
I'm going on Mahakumbha Mela.
Huh?
Mahakumbha Mela I will go. Please.
Sanjeev Patil. Sanjeev Patil. Sanjeev Reddy.
9 years ಯಾವ್ದು ಉಳಿಸಿದ್ರೆ 9 years ಫಸ್ಟ್ ಉಳಿಸಿದ್ರೆ
37, 38 and 40. It's 9 years.
ಲೀಗಲ್ ಏಡ್
ಹೌದು
38 ಕೂಡ ಲೀಗಲ್
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ ಎಲ್ಲ ಲೀಗಲ್.
ನಿಮ್ಮ ಕಲೀಗ್ ಇದ್ದಾರೆ ಬೇರೆ ಯಾರು ರೆಡಿ ಆಗ್ತಾರೆ ಬೇರೆ ಯಾರಾದ್ರೂ ಇದ್ದಾರಾ?
ಇಲ್ಲ ಮೇಲೋಡ್ NOC ಬಂದಿರೋದು ಮೇಲೋಡ್.
ಆಯ್ತು ಬೇರೆ ಯಾರಾದ್ರೂ ಇದ್ದಾರಾ ಅಂತ ಆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಬೇರೆ ಯಾರಾದ್ರೂ ಇದ್ದಾರಾ?
ಇಲ್ಲ ಇಲ್ಲ
ಎನಿಬಡಿ ಎಲ್ಸ್ ಇಲ್ಲ.
ಯಾರು
ನಿಮ್ಮ ಕಲೀಗ್ ಇದ್ದಾರೆ ಇಲ್ಲಿ? ನಿಮ್ಮ ಕಲೀಗ್ ಯಾರಿದ್ದಾರೆ?
ಇದ್ದಾರೆ ಇಲ್ಲ
ಯಾರಿದ್ದಾರೆ?
ಪ್ರೆಸೆಂಟ್ ಅವ್ರು ಅಪೇರ್ ಆಗಲ್ಲ ಮೇಲೆ ಲೋವರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಆಯ್ತು ಅವ್ರನ್ನ ನಾಳೆ ಇಲ್ಲಿ ಕರೆಸಿ, ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಅವರನ್ನು ಇಲ್ಲಿ ಕರೆಸಿ.
ಪ್ಲೀಸ್
ಹಾ ನೀವು ಬರ್ಬೇಕು, ಕರೆಸ್ಬೇಕು ಬೆಳಿಗ್ಗೆ ಅವರನ್ನು.
ಆಯ್ತು
ಅವರಿದ್ರೆ ಸಾಕು, ಬರ್ಲಿ ಅವ್ರು ಬರ್ಲಿ. ನಿಮ್ಮ ಪ್ರೆಸೆನ್ಸ್ ತೋರಿಸ್ತೀವಿ ನಾವು,
ಆಯ್ತಾಯ್ತು
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ತೋರಿಸ್ತೀವಿ, ಅವ್ರು ಬರ್ಲಿ.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
ಬೆಳಿಗ್ಗೆ ಕರ್ಕೊಂಡು ಬರ್ಬೇಕು ಅವರನ್ನು.
ಕರ್ಕೊಂಡ್ ಬರ್ತೀನಿ.
ಆಯ್ತು.
One second. 25 and 20 seconds. Sheila? Yeah. Yeah. Sir,
42 ನಾಡಿದ್ದು
sir, ನಾಳೆ.
ಆಯ್ತು ಹೇಳ್ರಿ. ನಾಳೆ ಯಾವ್ಯಾವ ಒಂದ್ ಗಿರೀಶ್ ಪಾಟೀಲ್ ಅವ್ರು ತಗೋತಾರ, ಮತ್ತೆ ಯಾವ್ದ್ರಿ ಶಂಭು ಅವ್ರು ತಗೋತಾರ. ಆಯ್ತು.
ಒಂದ್ ಇದನ್ ತಗೊಂಬ ಅಂದ್ರೆ ವಾರ್ನಿಂಗ್ ಇಷ್ಟ. ಕಟ್ಟಿಲ್ಲ ಅಂತ ಅನ್ಸುತ್ತೆ. ವಿಚಾರಣ ಅವ್ರ ಬದ್ಲಿ ನೀವು ಅವರೆಲ್ಲ ಸಾಹೇಬ್ರು ಕೇಸ್ ಆಗ್ತದೆ ಸರಿ ಕ್ರಾಸ್ ವೆರಿಫೈ ಮಾಡಿದ್ವಿ ಕೇಸ್ ಕಟ್ಟಿಲ್ಲ ಅವರಲ್ಲ ಕಟ್ಟಾರಂದ್ರೆ ಇವತ್ತು ಕಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ನೀವು ಸೀನಿಯರ್ ಇವತ್ತು ಕಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ ಪೇಪರ್ ಏನಾದ್ರು ತಂದಿದ್ದೆ ಎಂಟ್ರಿ ಮಾಡೋದು ಯಾವ ಇದು ಇವ್ರಿಗೆ ತಗೊಂಡೋಗ್ರಿ ಇವ್ರೆ ರಾಠೋಡವ್ರೆ ಮೇಡಮ್ ಈಗ ನೀವು ಇದು ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 9 years ಈಗ ಹಾಕದ್ ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ಯಾವ್ದೈತಿ 9 years ಐತಾ 9 years ಇದೆಲ್ಲ ಮುಗ್ದಂಗ 12 ಹಾಕ್ತೀವಿ ಒಂದು ನಿಮಿಷ ಮಾಡಿ ಈಗ ಸಾಹೇಬ್ರು ಕೇಳಿದ್ರೆ ಈಗ ಲಿಸ್ಟ್ ನಾಗಿರೋದಷ್ಟೇ 9 years ಬೇರೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ
ನಮ್ಮ ಪೆಂಡಿಂಗ್ ಎಷ್ಟು ಕೇಸ್ ಇದಾರೆ ಎಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡಿದ್ವಿ
ಲಿಸ್ಟ್ 9 years ಮುಗಿತು ಇದು ಅಂತ ಅದೊಂದು ಮಾಡಿ ಇದ್ರೊಳಗೆ ಯಾವ್ದು ಮುಗೀತು ಅಂದ್ರೆ ಇದ್ರ ಕೊಡ್ಬೇಕು 200128 ಐತಾ ಅದೆಲ್ಲ Serial number 1 file ಕಳಿಸ್ತೀವಿ. Top of the list ಐತಿ order first. ನಾಳೆ top of the list ಐತಿ. ಇದು ಎಲ್ಲ ಇದೆ. ನಾ ರಿಪೀಟ್ ಅನ್ಸುತ್ತೆ ನಿಮ್ಗೆ ಇಂಟಿಮೇಷನ್ ಕಟ್ಟಿಲ್ಲ ಅಂತೆ ಮೆಮೊ ಹಾಕಿದಾರಂತೆ ಕರೆಕ್ಟ್ ಇದೆ. ಏನ್ ಇದಕ್ಕೆ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ಗೆ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್. ಪಿ ಎಫ್ ಬೇಕಿತ್ತಂತ ಅದಕ್ಕೆ. ಪಿ ಎಫ್ ಬೇಕಾ ಅದಕ್ಕೆ? ಪಿ ಎಫ್ ಬೇಕಾ ಅದು ಪೇಪರ್ ಸಾಕಕ್ಕೆ. ಮತ್ತೆ ಅದನ್ನು ನಾವು ಕೇಳ್ತಾ ಇರೋದು ಪಿ ಎಫ್ ಕಟ್ಟಿದ್ದಾರೆ. ಪಿ ಎಫ್ ನೆಸಿಟಿ ಐತಾ ಕೇಳಿ. ಪಿ ಎಫ್ ನೆಸಿಟಿ ಇದೆಯಾ ಅದಕ್ಕೆ? ಇದೆಯಾ? ಇದೆ ಅಂತೆ ಕಟ್ಟಿಲ್ಲ. ಸರಿ ಇದು ಹಾ ಆಮೇಲೆ ಹೊಸ ಹುಡುಗ ಬಂದಾನ ನಿಮ್ದು ಎಲ್ಲಿ ಪಾಲಿಸಿ ಎಲ್ಲ ನೋಡ್ರಿ ಇಟ್ಬಿಡ್ರಿ ಇಬ್ರು. 34 ರಿಪೀಟ್. ಇಲ್ಲ 33 ಮುಗೀತು ಹೊಡೆದಾಕೊಂಡ್ಬಿಟ್ಟು. ಲಾಸ್ಟ್ ಐದು ಪಾಟ್ಲೆ ನೋಡು. ಹಾ ಪಾಟ್ಲೆ ನೋಡಿ ಕನ್ವರ್ಟ್ ಆಗ್ತದೆ. 34 ಇದು ರಿಪೀಟ್. 35 ರಿಪೀಟ್. 36 ಹೊಡೆದಾಕೊ. 37 repeat. 38 repeat. 39 repeat. 40 repeat. 41 repeat. ಹಾ ಒಂದ್ ತಗೊಂಡೆ. 40 ಚೆಕ್ ಬಿಲ್ ಮಾಡ್ತಲ್ಲ ಎಮ್ಮಿ. 42 repeat. 43 ಹೊಡೆದ. 44 repeat. 45 repeat. ಆಮೇಲೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮೆಮೋಸ್ ಬಂತು.
16 ನಾವು ಹೇಳಿದ್ವಿ
ಹಾಕಿರಾ? ಅದಿರಲಿ. ಅದೊಂದು ಇನ್ಸರ್ಟ್ ಮಾಡಿ. ಇದು ಒಂದು ಆರ್ಡರ್ ಇದ್ದ ಟಾಪ್ ಬರ್ಬೇಕಲ್ಲ ನೋಡ್ರಿ. ಈಗ ಸಾಹೇಬ್ರ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅಂದ್ರೆ
ಸ್ಟೇಜ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅವ್ರು ಏನು ಫೋಕಸ್ ಮಾಡ್ತಾರ ಇದು ನಿಮ್ಗೆ ಚೇಂಜ್ ಆಗ್ತೈತಿ ಆರ್ಡರ್ ಕಂಪ್ಲೇಂಟ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಬಟ್ ಇಲ್ಲಿ ನಿಮ್ಗೆ ಇದು ಬರ್ತದೆ ಹೀಗಾಗಿ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಏನಂದ್ರೆ ಇದು ಪಿ ಎಫ್ ಅವಶ್ಯಕತೆ ಇದ್ರು ಪಿ ಎಫ್ ಕಟ್ಟಿಲ್ಲ. ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಮೆಮೊ ಹಾಕ್ತಾರೆ ನಮಗೆ ಸೇರಿಸ್ತಾರೆ.